Streaming the event. Okay. Okay, just let me consult first. Everybody has a copy of the program. It's self-explanatory. We know the University of Nairobi students have an exam this morning they couldn't miss, so they will join us when they are ready. So we'll start right away so we can maximize the time with the judge. The judge has asked me not to give him an extensive introduction, and I will comply because I don't want orders against me. I'll comply by only referring to an introduction that was given of him by his son when he received the Jurist of the Year award last year. So his son said, I can't get in trouble with him for reading what his son said of him. By his fellow. So I'm skipping a lot, as you can see, Judge. He's not only, of course we know he's a judge of the Court of Appeal. His son said, our jurist is not only an advocate of the High Court of Kenya, but also licensed and practiced law in Massachusetts in the United States. He can tell you many stories about the law firm, one of the leading law firms, international law firms where he worked, and receiving Kenyan delegations who asked him interesting questions. You can ask about that over tea. He served as, he was a tenured professor at the University of Washington College of Law from 2004 to 2011, where he taught lots of human rights courses and did lots of work with advocates here in Kenya, did lots of training. He was an award-winning professor, winning several teaching awards while he was there. At the time when his son introduced him, he was a judge of the High Court. And of course, we know now he's a judge of the Court of Appeal. And there's a very interesting story about that. He has decided some of the most interesting cases. He chaired the panel that saved the 2010 Constitution. I can defend that anywhere on this planet. And he was the author, of course, of the Judicial Transformation Framework. Okay, so I have to tell this story. So when Judge Ngugi was appointed as a judge of the High Court, and he was assigned an office in the High Court, and the staff were passing tea around, they opened this office and found this young gentleman, and they said, he chair is Siako. And Judge Ngugi kindly obliged and said, Sawa tu, Ikibaki, you can bring me. This tea is not yours for the, he didn't qualify. He didn't look like he qualified. And when they were launching the Judicial Transformation Framework, which he was working on at that time when they were denying him tea, and he sat next to the Chief Justice, those staff at the judiciary almost fainted, and they have never stopped apologizing today. Anyway, I can tell many stories like that. Okay, I'll tell another story instead of reading the bio. So Judge Ngugi is a really transformative judge. When he used Machakos, the Machakos High Court, as the first place where the judiciary transformation framework started. And in one of the cases where he where some defendants came before him, some in a criminal case, and it turned out that the file was lost. And this guy had been in custody for how long? 7 years. The file was lost for 7 years. And when Judge Gugi tried to ask the court staff what had happened and they couldn't answer, he walked across from the High Court building into the Magistrates Court building to look for the file himself. And he found the file because he couldn't understand how the other defendants had been released and this guy was still in custody, but there was no file. So this is the kind of jurist that we are dealing with here. So I could say many things. For the non-Kenyans, let me just say, you'll excuse me, among them, the very important things that he has helped to do was the Steering Committee on Active Case Management, the Technical Committee on Criminal Procedure Bench Book, which produced the Criminal Procedure Bench Book in 2018. So you can still be a twirler and be very effective doing what needs to be done to ensure the proper administration and fair administration of justice. The Judicial Task Force on Sentencing, which produced the Sentencing Policy Guidelines in 2016. The Task Force on Bail and Bond, which produced the Bail and Bond Policy in 2015. The Committee on the Code of Conduct, which produced the Draft Judiciary Code of Conduct in 2018. The Committee on Judiciary Disability Mainstreaming Policy, among many things. And at the moment, although there are rumors that he's been there too long, in 2016 he was appointed chair of the Judiciary Task Force on Alternative Justice Systems, and he has developed the National Steering Committee for implementing the Alternative Justice Policy. I think this is a really twirl agenda. He currently serves as chair of the National Steering Committee on implementing the Alternative Justice Systems Policy. I know Kioni said many things, and you don't want me to say everything. And I'll just read what he said towards the end. Our Jurist of the Year, recently appointed a judge of the Court of Appeal of Kenya, is one of Kenya's bold and progressive judges making precedent-setting decisions. To a man alive to the place of law in society, committed to interpreting the law courageously and ambitiously without fear of favor, we are honored to present to all of you for our keynote, Judge Joel Ngugi. Please join me in welcoming the judge. I don't know where the PowerPoints went off.
And I think it just went again in the court orders. I'm actually wondering how I will do this with the PowerPoint here. Now, I don't like using the microphone, in part because I use both hands to speak, and I have a piece of paper in my hands. Those who are doing live streaming, can I be heard at all? Not at all. Is there an audience? That's a very practical question. It's a 12 question. There is an audience. How many people? Because we have to do cost benefits analysis. Even one is important enough.
So you can use these ones to go forward.
Okay. All right. In that case, I might be forced to do this. Okay. First of all, thank you, James, for your very kind introduction. I'm truly honored to be here. And it's always very good to see old friends like you, James, and Dr. Musembi, and newer friends like Titi and Apala. And it's always great to be back at Strathmore, which does not seem quite like the third world. But it's always good to be back here. We have 1.5 hours. That's what I was told. And I am sorry. immediately after my presentation, I will have to leave. What James did not say is that he summoned me back. Attending the Judges Colloquium in Mombasa, and I took the midnight flight back to Nairobi yesterday so that I can be here, and this afternoon I have to be back. The Chief Justice gave me just the morning off, so this afternoon I have to be back in Mombasa. So my flight is at 1, so that means by around 11 I have to be getting out of here. So my apologies, I cannot be with you for the rest of the day, and it is not because I'm feeling important. It is because we had already seriously negotiated that with Professor Gadhi. So I want to begin with an apology because this has been described as a keynote, and the word keynote connotes something serious or substantial, or at least some important content to convey. Now, just to avoid an anticlimax, let me confirm that there is nothing key about my presentation. And I have no substantial paper or notes to give you. So, keynote is a misnomer. Keynote is what Professor Tony Angie gave us at the first 12 conference back in 1998 in Cambridge. You would remember. Back then, I was in my LLM year, and I think Professor Gadhi was in his final doctoral year. His other name then was radical deconstructivist. That's what we used to call him. When there was a colloquium, I remember Gadhi used to say, "We are going to deconstruct that thesis." Now, at that time, Dr. Celestine Nyamo Musembi, she was there too at that first 12 conference. I remember she sat quietly at the front, her eyebrows every so often raised in enlightened absorption of erudition. And when she turned to shush me, because I was seated at the back, and I was speaking with my classmate, Dr. Zachary Lomo, and we were getting very overwhelmed by this new 12 terminology. And I was telling Dr. Lomo, I remember, this term liberal, we must really start understanding what it means, because we used to think being liberal is a good thing, but they were speaking as if being liberal is a bad thing. And then I remember Dr. Musembi, I remember looking at her then, and she really just looked like the Egyptian god of knowledge and wisdom. By the way, Dr. Musembi, I should tell you, I remember you used to host us for many dinners those days. We used to be so academically terrorized by Dr. Musembi because she used to ooze so much knowledge and wisdom that even before going for her dinners, I would have to brush up on my Feminism 101. I would have to read first before that. Now I can disclose that, Dr. Musembi, because now I have an armed guard. So I'm safe now. Now, that's my first apology. My second apology I should probably make is that when I got the invitation to speak, I did not ask Professor Gadhi whether I was expected to give a doctrinal paper. You know, a doctrinal paper is the kind that defines toil and retraces its history with about 240 footnotes for the 20th time to an audience that already knows what toil is. I did not ask that question, frankly, because I did not want to do that work. So if you expected that doctrinal paper, you'll be sorely disappointed this morning. I'm sorry. Now, I understood my task this morning, or at least I persuaded myself that my task was simply to offer some thoughts about toil in the third world municipal setting. Just so that we are on the same page, let's make sure we all understand that I'm using third world as an intellectual concept, not a geographical or teleological marker. As Professor Raj said, third world as a concept is not inflexibly moored to a fixed and unchanging geography. No, it's a second. It's that one. Okay. Yes. Or, as Professor Karen Mickelson reminded us, third world is a chorus of voices. Upendra Bakshi similarly recalls that there are geographies of injustice. Hence, there can be a south within the north and a north within the south, like Strathmore within Madaraka, right? Now, let's all make sure that we understand that I'm also using municipal to locate our discourse at the national level, but in a dialectical or even pragmatic conversation with international legal discourses. Very shortly, you will see why this is important for my conceptualization. Now, I must say that I stated to use the word conceptualization because immediately you use that word, the audience's expectations is heightened. So I was very hesitant. Now, let's start with what I believe is not a controversial statement for this audience, but could probably be a very controversial statement for the audience I will be joining this afternoon in Mombasa. Historically, is there someone who can do this? Or it has to be done from here? Okay. But that means you have to sit here. Now, historically, the third world has viewed international law as a hegemonic regime and discourse of domination and subordination, not resistance and liberation. Now, I'm sure that I got your attention. If I did, I may as well say this. Historically, women and other marginalized people, including people from my home county of Kajiado, have viewed national laws and legal discourses as regimes and discourses of domination and subordination, not resistance and liberation. See what I did there? One of the things I'll be urging you to do today is to see the parallels between TWAIL and local emancipatory discourses, and to know that you can practice TWAIL by engaging in those discourses. So, unlike Jesus, who scared that guy, remember that guy in Luke 18:22? He scared the guy by telling him that the only way that you can go to heaven is to go sell all your belongings, give all the money to the poor, and then come and follow me. That's a very scary thing. The guy never came back. Now, so unlike Jesus, for TWAIL, just like human rights, it can be practiced everywhere and in any form. It can be practiced in the small places and in the big cities. By big guns, like Professor Gadhi, and by determined status, like Mudei in his second year. Just for doctrinal purposes, let us recall some basic objectives of TWAIL. And here I will just use the words of Professor Makau Wamutua, which was so laconically and beautifully given in 2000 at the ACIL. James will remember, he was there. He was a newly minted professor. I remember he bought me just 2 glasses of wine. So let's talk about the objectives of TWAIL. The first objective of TWAIL is to understand, deconstruct, and unpack the use of international law as a medium for the creation and perpetuation of a racialized hierarchy of international norms and institutions that subordinate non-Europeans to Europeans. And by Europeans here, we mean all the white guys and the guys who think like them. First objective. The second objective is to construct and present an alternative legal edifice for international governance. The third objective is, through scholarship, policy, politics, and for Kenyans, even through maandamano, to eradicate the conditions of underdevelopment in the third world. The fourth objective is to relentlessly question and undermine conceptual meta-narratives in international law for the reasons that TWAIL finds them to be products of hegemonic discourses. So Professor Makau had the first three, and I've just added the fourth one, and it will become clear why. Now, I must say this, even though I know Professor Gavi might not fully agree. TWAIL was, to a very large extent, influenced by and benefited from the new approaches to international law, NAIL. I don't know how many of us know the history of NAIL and TWAIL, right? But for those of you who are uninitiated, Professor Gavi and I actually shared a doctoral supervisor. That's Professor David Kennedy, who was the founder of NAIL. And in 1998, when the first TWAIL conference was had in Cambridge, there was a lot of tension. Because the NAILers, Professor David Kennedy could not understand why these guys were branching off to start this TWAIL thing, while NAIL was there to accommodate everybody. I didn't know, I was just a baby LLM student. And I remember Gavi and Tony Yangi were very pugnacious about it. They were very aggressive. And I couldn't understand why they couldn't just make peace with, at that time I really wanted to get into the doctoral program. And I was wondering why James was antagonizing David Kennedy, who was the director of the program. It was a very difficult thing for me to understand, but later on I did. Now, the intellectual method is what unites NAIL and TWAIL. What separates us are the three functional objectives I've given above. So remember the four objectives I gave. The first three are functional, the ones given by Mutua. NAIL as a project could be undertaken by an astute intellectual who did not have or care for any political project. Just like algebra or calculus, if you are bright, you can do it. But it does not define your politics or ethics. TWAIL rejected that idea. And we would use some very impolite words, often after the sixth glass of wine, to describe what this pursuit of deconstruction for intellectual aesthetics seemed to us. Of course, NAIL also, in spite of itself, sought to offer a conceptual meta-narrative of being critical. And, as I said in the fourth objective, TWAIL is definitionally suspicious of conceptual meta-narratives. Now, talking of the first objective, as I have stated it, that is the objective of deconstructing international law, I must confess that my statement of it is probably too strident. That stridency reflects my particular approach to toil. It is important, however, to acknowledge that there is much internal diversity and rich variegation within toil. And so, toil is not a monolith. This is the result of where different toilers place their emphasis and focus. Some are socialists. Some emphasize opposition more than others. Some stress reconstruction more than others. Some stress feminism more than others. Some emphasize praxis more than others. So, for toil, it is, as Professor Obi Okafor says, it's a fragmented unity. But, as Professor Ravi, and now his newly minted PhD student, Dr. Harrison Mbori, and most of you would know he used to be here before he was radicalized. They have quite pugnaciously insisted that all these flavors of toil can be divided into two. Contributionism, or sometimes called moderate. I think Titi calls it moderate. The moderate strand, and the critical or radical strand. The contributionist strand emphasizes the Global South's contributions to international law on the one hand, and critical theories examine the Global South's subordination in its international relations as a legacy that is traceable to international law on the other. The contributionist strand tends to be more moderate, perhaps benign. On history and origins of international law, for example, contributionists insist that international law is the product of a number of civilizations, including, Africa, rather than the sole product of European civilization. Contributionism emphasizes, for example, that Africa is an innovator and generator of norms of international law. So here, think of the late Judge T.O. Elias of Nigeria. That's an exemplar contributionist. On the other hand, the critical theorists, or the radical strand, focus on the manner in which modern international law continues the legacy of colonial disempowerment while providing spaces for resistance and reform. For critical theorists, a central question for them is how, and here I quote, to defang international law of its imperialist and exploitative biases against the global South in general. Sounds very radical. Here, think of Professor Gavi, Professor Macau, Professor Angie, Professor Okafor, Titi, Mbori, and probably everyone else in the room. So, now we know something about toil, and we know it's complex and variegated. Now, critics of toil say that this is the first major flaw of toil. That toil has no unifying conceptual theory. We say that this is toil's first major strength, that it resists hegemonic meta-narrative. But we also know that one of the insights of the critical strand of toil is that international law was produced during the encounter of the Western world with the colonial other, and that colonialism is a central, not peripheral concern of international law. That is Angie. These historical insights yield the further contemporary insight that the colonial pedigree of international law persists in contemporary discourses of international law and its enduring project of governing and transforming non-European peoples. Given these insights, and given the enduring colonial legacy in the production of contemporary norms and doctrines, then can a toiler be a judge or a lawyer in state court in the third world without betraying her toil colors and values? If so, are there any intrinsic insights, values, or approaches to the law and the cases she is handling that she brings from toil? If the answer is in the affirmative, if the answer is yes, should the law teachers in universities in Kenya then not take toil a lot more seriously? Especially those whose vision is to be the region's hub of change agents? You know which school that is? Your guess is as good as mine. We are in it. Does it teach toil? As I pointed out above, toil is, above all, an approach to law that is committed to seeing the oft unseen violence, oppression, and social injustice that is occasioned on certain groups of people in the third world through the operation of the law. Much of this law, which oppresses rather than emancipates, whose doctrines hurt rather than heal, and whose rules dispossess rather than empower, has its origins in the imperial DNA of international law and its mode of diffusion globally. A toiler judge or lawyer, armed with this acute awareness and committed to uncovering the colonial origins of the various doctrines of law, as well as the theory of the adjudicatory process, is better able to see the systematic ways in which the law operates to disadvantage certain groups while masking its violence and oppression through neutral-seeming rules, doctrines, and practices. Most of these rules, doctrines, and practices are sanitized and given legitimacy through judicial imprimatur. It takes an unaware judge and lawyer to see the unseen operation of law, to hear the unheard, the unsaid, or even the unutterable perspective, and reconceptualize the case she is handling in a way which simultaneously does substantive justice to the parties, while remaining rooted in a theory of thoroughgoing change aimed at uprooting the colonial origins of international and national law. Now, I hope to spend the rest of my time demonstrating that this ambitious project that I've just described is possible. But it's only possible through a commitment to four things that I believe toil teaches us about law and lawyering. First, through a commitment to a historical analysis of law. Can you go? Go next. That's the first. Second, through a commitment to uncovering the material interests of groups in the society. You can go next. Third, through a commitment to pluralism in the law, the complex pathways to justice, and eschewing the colonial efforts to bring everything within the gaze of state-sponsored norms and legal system. In other words, prioritizing, where the first two commitments permit, people-centered justice systems. Now you know why I do AJS. And fourth, through a commitment to the idea that law exists to lead to societal transformation and not to preserve existing patterns of subordination, oppression, and equality. Law must, by definition, be transformative, because law cannot be, by definition, be neutral. I will repeat that for those who have never thought about it critically. Law must, by definition, be transformative, because law cannot be, by definition, be neutral. I fear I can be removed for that statement. Be removed as a judge. Now, we can spend the whole day on this one, but I'll just leave it there for a future conference, James. But in my view, this fourth commitment means that a Twaila must be engaged in an explicit political project. Political in the sense of improving the material conditions of the subordinated, the oppressed, the voiceless, the unseen, the unheard. To restate, a Twaila cannot be agnostic about the plight of the oppressed and subordinated peoples. And that was our difference with Nail. Nailers believe you can be agnostic about political projects. You can just do deconstruction for academic aesthetics. Twailers believe that that is unethical. These are the four commitments of a Twail lawyer, academic, or judge. Okay? They're still there. They're still there, right? You can see them so that they can convict you in case you miss one of them in your daily life, in your everyday practice, or scholarship, or policy making. All right? Or friends making. These four commitments are my reading of the various political and scholarly projects of Twailers. In my view, they completely annihilate, they completely destroy the second major critique of Twail. Because the second major critique of Twail is that it exists to critique for the sake of it. I read somewhere someone saying that Twailers just critique as wellness, as therapeutic thing, right? All right? Yes. All right? Now, recall I said that is in fact the major point of departure between Nail and Twail. Twail is committed to particular scholarly and political projects both at the international and national levels. I must admit that there are few Twailers who might find my very strident remarks in this sense problematic, but we are a very big tent, as I said earlier. In my view, though, the lived realities of too many peoples in the global south do not permit us to engage in critique for mere theoretical stimulation or academic aesthetics. That, to me, will be a betrayal of their voices, their needs, their blood, their sweat, their language. I firmly believe that if one claims to speak for a people or with a people, she must care about their lived realities and material conditions. One cannot be agnostic about it. Now, I already stated that one of the insights of Twail is that the third world is unavoidably constitutive of international law. International law is made at the frontiers of the encounter between the third world, that is the other, and the empire. Okay? You can hit the next. You got that? This is basically the origins of Twail, okay, and the imperial Tonyanji's book. Now, let me add another oft ignored insight, which was verbalized at least the first time since 1904 by Professor Robert Lee Hale, but it's never taught to students at Strathmore Law School. Said it's never taught. I'm sure. That insight is that the state is unavoidably constitutive of the market. You can hit the next. Take a moment to reflect on that. See what I did there again? See the parallels? Now, the implications of this statement, by the way, just to bring it home, is that the next time, for the Kenyans, you hear the next billionaire or tenderpreneur talking about the free market, you should just say, wongo, wongo, wongo. Just, that's the point. There is no such thing as free market. This has been the insight of Professor Hale since 1904. I was not taught it at the University of Nairobi, and I'm sure it's not taught at Strathmore Law School today. So the parallel should be obvious. As international law is unavoidably constituted and remade in its encounter with the third world, the market is constituted and remade by the state. It's important to say that that statement is neither a conservative or progressive statement. It's just a statement of fact. This means that it can be deployed for oppressive or conservative purposes or for emancipatory purposes. So one can choose. I guess it's just like the Bible. Could be used for progressive things, can also be used for shakahola things. Now, toil is about disarming the oppressive dominance of neoliberal legal and social thought at both the national and international spaces and discourses. Dominant international law naturalizes and preserves power imbalances in the international order and masks the dominance by allowing critiques at the margin as a safety valve to prevent radical transformation in its doctrines and discourses. I would like to suggest 3 ways. Yani mambo ni mangapi? I'm sorry for those who are not Kenyans. Some of these jokes will fly you by, but these are current things going on in Kenya. It means there are 3 things. 3 ways in which toil can play the emancipatory role in today's world of ius gentium, where international law, in some form, permeates the regulatory and governance affairs of the very mundane and quotidian affairs of a nation, and thereby help in, I quote again, defying international law of its imperialist and exploitative biases against the global south. So, mambo matatu. Ya kwanza, first. The first one was kufunga jela. Hiyo haiko. It's not the parallel. I know the last one ni mbinguni. So, ni kwenda nje. Okay. No, hiyo ilikuwa ya pili. Ya kwanza ni kufunga. Ya pili ni uhame. Ya tatu ni uende mbinguni. Okay. So we'll use those ones, okay? So the first one. The first one ni kwenda jela. You go to prison. First. This one is not here, so don't worry. First, there is the everyday production of what I call, quote-unquote, global law, a seemingly universal logic on governance, regulations, and the appropriate relationship between the public and private law. Now, there's now a serious contest on the way for the social conception for the trinity of property, torts, and contracts. There's now a serious contest, which means toil can become the regulatory technology or discourse for defanging the malevolent neoliberalism and illiberalism that can be born of either excessive sovereign nativity or excessive and unsuspicious borrowing of the global law. For example, think of the private-public partnerships framework that now we borrow all the time unsuspiciously, or think of the current regimes of sovereign debt. Second, TWAIL can also become the tool for deracinating the emerging standards of common decency in human rights by infusing critical thought in decolonizing human rights. For example, African jurisprudence has been pivotal in redefining the human rights contours of the death penalty, as well as sexual and reproductive rights, at a time when the United States is rolling back gains in both. You are aware that in the US, they're going backwards in both. In most African countries, we are going progressively in both. You could say, to a very large extent, and maybe that's a PhD thesis for someone here, you could trace TWAIL thought in that jurisprudential development. So, basically, TWAIL is improving, updating, and even radicalizing the content of human rights, thoroughly decolonizing it and humanizing it in the process. Third, TWAIL can be the conceptual technology upon which we can build grassroots coalitions, which can then be used to rebuild more legitimate and people-centered states in the global south, which might ultimately lead to a coalition of global south states. When that happens, so you can imagine local grassroots coalescing with each other, taking over state power, and then the different states coalescing as global south. When that happens, the end of globally entrenched inequality, oppression, and subordination will be at its end. This is, by the way, the response to the third major critique of TWAIL. Because the third major critique of TWAIL is that TWAIL is ambivalent towards the state in the global south. Yes, TWAIL is, in the main, ambivalent towards the state in the global south as presently constituted. This is because the state as presently constituted in the global south, well, everywhere really, is largely illegitimate due to its complicity in the continuing international order of subordination. However, TWAIL does imagine reconstitution of both the state and its citizens in an organic, thoroughgoing way, which would recreate individual states in the image of true equality, freedom, and non-subordination. I'm going to say a little bit more about this at the end of this paper, which is, by the way, coming in about 7 minutes. So please don't go to sleep yet. Now, in all these three instances, TWAIL can be used as a technology to remake international law at the frontier of national law, and then re-export a better version of it through the mechanism of global and human rights law, and in the last instance, through the mechanism of coalition building. In these broad projects, the two parallel insights that I talked about earlier, they're still here, that international law was historically constituted in its unavoidable encounter with the third world, and that the state is unavoidably constitutive of the market, become important starting points for framing legal concepts that aim to challenge the law's tendency to naturalize inequality captivity, suppression, and subordination of some people as their accepted lived realities. Here are specific examples where this is already happening. And this is probably all in response to some of the critiques of toil that we're seeing. We are already seeing South-to-South judicial dialogues and borrowings, which are producing a distinct new school of constitutional thought, which we can call transformative constitutional thought. I was never taught about transformative constitutional thought at the University of Nairobi or at Harvard Law School, and neither did I see it being taught in my 7 years at the University of Washington. But this is a concept that has emerged from South-to-South speaking. Kenyan judges speaking with South African judges. South African judges speaking with Colombian judges, and so forth. Secondly, we're seeing it in, and this is part of the really roaring success for Afronomics, we are seeing it in the discourse and the litigation on sovereign odious debts and financial governance litigation. Just this morning I was being told about an interesting case from Zimbabwe. I'm really looking forward to reading about it. We're also seeing it in climate change litigation and activism. And fourthly, we are seeing it in the expression of sovereignty through public and citizen participation as a juristic thought applied in specific contexts to resist hegemonic state actions. Think about all the public participation cases and jurisprudence we've had in Kenya and in South Africa. And then think about where that could head with proper grassroots coalition building. Now, ladies and gentlemen, as I end, you know, if you want people to pay attention, you promise them you're about to end. Or you say, finally. In conclusion, you would recall that I talked about the 4 commitments of a toiler. You recall them? I wish to relate them here, or to retell them here, by telling you what it means to be a toiler. Now, again, it means 3 things. Mambo ni ngapi? Okay, at least, I should say, at least 3 things. You can add others after that. You can add being a wife, a husband, after that, okay? But it means at least 3 things. First, one must have political commitment to end all forms of oppression in our individual spaces, capacities, scholarship, intellectual thought, and professional work. It is not enough to be critical. It is even worse to be just academic or erudite. If you do not know the answer to the question, what is your ultimate theory of change? You are not a toiler. Do you remember that program on American TV where they would do DNA tests and there would be tension and they'd say, you are not the father? Now, if you have no political commitment, and if you do not have the answer to the question, what is your ultimate theory of change that informs your work? You are not a toiler. And by the way, neither are you a Christian, or Muslim, or Hindu, or a real lawyer. I'm sorry, but even Jesus whipped some fellows in the temple. Sometimes it's necessary. Second, so that's the first one. Second, one must be pathologically optimistic that law has emancipatory potential to transform. Now, people who tend towards TOEL tend to look at black letter law contemptuously, like James. Or have you reformed? Yes. So, let me be very clear that law must be conceived at 4 levels. The doctrinal, that is the black letter law, the rules. The pragmatic, that is the practical or the application of the rules to the facts. Thirdly, the theoretical, that is the philosophy that coheres or questions the doctrinal and the pragmatic. So, a set of general statements that aim at justifying or falsifying the discrete legal phenomena, the theoretical. And fourthly, the meta-theoretical, the theory concerned with an analysis of the theory itself, where the context and meanings are produced. And the truth is, most of us don't get to the 4th level. We think being theoretical is the third level. In fact, most lawyers stop at the 1st level. The doctrinal. Yes? Okay. Body tells me repeat from the beginning. So, 4 levels. The first one is doctrinal, the rules. Okay? Most lawyers just know the rules. They just come and tell you, in the case of so and so, in the rule this and this, in the statute, in the this, so hold in our favor. Yes. Only in heaven. The second one is the pragmatic. Pragmatic is now the application of the rules to the facts. So contextually, okay, you have to show that this rule should apply to this set of facts and not that rule. This doctrine should apply to this set of facts and not that one. This rule should apply and not the exception. Or this exception should be the one to govern and not the rule. That's the pragmatic. The third one is the theoretical. It's justifying. It's basically justifying the application of the facts, of the rules to the facts. And the fourth one is the meta-theoretical. It's what questions the theory you are using to justify, okay, the application of the rules to the facts. And to be a real TOELer, you've got to be able to do all 4. In fact, you would have noticed by now what I'm saying is to be a real lawyer, you have to be a TOELer. Okay? So, and to be a TOELer, you have to do these 4, which means to be a real lawyer, you have to be able to do all 4. Remember, that was just the second thing we said. The third one must be courageous and bold. The work of liberty, freedom, and social transformation is not for the faint-hearted, because none of those things will be willingly be given by those benefiting from our unequal society. Yeah? And if I may add, the work of liberty is never done. It's never finished. It's always ongoing. So don't imagine there is a day you will do all this work and then you say, like this, it's called the foolish man in the Bible. Now we can just sit and reap the fruits of toil. That day is not about to come. You have to be courageous, you have to be bold, and you have to always be doing the work of justice. How can you do all these 3 things? Seems too much. I say simple. By sustaining the 4 commitments of a TOELer that we talked about earlier. A commitment to a historical analysis of the law. A historical analysis of the law means that you are doing either work at the theoretical or meta-theoretical level. Second, a commitment to uncovering the material interests of groups in the society. You must be asking, who is this benefiting? And who is this disadvantaging? As we said earlier,
rules and statutes and doctrines are definitionally distributive. That is what we mean by saying the state is unavoidably constitutive of the market. There is no rule, there is no doctrine, there is no law that is neutral. Each redistributes and distributes. In fact, I now urge people to talk about, never to talk about redistribution. It's always distribution. Those who have it call it redistribution when things change, right? But when they got it, they didn't think of it as redistribution. So it is not redistribution, it is just distribution. Law is always creating winners and losers. So you always have to be asking the question, oh, I wanted to use a bad word, but we're in Kenya, and a Strathmore, so I won't. Always ask the question, who is this benefiting? Who is losing from this rule, from this doctrine? And unless you ask that question, you're not doing tail. You're not doing real tail work. Third, a commitment to pluralism in the law and people-centered justice. You've got to move away from just the state. It can't be just the state. People have agency. The most important work of a tailor is to give people agency so that they can determine their own sense of justice, their own sense of substantive justice. And if they choose that substantive sense of justice, you must be ready to respect it. Don't say, oh, but, you know, Eleanor Roosevelt in 1948 said, it doesn't matter. Whose justice are we talking about at the end of the day? A tailor must ask that question. And fourth, a commitment to using law as a political project to address substantive justice questions of an oppressed or subordinated group. The four commitments of a tailor. Now, did I just hear someone say, can you be practical and give an example of 12 Kenyan project we can think about or be involved in? Did I hear that? Yes. Yes, I can. And yes, I will. I think the 12 repertoire in Kenya can be used to do the following. And this is just a menu. I wanted to call it a Chinese menu. I should call it a Maasai menu. One, it can be used to expose the remnants of colonial law and its continued application in Kenya. And there are many places. Think about the anti-poverty laws in Kenya. There are many laws in Kenya that criminalize being poor. Many. If you did apply, that could be one of your projects for your students. Just tell them for a seminar, go and read all the statutes and judicial doctrines and find which ones criminalize poverty, or at least stigmatize poverty. Secondly, in Kenya, we still have anti-dissident laws. Did you know that? In the law books. Did you see them being used just the other day? Thirdly, we have a lot of anti-customary law doctrines in Kenya. Doctrines that assume, these are mainly judicial doctrines, they assume that definitionally that which is customary is bad. In fact, the word they would use is repugnant. It doesn't matter whether the people like it. It doesn't matter whether they have agreed to it. It's prove to me that it is good. Then I will use it. Okay? A lot of work to be done. A lot of judicial doctrines to be debunked. And then we also have a lot of anti-liberty laws to be unmasked. And since lazima nichokoze Strathmore tena, for example, anti-sodomy laws in Kenya. That's one of the projects one can do. Second project. Clarify how the state is unavoidably constitutive of the market and how the myth of state neutrality in the market serves foreign powers and their local compradors. That's an important intellectual project. And it should be done in each African country, in each country in the global south, for example. It's huge. Huge project. Maybe the next work of James Gathi before he retires. Now, it's important for these purposes to distinguish between limited government and limited state. Now, in Kenya, our transformative constitution has no conception of limited state. Conservatives like talking about limited state. Our constitution, I want you to remember this, our constitution has no conception of limited state. And it is not a product of cognitive confusion. It is a choice. Instead, our constitution permits the state to do all in its power to transform the society. But it limits how the government can do that. Differently put, our constitution limits the government, but not the state. I hope now you can see why we had to defend our transformative constitution unto death in BBI. Because it is the genius of our transformation. Next project one can do is to expose how state capture happens. This is related to the first one, as the second one. And then demonstrate the role of transnational law in the capture. That would be a very interesting intellectual project in Kenya, for example. Fourth, start teaching TWAIL in your law schools, for the professors who are here. And I say teach it as the main public international law course, not as an alternative perspective. And while at it, infuse TWAIL thinking in all the courses that you teach. And if you are a student, ask 12 questions in all the courses that you're taking. If you're a student also, insist that 12 be taught in your law school as the main course in public international law. Let the other public international law be the alternative perspective. This should be the compulsory course. Let me end. No, on a serious note, let me end with this. Oh, no. Before I end, let me say. See, it works. It works. Now, the fifth thing that we really must be doing is to build a grassroots coalition to protect Kenya's transformative constitution. Because you know it's under attack, and it has been for a while. And it's under attack from political elites, political and economic elites, from both sides. So let me end with this. Why is grassroots coalition building important? Because that is part of rebuilding a substantively legitimate state in Kenya, which will ultimately have the capacity to be a TWAIL state. Remember we used to talk about a human rights state? I'm talking about a TWAIL state. A TWAIL state is one which organically subsumes the 4 TWAIL commitments I spoke about, because its institutions are peopled by TWAILers. That means a 12th state will be committed to ending all subordination, inequality, state-induced poverty, corruption, and oppression. Now, imagine if all states in the global south became 12 states, then all states in the global south would use law transformatively to resist hegemonic international discourses that harm their people, to remove markers of subordination and oppression among their own people, to build truly free, people-centered societies and institutions. Ladies and gentlemen, is that not the definition of heaven found in the Bible? 12 can deliver that ultimately. That is my meta theory of change. So, ladies and gentlemen, come we 12 together. Thank you for your kind attention, and apologies for taking too much of your time, and apologies for annoying some of you. Thank you.
Thank you so much, Judge. That was really outstanding opening. And now we have a few minutes for very sharp, targeted questions. The judge is going to be on his way. I forgot to mention, if we had to write to the Chief Justice, it's true. And she was very kind to let us have the judge. So maybe we are going to take maybe 4 questions. Make sure that every law school here is represented in the Q&A. All right, so who wants to go first? And it's going to be a balance between men and women in the room. Wewe unatoka shule gani? Kabarak. Aya, sharp to the point.
Okay. Mine is a 12 critique about its generality, and it's even written by our own lecturer, Mr. Sipala, about how being third world, then it's a bit too general. Shouldn't we now also an example is disability rights by that persons with disabilities facing problems in Kenya is not the same as in Mexico or Colombia. So what would that be a response to such a critique of its generality?
Now, as a lady. Somebody from back there? No question? Okay, which school? Which school? Kabarak. Okay.
Okay, thank you. I was reading a book by Professor Gadhi, and he spoke of 2 types of toilers. He speaks about reconstructionist toilers and oppositional toilers. So maybe if you can enlighten me on the difference between the thought process of the reconstructionists and the thought process of the oppositional toilers.
There's too many men asking questions. Chico, what's going on? I'm not accepting from you. Let's go here to hear comment.
For me, it's just a comment. I think the whole aspect of embracing toil would really help in the climate change conversation, because we have, for a long time, Africa has been seen as the victim of climate change. But then we can also look at it from the perspective that we're also the powerhouse of renewable energy. So I think it's really interesting, and it's something that I would want to study further. Thank you.
Okay. Who? Yes. Asfan. Professor.
I was just curious. That was an excellent presentation. Thank you. I was just curious. Of all of these commitments, what if a toil scholar decides to engage in a historical analysis of law? So you're uncovering perhaps some of the marginalized narratives. Your work perhaps is not leading to societal transformations. You just want to document the process. So for example, let's say the AFCFTA, you want to document so that it is written in stone for posterity would that still be a twail analysis, or does it always have to engage in all of the elements that you so eloquently articulated?
I'm going to this side of the room. I have a star student here who I taught many years ago, and she's going to ask a question or a comment.
Thank you, Professor John Ngugi, for that eloquent speech. I'm really sad I missed the first part, but I'm seeing it's being live streamed, so I'm sure I'll catch up on it. Since I have been requested to pose a question, I've written a little bit on decolonizing the classroom, okay? And you talked about infusing twail into the learning of international law, into the teaching of international law. Do you have any other pieces of wisdom on how to decolonize the classroom and make sure that the next generation is not fed what we were fed and now we're having to unlearn?
I have another star friend who just published a star article in a star journal, and she's seated right here.
Okay. Well, okay, thanks, Prof. Thank you for the presentation. It was very useful, especially for those who, like me, are just beginning their journey in academia and trying to teach some of these aspects of twail into the classroom. So mine is specific to my situation, which is if you're teaching, like you want to teach international trade law, for example. How does that look like? Because you have to talk about the place of, for example, the WTO law and talk about the agreement and then come down to the FCFTA. So maybe like a question more specific to us who are going to teach it, how does that look like to incorporate twail into the classroom? Because I'm sure it's not full ignorance completely of the international law and the place of the agreements and what they mean for the African context, but I'm sure it also means maybe paying more attention to agreements like the protocols in the FCFTA and what they mean or what they could mean for the continent. So maybe that balance, that clarity for me would be very helpful. But thank you so much, and thanks, Prof.
Nona. Oh, here and as Nona, give Nona, yeah, go ahead.
Thank you so much for this. It's interesting to draw the parallels between twail and other aspects of the law, and the parallels I've been able to draw have been between twail and African philosophy. So my question will be, what exactly is African philosophy and how will you incorporate that into building an African jurisprudence? Thank you.
Thank you so much, Professor, for the great keynote speech. My name is Nona Tamale from Makerere University. Very similar to the question raised by Florence and Janet. I'm really grateful for the fact that the last part of your presentation where you get into actual national projects, because I've been struggling to frame something I wanted to do around commercial law, especially. Like the way we teach commercial law is very black letter law. And so I just wanted to pick your mind on some more examples on how you move from the ordinary discussion of subjects like sale of goods, banking, you know. These are all foreign concepts, and we still, how do you infuse the law in it? Sometimes when you want to change some things in banking, it's those economic discussions, the law really just is used to reiterate what should be economic policy. So some of the ways we can infuse twail in commercial law subjects. Thank you.
Maybe the last one here.
Yeah, thank you, Prof. And thank you very much, Prof. Justice Ngugi. I think that was a very excellent presentation, and it's time you consider coming back to the classroom. My question is specific to one of the things you said that twail can do, which is humanizing and decolonizing human rights. And my question specifically relates to how we strike a balance between the fact that human rights are universal values and then explore the intersection between these universal values and what we consider to be African values and what you called customary law, which sometimes is considered repugnant. And this also relates to her question about Ubuntu and maybe African philosophy. Thank you.
Okay, at the risk of getting the judge late, but he won't blame us since we'll give him the mic and then he'll decide what after 11, how many minutes after 11 he'll risk.
Okay, thank you very much for that insightful speech. I must confess I'm a freshman in the School of 12 and would like to raise some few questions. Number one, on the issue of 12 commitment in promoting pluralism in the law and people-centered justice systems. We have seen how ADR has gained traction in our country, especially mediation. And however, in as much as that has been promoted, it has not still reached to the common mwananchi or to the common people. For instance, a researcher pointed out that arbitration, especially international arbitration, has now become like a conclave of the elite now. It has not yet, transcended to the common mwananchi. We have seen how mediators are really struggling to, come to the wananchi. So how can we infuse TWIL and ADR in order to promote and try and decolonize our legal system? Thank you.
Chico, you have the last word, and it has to be 30 seconds.
Yeah, really in 30 seconds, of course, thank you very much for the lecture. But really quickly, I'm just curious about your experience at the judiciary. Did you meet a 12 bench when you went there? And if you did not, how did you recruit them? Or are you still facing some resistance there?
Judge, we are sorry, but I know you really wanted to hear the room.
All right. I can answer them from here? Oh, I need to go. Okay. Sorry. So, because of time, I will answer these questions in rapid fashion. And then the rest will await the next conference, which we've been promised. It's coming. On the generality of TWIL as a critique, I believe I responded to that directly in my paper. Apala, you better go and revise your critique. In short, it's this. That is not a critique. It's a strength. TWIL is suspicious of any unifying meta-narratives. Unifying meta-narrative, by definition, become hegemonic. So, and as I have demonstrated later on in my paper, the fact that it is general, and it's an intellectual concept that is general, does not preclude it from being useful in specific progressive projects. So then, if that is so, what is the purpose of the critique of its generality? All right. Number two, reconstructionism and oppositionalists. Again, I believe I talked about that. Those are just words again that respond to the contributionism and the critical theories, the radical strand. So the reconstructionists will be the recontributionism. The oppositionalists will be the radical strand. So the same thing that I talked about, okay? So sometimes they are called weak, moderate, and then radical or strong, and so forth. Different people use different things. I believe there is a TWIL bibliography that I think should be shared with the students so that they can at least read some of the seminal work. The climate change and comment, thank you, I like it. That's exactly the point. We need to be changing the conversation. And part of the changing the conversation, what TWIL does, again, one of the critiques of TWIL is that TWIL presents itself as a helpless, hapless discourse. I hope I've demonstrated that that is not true.
TWAIL aims to put agency in the peoples of Global South. And you only do that by changing the narratives, that what we are being told about the different concepts, the different legal subjects, and so forth. So by doing so, we give people the agency. We change the narratives. Right now, people don't have the agency because the discourse that is used is a disempowering discourse. The discourse becomes the technology of disempowering. By changing the narrative, you make the discourse an empowering one and give people the agency. When people get the agency and then you continue with the coalition building, then you start changing things. Historical analysis and documentation, excellent question. Now, I think if you're doing historical analysis of a phenomenon, for example, or a doctrine, for purposes of documenting so that it's known and so forth, the only question in that is TWAIL work. If only you ask yourself, okay, by doing so, are you uncovering material interests of groups? Clearly you are. That's why you are, you're documenting that process, right? And then, why are you doing it? Because those people have already been disempowered. That's why, right? That is why they were voiceless. That is why their story have not been told. That's why they have not been documented. You are providing agency and a voice for them, all right? Then you ask yourself, why, in the end of the day, by the way, why are you doing it? Because sometimes we document for purposes of commercializing. So it's taking advantage of those people. So if you ask yourself that question, sometimes you might even decide, actually, I will not do this work. At the end of the day, I will not do this work. One day I will tell you of some research I did for 2 years and decided I will not publish. I will not, because I thought its repercussions. It was a very interesting intellectual project. But I thought the impacts of it on the people would be worse off. So when you ask yourself that question, sometimes even after you've documented for a number of years, you decide maybe this is not something that should be published. Okay? That is the commitment. It's personal. Okay? Nimeona watu sasa wameanza kusema, hii imeanza sasa kushika mahali. This is becoming, yeah, sometimes it has a personal cost. And if it has personal cost, so be it. Then, decolonizing the classroom, which is related to the question on international law and the question on commercial law and so forth. Let me just give you a very short story. I used to teach contracts law. Okay? Do I look like a guy who teaches contracts law? That was my bread and butter course. Okay, 1L, first year. First year of law school. That's what I used to teach. I also used to teach business associations, company law, believe it or not. Okay? I hated it. But I loved contracts. Okay? I loved teaching contracts. Now, let me tell you how I used to teach contracts. The first class, I would assign a case called BBM case. I know some of you know the BBM case. That was a case I would assign. I would just tell the students, read BBM case. I would give no further instructions. So they would read BBM, and they would come for the first class. And they would be, bushy-tailed, excited, BBM case. And I would just ask them, 2-hour class, I would ask them, what did you think about the case? And I tell you the discussions. And we had this technology at the University of Washington where we would tape the class, right? So we would tape it, we would tape these discussions, and would actually produce a transcript. So there would all be this interesting, philosophical, practical, pragmatic discussion. The first person would say, I thought this case was decided very unfairly. And this is what I would do. When I produce the transcript, every time someone said the word unfair, or fair, or moral, immoral, we would just count them. Okay? So we would just talk about BBM. BBM case, for those of you who don't know, is an adoption, a surrogacy agreement case. Okay?
A woman who was a doctor, married to another doctor, had MLS, couldn't have children, but she wanted children. So they harvested her egg, they harvested the man's sperm, they got a surrogate, paid her $10,000, which is a lot of money then, and paid for all her medical things and her food. The surrogacy agreement was very particular about what she could eat and so forth. It was a contract. And the idea was she would be paid, she was paid in incremental, and then the final amount she would be paid 3 days after she gave birth. She would hand over the baby to the biological mother, and she would never again come see the baby. That's what the contract said. Okay? So they signed the agreement. She carries the pregnancy. She gives birth. 3 days, they come for the baby, right? She's in this nice hospital, wherever. They come for the baby. The woman says, it's okay. Can you just give me one more day? Just one more day. So they get alarmed, but they say, okay, humanitarian, okay, 1 day. So they go away. While they are gone that evening, she jumps through the window with her boyfriend, with the baby, and they run away, okay, with the baby. So the action that is brought in court is for specific performance of the contract. Okay? The specific contract of the contract is hand over the baby as the contract said. You get it? So it's a contract action. It's an action in contract. So the defense by the surrogate mother is this is a contract in violation of public policy. It's baby selling. You cannot enforce it. So you cannot do specific performance. Okay? So the judge goes through contract analysis and decides, yeah, we can't allow this kind of contract. This is baby selling. Okay? So that is the context. Later on, there was a consent, by the way, and there's even a documentary done on BBM. So that is what I ask my students to discuss. Some say we think it's fair, we think it's unfair, we think, and so forth. So then I go through the whole contracts course. I teach them everything, including the feminist approaches to law. I think I have done a very good job of introducing them to critical thinking, right? But I also teach them doctrine. I teach them application of, the doctrine to the facts, and then I teach them, theory, but I teach them IRAC, okay? In fact, the reason I used to win Professor of the Year award, they used to say, he really knows how to teach IRAC, right? IRAC is, issue, rule, analysis, conclusion, right? That's what lawyers do. Right? What is the issue here? What is the rule applicable? Analysis. You apply the rule to the issue. You come to a conclusion. If you do that in your exam, for those of you who are law students, you get an A straight up. Okay? That's the easiest way to get an A. So, so they learn all this, and they're also doing all these things, they're taking all these other doctrinal classes, right? We come to the last class. The last class, I assigned BBM class, BBM case. Same case. 2 hours, I come to class. I tell students, you read the case? Yeah, we reread it. You remember you read the first time? Yeah, we do. What did you think about the case? First one. The issue in the case is the rule applicable is now applying the rule to the analysis. So the conclusion is
judge was right. The other one says, I agree with the issue, I agree with the rule, that the analysis is a little flawed. My analysis will be the following. I will come to the opposite conclusion. There I say, so the others say, may I agree with that one, may I agree with that one. 10 minutes, class finished. Nobody has anything else to say. Then I ask them, do you guys remember what we did in the first class? Do you remember the conversation we have? I play some of it for them. Right? This conversation lasts every year, 7 years. It was the same. In 10, 15 minutes, that class will be finished. Nobody will have anything else to say. I tell them, do you realize what has happened to you in a space of 12 weeks? What has happened to you is total indoctrination. Your mind has been completely colonized. That is what has happened in a very short period of time. And I'm sorry I've done a biological experiment with you without human subjects. But what has happened is what has happened to you is something that human beings have been looking for a way of doing for the longest time. And this is the shortest time. You know, in Africa we complain we were colonized for less than 50 years and we're still carrying the scars of colonization. Yours has happened in 12 weeks. So now your task for the rest of your law school life is to find how to decolonize yourselves because you are completely messed up. And I've just demonstrated to you how you've been messed up. Right? And the transcript is there. Nobody has talked about unfairness and immorality and so forth and so forth. So what happened to all those views you had when you came into law school? What has happened to them? Okay? Now, TWAIL must be a way of avoiding or teaching your students to resist that colonization. Because that colonization, the allure of Iraq is very strong. In fact, that's why many people go to law school thinking about justice and fairness and so forth, and then they find this very, very alluring method of analysis that is empowering. Okay? So now even when they go to their village, even their way of working changes. So they find a debate, they say, what are you debating about? Then they listen for 2 minutes, they say, okay, I think the issue is... That is true. So it becomes very empowering to them. And you just must keep reminding them that that is no way to be human. That is what you have to remind them. Okay? Now you have to teach your students the doctrines, as I've said. You have to teach them. Because if they don't learn the doctrines, and they don't learn how to be careful with the doctrine, and they don't learn the legal mechanisms of working with the doctrines, they will never be good lawyers and they will never do any of the national projects we're talking about. You've got to be able to do it. You have to have the keenness of mind to be able to do it. But you've got to warn them of the dangers. Okay? So you have to tell them, this thing, this doctrine thing, this analysis thing that I'm teaching you, it's like alcohol. You know, the alcohol comes with those things that says could be harmful to your health. But we still drink it. But it says it could be. Does it say could be or it says it is harmful? No, cigarette is harmful. But alcohol could be harmful. Right? So that is how you have to teach doctrine. It could be harmful to their health. And I think you've got to always let them know that. In international trade, I mean, of course, James has done this, his articles. Just use his articles as part of the critique when you're teaching. For every doctrine you teach also the critique of it. But I think you've got to ask your students from the first day, what is the purpose of international law? What is the purported reason for international law?
is to have free trade. That's what they say, right? In fact, a lot of them are called free trade agreements, right? So you've got to ask them, if all you want is free trade agreements, why are these rules 2,000 pages? Why didn't they say there shall be free trade? If it was just free trade, you just sell what that's free trade, isn't it? That's one of the questions I think you got to ask from the get-go. And I think if you start teaching students that the legal rules and the legal doctrines have a distributive impact, you start the journey of decolonizing from the first day. Now, African philosophy, this is what I would say. First of all, recall I said toil resists a unifying conceptual framework. So toil, like John Beatty taught us many years ago, that there is no unifying African philosophy. There might be aspects of it that are shared, but there is no such thing as a unifying African philosophy. And be very suspicious and be very worried when you start looking for a unifying African anything. Okay? There are certain aspects of it you can share. There is something called Utu, which, you say, well, that seems like it's common and humanistic to all Africans and so forth. But if you start saying, now we look for a unifying thing, then be very careful. Be very careful about that. Now, in terms of the human rights question and African customary law, all I say is this. All human societies had concepts of human rights. All. In fact, the way we teach human rights when we are doing AJS work is we go to the community and we ask them, tell us about your ideas of human rights. What are the human rights that exist and what did you call them? And they would give us their own ideas and we would write them down in their language. And in every instance, when we look at what they have produced and we come up with our constitution of Kenya and we look at the Bill of Rights, they are mirror for mirror. We've never gone to any society where they have said, we like defiling children. Part of our custom. We've not found one. Okay? In fact, we've not even found one that says discrimination against women is allowed. Not one. Now, we do know that in application, because of the patriarchal norms, there is discrimination, and that is something that you have to demonstrate to them, just like we have to demonstrate to, the modern state, that it's patriarchal as well. That what we call modern laws are also patriarchal. So they do as much discrimination as customary law. So one of the things that we have to do is to decolonize that human rights space. We always hear this, when we're doing AGS work, we always hear this response, especially from the human rights crowd, like, but aren't you worried about human rights abuses in that space? And I ask them, but aren't you worried about human rights in the courts? Human rights abuses in the court? Do you know how much human rights abuses happen in the court? He just told you the story of that guy who was in for 7 years because his file was lost, isn't it? Is that not a human rights abuse? Is it not? It clearly is. Right? And they say, what about gender justice? I tell them, it's a valid concern. It's true, it's a valid concern. But guess what? It is surely a valid concern also in the courts, in the state-based courts. And Dr. Musembi has done wonderful work to show how much damage and violence the courts do in their language. And just because it's a good day, I'm going to read you something that was from the courts, so that you don't think that human rights abuses only happen in toil-based African societies, right? Okay, listen to this. Canada. I want to give you examples from what we consider the president is from Canada, isn't it? Right? Champion of human rights. Now, this is R versus Wagga, a criminal trial for sexual assault in the Canadian Federal Court. Judge Robin Camp repeatedly asked the complainant, who was a 19-year-old female victim, why did you just keep your knees together? He also told her, why didn't you just sink your bottom down into the basin so he couldn't penetrate you? That's Canada. Federal court. So you think human rights abuses only happen in Maasai? Among the Maasai people? Now, Portugal. An ex-lover lured a woman to a room and then called the woman's ex-husband. So this woman had left this guy, so he went to, was with another boyfriend. So the present boyfriend thought that she was cheating on him. So he lures her to a room, calls the ex-husband and says, you know what? Now I know why she left you. She is a cheater. Come, I have her here in the room. So they get a nail-spiked club and they beat the hell out of her. Okay? They were convicted. They were given light sentences. In fact, they were given a suspended jail sentence. So the prosecutor appealed. The appellate court says the light sentence was justified. This is what they say. A woman's adultery is a very serious attack on the honor and dignity of a man. Societies exist where an adulterous woman is stoned to death. In the Bible, we can read that the adulterous woman should be punished by death. Not long ago, the criminal law of Portugal of 1886 punished with a little more than a symbolic penalty the man who, on finding his adulterous wife, killed her. These references are merely intended to stress that the society has always strongly condemned adultery by a woman and therefore sees the violence by a betrayed, humiliated man with some understanding. That's a quote. So when we talk about decolonizing human rights, we're talking about this kind of work, right? So human rights abuses, we shouldn't just assume that they happen in the other, in the places which are manned or womaned by the other. Human rights abuses also happen in those places which are peopled by people who think like Europeans, right? Which are the formal courts. And TWAIL and ADR. That's very simple. That's why we have AJS. Okay? So arbitration might not have reached the village, but surely AJS has reached the village. So we believe that the most the intervention that will change the justice narrative in this country eventually will be AJS and not ADR and not mediation. In as much as it's a multi-door approach, the idea is to give people the agency to choose which one they want, but we have shown through study, anthropological study, that when people are given that choice, even when they have the choice to go to court, they choose AJS. So the question is, which are the cases that we should allow for them to go to AJS? And we have a theory for which that
that should be. And lastly, 12 bench. We have 12 benches all the time. I believe the BBI bench was a 12 bench. If you look at the BBI judgment, there is a whole strong historical analysis. Okay? That historical analysis is 12 work. If you want to see a 12 judgment, read the BBI High Court judgment. That is a 12 judgment. And so that was a 12 bench. Thank you very, very much.
Thank you. So the editors come. We want to present the work of AfronomicsLaw to you so that we can let you go. We don't want the Chief Justice to come after us. You can hold one of them, and BC can hold the other one. And somebody can take... oh, the photographer is here. I think... I don't know how to do this.
Oh, we do one by one.
Okay.
Which one? Okay. Did you already take?
No.
Okay. And then I'm going to this one.
Okay.
Okay. All right.
You can also hold the other one.
Yes. Okay.
You can do the last one. You hold the
All right. I can hold both. I have two hands. Hands out.
Thank you.
Thank you. Thank you so much.
So we are, of course, delighted that the judge was here. We are, of course, running late, but we'll take a very quick break. Let's try to be here at the very, 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 very latest at 11:45, because we want to take a picture as well before the judge goes. So let's go take the picture quickly, Elvira.
I have two announcements to make. My name is Akecha Elvira. I was the coordinator for this event with the SLS team. So if you have any questions about how to get around the university or anything that you need help with, please ask me. So the first announcement is we are not allowed to bring in food or drinks inside the campus because that would make the work very tedious for the housekeeping. So please make sure you take your food and drink inside the student center. The second announcement is once you're finished with eating at the Kilimanjaro cafeteria where we're going right now, please make sure you clear your plate. There'll be a crate where we're supposed to place all our used utensils, so that's the second announcement. So I think now, if you've not taken the food yet, you can.
You can go take a photo outside.
Okay.
And then go for tea and be back here latest by 11:45. If you're late, you miss that session. Yes.
That is not a keynote speech, which I think has set the stage for the rest of the day's conversations. Just to be some backdoor background, on the steps of Hilton Hotel in 2015, I think, and we mused with Professor Gadi how there have been so many TWAIL convenings in so many other cities, except not so many in African cities. So yeah, we really should do more of like TWAIL conversations. Yeah, we should bring one to Nairobi, yes, we should. And this is one of the first of what we have been planning since then, musing here and there. I'd like to thank Prof. Gadi and the Afronomics team for making this possible. So we are going into a plenary session moderated by myself. My name is Humphrey Sipala. I am editor-in-chief, Kabarak University Press, and I teach at Kabarak School of Law, along with Dr. Msembi. We'll introduce ourselves as we go around. The idea of this plenary is to have a conversation with some of the teachers of public international law in Kenyan law schools, and to ask ourselves, to have a conversation with each other, and to also be open to conversations with our students and colleagues from other universities, other schools, on what has been our experience with teaching public international law, PIL, what has been our sense of the impact, the influence, the embedding of TWAIL in Africa, the questions that began to be raised about how to teach it, how to be critical, that Professor Justice Ngugi raised earlier, dealt with earlier. And so we just want to continue that conversation. We'll do this in a more conversational state. So we don't want to have so much as specific presentations, but we have some guiding questions, and we'll go around and we'll share about them. We are quite keen to have this conversation. So please, if any questions at the end of one round or the other, we'll invite conversations. Ask us difficult questions. So yes, I think we'll just, because there's no right or wrong answer, it's a conversation. But yeah, so let me hand over for introduction, Dr. Msembi.
Thank you very much, and good afternoon, everyone. I also echo my co-moderator's views about the keynote speech from Justice Ngugi. I mean, that was simply excellent. Except for the glasses of wine, I was not part of that. Let me just make the record clear. That was between them. I didn't know about the glasses of wine. Mine was just a scholarship. Okay. I teach at the University of Nairobi. Some of my students are here, and they probably are surprised to see me discussing international law, because I never taught them public international law. Truth is, I haven't taught public international law in a while, but I do teach in human rights, and I taught them in property, and I teach family law. So I was very relieved to hear the judge say that you don't have to be restricted to international law to be using the methodology of 12, and I can affirm that here. I can attest to that. So let's not take too much time. I can probably ask them the first question, then as you're answering, introduce yourself. I think we could do it that way, yeah? So the conversation will revolve around 4 questions, if we can get through all of them. And the first one is just for each one to tell us what areas they teach in. The question says what areas of international law, but now we broaden it out, okay? And then to tell us in what ways they have engaged with the TWAIL approach, okay, in the areas in which they teach or research. And then to reflect on the institutional or environmental conditions that that facilitate or impede critical teaching and research in public international law or related disciplines in Kenya. And then finally, to reflect on what they see as the next frontier for the TWAIL approach in the Kenyan context. So that's the gist of the conversation. So we'll start here, just go with the first question. What areas you teach in as you introduce yourself? Sipala, you have a different idea? No? Okay.
Oh, okay. Good afternoon, everyone. My name is Edwin Abuya. I am based at the University of Nairobi Law School. The first question was, I'm actually also glad that it was not international law. I taught international law many, many years ago, but now I teach human rights, I teach legal writing, and refugee law. That's it, isn't it? For now.
Is it afternoon? Good afternoon, everybody. My name is Florence Shako. I've taught public international law, international human rights law, but just like Professor Ngugi, I've taught contract law and others, ADR. What haven't I taught is actually the question. But at the moment I'm in practice. I have my own firm, Mitula Shako and Associates Advocates. But I still research a lot on international law. I love these spaces. I'm so happy to see all these TWAIL faces and TWAIL aspiring faces at the next generation. So I'm really happy to be here today. Thank you.
Hello, everyone. Yes, my name is Tom Kabau. I'm at JK Watt. I've at some point mixed units. Those are the realities of our universities. So it's not always, that is my area, international law, but at times I find myself teaching property law and jurisprudence.
Hello everyone, my name is Lily Boro. I have previously taught jurisprudence, law and development, environmental law, and international humanitarian law. Very happy to be here. Thank you.
Thank you. Thank you for the invitation. My name is Tomasz Milej. I will be speaking slowly because I'm still processing Professor Ngugi's thoughts. I teach at Kenyatta University, and before that I taught at the University of Dar es Salaam. Public international law, mostly East African community law, international trade and investment law. Long time ago, international humanitarian law, but it was a long time ago. Everything. Refugee. And I do also clinical projects. We go out of the university and try to engage with the NGOs and learn from them and provide some assistance. Thank you.
Sawubona. Good afternoon. Ogada Evans is my name, from the University of Nairobi. What have I taught? I'm teaching public international law. I'm teaching human rights law. Like my seniors, pia natumwaga to teach contract law, property law, those ones that you really don't like. I have taught international criminal law. And yes, it would be remiss of me not to say that Professor Buya taught me human rights law. I'll be disciplined for that. Thank you. No. You will not blame Professor Buya at all.
I suspect I didn't. Did I say what I teach? Oh yeah, terribly. I have taught in another university. I will not even mention where that is. I taught legal research and writing, communication skills. We did this naughty thing. You know this problem that I think we all have, where we are required to use these university common courses, and the students feel so out of place for them because they're being taught by this department that is not particularly concerned or does not even have the bandwidth to adapt it for law students. So I naughtily made common skills legal research and writing class for lawyers and teach them how to read judgments and stuff like that. I've taught human rights law, international humanitarian law. I was once asked to teach international law to international relations students. And that made me remember something, that most of international law is practiced by non-lawyers. Most diplomats are not necessarily lawyers, so maybe we compound ideas here that in the actual practice, that the summit people are not thinking about. Anyway, yes, so that's what I've taught, and yeah, public international law. So we could go to the second question, and I think we began to touch on a bit of the polemics. Have you engaged in critiques of international law or municipal areas of law from a third world perspective, a TWAIL perspective in how you've taught?
Me again. No, it's okay. It's okay. Let me answer by giving an illustration of the engagement of just general international law from a third world perspective. There is an author called Jack Donnelly, and there are three things that Jack Donnelly says. And that ties to the question that the gentleman behind there talked about, that, we practice human rights. What Jack Donnelly says is third world countries or non-European countries do not, one, understand the concept of human rights. Number two, that because you don't understand, you then cannot practice. And then number three, that if you want to get a touch of what happens human rights-wise, you need to go to the westernized world. Of course, that argument has brought in a lot of critiques. Yeah, but what Jack Donnelly does in his article, which is very good, is that he uses illustration. So he goes to Africa, and you heard Judge talking about the African customary law, and he says no. In fact, he dismisses and says, those arguments cannot hold water. He goes to Asia, he goes to Russia, he goes to China, and then he goes to India, and he says all the examples that have been given are nowhere close to human rights. One, understanding, and two, practice. So if you pick, and I always use Jack Donnelly as the pitching point in my class. And of course, the first class, the students are very angry about it, and they say, no, this cannot be. Yeah? And Jack Donnelly has been criticized, but there's some work that I'm doing now on the ESC law. And in a region like this, we have the municipal domestic law, and then we have the ESC law. And in the context of the ESC law, citizens of the East African community are allowed to move to other countries and set up businesses, commercial enterprises. And you can also move with your spouse. Yeah? But if you come to the domestic law of Kenya, it doesn't allow spouses to come on board. So what spouses are given is a different pass. It's not a pass that allows you to work. It's called a dependent pass. Yeah? So why am I telling you all this? If you reflect back to Jack Donnelly, he says, yeah, you may now have the conceptualization of the right to move, but are you really practicing that right? Or should you go to the EU where some of those factors have been debased? Yeah? So in terms of engaging with critiques of in international human rights law, there is a side which talks about the conceptualization in terms of paper rights. So you heard the judge talking about the progressive nature of the Kenyan constitution. But as far as some of the community rights, which is the area that I'm researching on, are concerned, it just doesn't translate. So there's a huge disconnect there. So for me, the critique that I have for international law, but now it's reflected in the ESC sort of legal framework, is the desire by countries to try and to be party to the treaties, but when it comes down to implementation, then the countries are countries like Kenya very reluctant to sort of accord. Yeah. So the critics of international law are many, and when a judge was talking, it reminded me also of another project that I'd done on what you call the colonial theory, and it sort of fits in well with the TWAIL approach of talking about looking for local solutions. Yeah. In the context of asylum and refugee, again within the context of the East Africa, we sign on to the treaties, but when we come down to things on the ground, things are very different. Thank you.
I'll also tell a story because I think experience sharing is the best way to approach it. When I attended the University of Nairobi and I studied international law, I learned from all these European textbooks and I didn't see a problem with it. It was great. I loved the unit. And to be honest, when I began to teach way back in 2010, I was guilty of doing the same thing. I picked up the same textbooks and I was teaching and I was really proud of myself. I thought I was a great teacher, to be honest. And then I was with our dean at the time, Dr. Sylvia Kangara, and she told me, you need to go and attend this forum. And I was like, okay, that sounds like fun. So I went to London for the Institute of Global Law and Policy. It's hosted by Harvard Law School, but they've had it in different countries. And they started to talk about this alternative narrative to international law. And I was so puzzled. What's going on here? Session after session, starting to learn that, you know what? You can look at international law from a third world perspective. And that was my interaction with TWAIL, and I started to learn about its methodology and its approaches, just like some of you here are starting to familiarize yourselves with it. And as I did that, it really came now to inform my research. And I thought of now the classroom. Being an academic of so many years, I was like, okay, wait. Classrooms are actually one of the sites where legacies of colonialism are perpetuated. And that really shook me to the core. And I started to think, you know what? You need to think about how you teach. You need to think about the text that you pick up and what you're telling the students. So that is when I started to read more and more, and thank God Professor James Gadi has a great starting point with a bibliography on TWAIL, which you should look at, and you start to get all these authors, and you start to understand that as somebody in the global south, you have a voice, and your voice matters, and your knowledge production matters. Until then, even as an academic, when you were submitting papers, it was to all these global north journals, and they got to tell you your paper is, needs this 100,000 corrections, and basically your voice is not valid, which is the communication. So I could go on and on about it, but for me, my engagement with TWAIL was more about a moment of understanding that my culture matters, my voice as somebody in the global south matters, and that's what I should take even to the classroom. So I'll talk a little bit more about it, but that's how I started to engage with it in my teaching and in my research.
My experience has, again, as just been mentioned, been informed also on how I received international law. I was somehow, when we did it undergraduate, it was more of a perfect system until I now go to research, and I realize this is a very imperfect system. And the moment of course, Professor Gidu introduced us to CLS, critical legal studies, and bringing in the issues of deconstructing, demystifying. The fact that law in itself does not lead to justice. That law in itself can be very unjust. So, that was a good reawakening in terms of the context of deconstructing the realities of the law. And then when I was doing doctorate, I met a professor based in the UK by the name of Professor Tony Cutty, who is largely on philosophical approaches to international law. And I realized, again, that the perception was far from the reality of how international law, its origins, how it is utilized in the contemporary world, how it subjugates. And at that point, those are the times I would, in the course of doctoral research, one of my friends was actually doing TWAIL approach to self-determination. And it was very informative to me, and got a lot of interest, realizing that there's a TWAIL perspective to almost everything, and helps you understand the realities of international law. So when I came back to Kenya and started teaching, one thing I did was to ensure that if I teach public international law, and we are, I could even see in the course outline, for instance, the guide was when we about theories of international law, and we were given examples as positivism and natural law. And I asked, now there is no even TWAIL. So I made TWAIL my biggest concern when I talk about theoretical approaches, and when we have different topics, we also want to have a TWAIL perspective. I went on and started delving to other areas such as intellectual property, things to do with the say. And looking at the regime or international law, I realized how unequal and how the international regime on property rights, including TRIPS, subjugates the interests and the concerns of that world. For instance, traditional knowledge is not mentioned under the regime of TRIPS, but there is continued expropriation of that kind of knowledge, and plant varieties rights. You might be surprised, Kenya is one of the few countries, Kenya, I think Tanzania, and one country in Northern Africa who probably have signed to a regime called UPOV. Kenya itself amending its Plant and Seeds Varieties Act to go to that regime, which is very inappropriate on subjugating the traditional, what we call traditional farmers' privilege, whereby they can save and sell seeds, etc. But this was aimed at, again, pioneering what we are, you have heard about these there's this the word is escaping me, but the GMOs, all to do with that, and some new technologies where companies are owning seeds, then they die after one planting. That is not good for African, not only food security, but livelihoods and economies because of our small scale nature. But then you look at other countries which are more knowledgeable, and India has had a more enlightened, for a longer period, with the realities of international law. And probably they started challenging those realities a bit earlier. But you'll find their regime is very different because India totally refused to do that. So the 12 framework has been very informative for me. And as is happening, there's general transformation on our the way we look at international law, and I believe that is not happening only to me as I teach, because those are the realities of people are questioning more. In fact, as I would say, India was a bit ahead of Africa on questioning such things. So I think this is part of an African transformation. And us as teachers of international law, or of law, let us not use international law, because 12 informs us on anything which, whether it is environmental law, there is an international perspective. Whether there is, as I have given an example, using intellectual property, IP. So that we continue and, of course, more significantly contribute to that transformation.
Yes, so maybe I can also give a story with respect to my experience with TWIL. So firstly, when I joined academia, I had been working as a human rights practitioner. So perhaps that also sort of informed the frame with which I was approaching my teaching. And so, you know, I was very conscious, for instance, about using social justice as a frame of reference in my teaching. So, for instance, in environmental law, not just having a doctrinal approach, but really centering other voices. So the question of validity of knowledge, what knowledge is valid, who gets to decide what is knowledge and what is not, and what, what's their interest in as far as determining only one form of knowledge to be valid and to discount or to debate other forms of knowledges. So at the time when I started teaching, I wasn't really familiar about TWAIL. I only sort of came to get acquainted about TWAIL as I was progressing in my academic journey. And maybe I would just speak to give an example, for instance, when I was teaching jurisprudence. So again, on this question of knowledge and what knowledge is valid, I mean, it was so stark how Eurocentric the curriculum was. I think jurisprudence is probably one of the most Eurocentric curriculums that we have in the law school, and sort of grappling with the confines within which the curriculum is considered to be complete as far as teaching jurisprudence, all the theorists that you have to teach in order to complete a course on jurisprudence. But then just feeling very a sense of unease in how the curriculum looks, in who it's representing. And I think this is a conversation that, I was very sort of alive to the fact that it's, I think as you were saying, Florence, that, this is, I don't feel represented in the knowledge that I'm teaching. Are my students represented? I remember there's a lecture, Professor Gavi, where you were talking about teaching international law, and do your students see themselves in the rules that you're teaching? And if they don't see themselves, if what you're teaching doesn't reflect their lived realities, then we have to ask ourselves, what's the purpose of this knowledge, and why is it so top-down? Why isn't it more reflective of our lived realities? So I think 12 for me has been very influential from the perspective of recognizing different sites of knowledge, other sites of knowledge as being valid, and foregrounding those other forms of knowledge that ordinarily are obscured in our law curriculum. So thinking about the fact that when it comes to knowledge, that a lot of academic disciplines have been built on a colonial archive of knowledge, right? So the very foundation it's a form of knowledge that is not, what's the word that I can use? It's not neutral. It's actually because knowledge systems, essentially, they've been used to subjugate, right? Western knowledge systems have been used to subjugate other knowledge systems. So in essence, sort of just
So I see it's an afternoon of personal stories. So I would also share mine. But I will start with a piece of advice which Professor Gathi gave to young scholars in Ghana. And he said, write about things which are relevant to who you are. And I think it's quite similar with teaching. Teaching is about relationship. And I cannot start teaching without thinking who I am and where I am and who I am talking to and what do I owe to the people I'm talking to. And paying attention. What is the living experience around me? How do I experience a public university being slaughtered by IMF conditionalities? How we cannot give to our students what they rightly deserve because of that system. However, I would start with who I am. You know, I come from a faraway, weird country. And this very fact conditions my thinking about public international law, about law, about life. And what is 12 for me? 12 for me is a personal journey. Not even a journey, but a struggle. A way of challenging my intellectual boundaries. The way of making me think more deeply of who I am and how is my personal experience relevant in other parts of the world. I think Professor Ngugi today morning put it very aptly that one should be suspicious of unifying meta-narratives. So my struggle continues, my struggle with 12 continues, but I think that is the stage I have reached. I have realized quite fast that my narrative, the way I was taught, not international law, but what I was hearing at school, what I was hearing from my parents, from my peers, the dominant media discourse in my... Better? No. In my weird, faraway country is so much different. So, let me say something about this weird, faraway country. I'll keep it brief, yeah. I come from Poland. Poland gained its independence in 1918 due to, after a long war, after huge sacrifices, also in the 19th century. And Poland, you know, was always, this is the dominant, the geopolitical reality, is somewhere between Germany and Russia, and it is a flat country, so there are no mountains. The flat country means that armies and tanks can pass without difficulty, so this is what tanks and armies have been doing throughout the century. But what I wanted to say, Poland's independence was cemented by public international law, by the Treaty of Versailles. And in 1939, Poland had a treaty with France against Germany. And the treaty said that if Poland gets invaded by Germany, which eventually happened on the 1st of September 1939, after 2 weeks, France would launch a full-scale attack in the west of Germany, so that the Polish armies get some breathing space. And this is how the entire tactic, or strategy of the Polish army was set up. And what happened? France, of course, did not do that. Yeah. So, and this is, I think, an event. Those two, yeah, cementing of public international law, securing the independence. Yeah? And public international law being betrayed, that actually conditions the Polish thinking, meaning my thinking, my as a teacher here, about international law. Yeah? So, what I wanted to say, for the way I was socialized, international law was not, and I will again quote Professor Ngugi, was not an instrument of hegemonic regime and discourse of domination and subordination. Was not. But it was considered as an instrument of preservation, as something that empowers this small struggling nation in this geopolitical situation between Russia and Germany. And even before coming here, I looked at the recent position papers of the Polish government, saying that, well, being a member of the Security Council will be about strengthening the compliance with international law. Strengthening the compliance. And when Professor Gatti pokes fun at me that I am, making those distinctions between shell and black letter law, I think it's because of that. Yeah. Now, my reflection with TWAIL. TWAIL is actually challenging my entire universum I grew up in and with. And this is a struggle which I think I will continue until the end of my life, and I will go to my students, they will see me struggling with that. Now, so of course, again about this perspective, it is about this Polish perspective. So, public international law as something that needs to be strengthened because otherwise we will die. Well, I'm very much aware that the Polish perspective is a perspective of an insider. As Professor Ngugi said, all those white guys. Yeah? Yes, the insider. Insider, frankly speaking, being a little bit, not even sometimes, not even a little bit, but looked down upon by the true Western Europeans, yeah? As the white guy, but the poor one, the less capable one, not that intelligent, but trying, but still an insider. Yeah. So the mere acknowledgement of the main claim of TWAIL, it was a mind-blowing for me to finally see that this public international law, which was so essential for Polish emancipation, is an instrument of oppression, of disenfranchisement. Yeah? And this is something I keep struggling with, trying to reconcile. And I will never do that. I will never succeed. Because if we were to succeed, we would be finding what a unifying meta-narrative, which is not there. Yeah? So that's my personal intellectual and journey. And said, I think my last statement, yeah. This is why TWAIL and all those contributions by Professor Gatti, by Professor Angi, by Madam, by Florence, your text on teaching, on decolonizing classroom, yeah. This is something which is crucial, not only to my academic growth, but also to my personal growth, to challenging my perspectives. This is something that keeps me alive as a human and as a scholar. That's too high sounding, so I'll pass to Evans now. Thank you.
Si tumpigie rafiki yangu mwalimu makofi tafadhali. And I grew up during the Moi times. How many remember President Moi? I stopped assuming. I was here a couple of weeks ago and people don't know so much. Moi's clubs used to be 3. So moja, mbili, tatu, funga, fungua. Now we are alive. I saw somebody's sleeping there, so that had to come in. Now, again, I stopped assuming. How many remember, or how many know of Professor Mutungi? Onesimus Kimweli Mutungi? Apart from Professor Gadi and the old school? The new ones don't know. How many know of Justice William Musyoka? Justice William Musyoka? You see, it's the older generation that knows this. Young guys, let's know our people. Because I am always fascinated. We know of people who have contributed or made their contributions in their unique societies, but we don't know our own. Now, those 2 names, I want you to write them down, those who are writing. Nimeanza kufunza. Professor Mutungi was my teacher. And Justice Musyoka, resident judge in Busia, was also my teacher. And the two of them combined to plant the seeds of academic insurrection in me. I was a very problematic person, questioning and asking all manner of questions, because the seeds of critical thinking were planted by these good teachers of mine. Now, Professor Mutungi, in one of the sidebar conversations we were having, he's passed on and I remember him till today, told me always question everything. Those were the first seeds of critical thinking related to the TWAIL conversation that we're having today. And part of that thinking leads me to the following. I will probably ask the founders of TWAIL, Professor Gedi, Dr. Celestine Nyamo, is it still appropriate for us to use the term TWAIL? Third world. Because third world creates a stratification, gentrification, where the black and brown are made to form part of a third tier. So whenever I'm given classes to teach, I deliberately caution and avoid using the term third world or civilized nation, as if the rest of us are not civilized. These were terms that were used in a certain point in time. Are we together? So critical thinking. Bob Marley, emancipate ourselves from mental slavery. That one you know, eh? I can see them nod, eh? Let us ask ourselves questions. Who are we as moral beings? As a human person? The knowledge that we are being fed on. How many have heard of Carl Schmitt? Carl Schmitt? Political science, jurisprudence? Anyone? And you expect to compete with Professor Bue in court, eh? You expect to honestly deal with Professor Bue in court, eh? Please write the name Carl Schmitt down. You're going to read him, eh? Those of you who read extensively will realize that Carl Schmitt was a philosopher for the Nazi Party. And when you go to schools and you read extensively like I expect you to read, you will get him spawning a lot of theories, and so many of them, so many of his theories are recited ad infinitum. There are people who are very passionate about Carl Schmitt. Carl Schmitt was an apologist for the Nazi. He was an acolyte of Hans Kelsen at the University of Cologne. So when you read Carl Schmitt without understanding his background as a Nazi apologist and as a philosopher, you become indoctrinated. Your mind is controlled. You feed the knowledge and theory from Carl Schmitt, which worked within his environment. As a human person, as a human being, and I research and read on international law areas, what makes you think that we didn't have international law as known to us, or the near equivalent of international law? I've seen a Muslim sister in a hijab here. She will probably confirm that we have what we call the siyar in Islam. The siyar is the equivalent of Muslim international law. We have principles under Islamic international law. Principles and concepts like al-had, the promise. Al-had, the promise, is what we will equate to Pacta Sunt Servanda, international law. Pacta Sunt Servanda, article what of the Vienna Convention? Mulisoma mkatupa vitabu, eh? Al-had is the equivalent of Pacta Sunt Servanda. Al-aman. Al-aman is a concept of diplomatic protection under Islamic law. Look at the relations, the connections between that and inviolability, diplomatic law. Look at al-ijma. That's another concept in international law. So ladies and gentlemen, now that I've prodded you to think and to ask questions, the key to evaluating who you are as a moral person is to emancipate yourself from mental slavery. None but ourselves can free our minds. Thank you. Thank you.
It's yours, it's yours.
Thank you so much. I think it's time to heat up a bit. Are you suggesting that contributionists are critical? Since Professor Gadi is here, the idea that there's a colonial foundation, so maybe when we dig into the history of how we contributed, but the story for another day. I don't know whether we have answered the question ourselves, Daktari, before we... part of the conversation. I wanted to first ask if the thoughts that have come out so far have prodded any questions. It would be terrible to wait so long if you've had something that pricks you. So we could take a few prickly questions. Okay, I think that was the first one. I'll take the mic round.
Thank you so much for this opportunity, and I want to thank the panelists for this insightful first part of this plenary session. I particularly want to echo what Senior Evans Ogada has said about the naming and the terms that we have adopted. And I was having a conversation last week. That was before this conference, the one that was happening about the climate change. And I happened to meet an investment banker during one of the sessions. It was held at the Memorial Park. It was a good session that preceded the conference. So this investment banker is someone who was also active in climate change advocacy. And so we get into a conversation. And he refers also and says that he has a problem with the way we refer to ourselves as the Global South. And so being also a member of this movement, although I've not been active, it also came to my mind. I was thinking, why would we adopt the name Third World? Why would we adopt the name Global South and Global North? So that if I'm here and I tell Sipala I'm on the Global North and Sipala is at the South, I don't know what that would mean. But I really want to echo what Evans Ogada has said, and I think maybe now that scholars are the most powerful voice in the world, scholars are people who really drive change. And in fact, what scholars do really has an impact. I think we should maybe adopt maybe names that tend to give us some sort of recognition. Because if Evans says that I'm from the University of Nairobi, it means that the University of Nairobi is a very powerful place to be. So thank you.
May I point that is just a suggestion? To our colleagues who are visiting us from outside Kenya, you can see the rivalry. So it's a healthy rivalry. So yeah, go ahead.
Thank you very much. You said something about civilized nations, and you're asking, so who's not civilized? And I remember having a conversation with Godwin yesterday, and he was talking about how even just when we look at the sources of public international law, one of the sources, the general principles of civilized nations. And so whose law are we looking at when we're talking about public international law? So just from that, and he asked, why can we not question that and even just, I don't know, just have that taken out completely, because public international law involves everyone. It's international, but we're talking about civilized nations. And also another one is the judicial decisions and teachings of the most highly qualified publicists of various nations. I've done public international law, and I know we do not talk about Prof. Gathi, we don't talk about Dr. Celestine, we don't talk about those highly qualified publicists of various nations. And so I think that's something that we need to also talk about when we're looking at the sources, because the very first thing you learn about public international law is the sources anyway. So the foundational understanding is already distorted from that point.
Thank you.
Yes, perhaps to share my thoughts first on his question about the names. I do not think the names are an extension of prejudice. that world and the global south and all that, first you need to understand that 12 is reactionary to prejudice that was inflicted by the existence of public international law, Eurocentric public international law. So calling ourselves third world approaches is an acknowledgement of that fact, is that we are the other in terms of, from the perspective of Peel. And now, I have a question for Professor Ogada. Just, you mentioned some examples of, and perhaps I'm about to question the whole foundation of toil, but you mentioned about the Arab, Muslim Arab equivalents of international law. As toilers, do we just focus on the Eurocentric international law, or all other domineering and colonial systems of international law? Because I think Arab international law should also be there. Rarely spoken about, but yeah. Thank you.
Samantha, I thought our discussions were off record. So I was surprised that, but yes, of course. So to the panel, just because, especially the last speaker, Evans, raised those points, I think there are probably many ways to do the things that we do without necessarily worrying about what we are doing. I'll give a couple of examples, and I've shared them with some of our colleagues, but I think that the design of course outlines and teaching approaches fairly accommodate things. So if you teach public international law, and you're talking about law of the sea, and you're talking about maritime zone delimitation, and you forget that when Francis Njenga of Kenya was actively leading the Africa group into the negotiation of the third round of UNCLOS from 1971 to 82, he was the spear, he was the arrowhead for the exclusive economic zone. So what's the problem? If you talk about Ambassador Tomiko, why can't you talk about Francis Njenga? There's really no difficulty here. If you're talking about international humanitarian law, how difficult is it to talk about Francis Deng and his work on R2P? Why can't you meld that into the work? If you're talking about baseline delimitation and you know that it's the canon short rule that was the original idea, of course we didn't produce canons. And of course we know canons were not for good purposes. We can find ways to undermine that, and then connect it to the broad agenda of extending territory from land into the sea. And then that helps you to even question sovereignty, to question the building of the idea of territoriality, territorialization. So there are many ways, and I was sharing with Prof. Gatti earlier on that I was doing this in Ghana, much against the advice of my colleagues, because we shared classes in PIL. Some would teach this, you teach that. But this is the way I approach it. Every subject, there was an intentionality to include literature that was already available. It's amazing that if you probably took a survey, probably only 3 or 4 people may know about Francis Njenga's work in this room. So, who is even Francis Njenga? I'll not even go to the younger ones, the older ones. I'll go to the younger ones, I'll go to the older ones. Maybe if I did cold calling. I don't want those with their hands up. They might be. Okay, I'll skip that. But I'm just trying to say that there's enough material readily available for us. It doesn't have to be that we are scrambling to create something that is anew. If I talk about Njenga in my work, there's no surprise here because Njenga's record was there for the 11 years that we negotiated the third round. That's just one example. And as I said, every topic that I taught in PIL, I took it upon myself to infuse that in my teaching. So I think that as we talk about these things, as Evans was suggesting, mentioning the names to the students and pointing these things out, it's important for us to sort of understand that it is not like we are creating something anew. Perhaps we are only rediscovering what we left behind. I think that it's one way to approach the tool problem for the younger ones when we encounter tool and people say, what? The very idea of putting one more marble in the box, so we count 5 marbles, not 4, it's in itself an end. I think that we need to be able to advance those kinds of arguments because people will say, so to what end? You say, well, you knew about 4, now you know 5. So don't tell me to what end. Thank you.
Yes, I think that comment, that intervention is deserved of a Moi clap. So, yes. Do any of our panelists have something to share in regards to that as we move to the next question, maybe quickly?
The brother there asked me a question, domineering models, hegemonic models. It is indeed true that the Muslim worldview and institutional contribution may be considered domineering in certain contexts. And indeed, when I teach jurisprudence, I always delve into Somali, the legal system among the Somali. How many have interacted with that before? Anybody taught from the University of Nairobi jurisprudence? Hey, yes, Nibwana. There is the Somali legal system, and it has 6 principles. And one of the principles in the Somali legal system is that it is non-religious. So contrary to the belief that Somali is equivalent to Islam, that's not necessarily the case. And you can see the Islam and the influence of Islam coming and masking that identity. So as my brother here said, let us rediscover that history. How do you rediscover it? Write that down again. Professor George I.T., Ghanaian professor from Georgetown, passed on 2 years ago. Very intelligent mind in terms of opening our minds to traditional African institutions. My brother who asked the question about the Muslims, in conclusion, Minister Louis Farrakhan, whoever controls the circumference of your knowledge controls the diameter of your thinking. That statement is loaded and heavy for this reason. That whenever you think that you are satisfied in terms of the knowledge that you have acquired or have read, you are not yet there. Professor Abuya always reminds me, read. Don't think umefika. Even if you reach at professor level, you probably know about 30%. So every time you read, discover something more. Let me ask you a question. What were you taught as the origin of democracy?
I was taught what I know is not.
Athens. If you read an author by the name Tikhine, write that down. Tikhine, he will point you to democracy as originating from Egypt. Cleithanian reforms, Egypt. Others will point you further, that Egypt copied political and institutional models from the ancient kingdom of Kush. That indeed even the pyramids, and the method of burial, the embalmment, were copied from the ancient kingdom of Kush. If you read further, you will be pointed beyond Kush. What am I saying? To Saw Metafadali. Thank you.
Thank you so much. You have a yes, intervention.
No, just to react to what Samantha said earlier on the civilizing mission, and I think it's critical that as you start your journey on TWAIL, or if you've just started, to at least read Anthony Angie, what I think should be the first book you read in international law, which is on imperialism, sovereignty, and the making of international law. And there he's able to explain just how the third world has been excluded even from the framework of sovereignty. It's really important to see where these notions of the dark continent came from and trying to view empire as if it was something that was good for us. Those kind of things are debunked in that book, and it's a really powerful statement. And also something he wrote very recently on rethinking international law at TWAIL retrospective. It's his latest article, and it sort of maps the journey of TWAIL right from what we call the TWAIL 1 scholars, the TWAIL 2 scholars. It's really an interesting read, and it gives a good foundation. And I really love what Godwin has said today, that their African voices are silenced and they're excluded. And this is not by mistake, it's by design, right? That is the way you are kept silent. Your voice actually matters. And what you find that in public international law, in the literature and in the pedagogy that is adopted, it centers the European voices. That is the issue, one of the issues that TWAIL addresses. So for me, I'd say those two readings are compulsory readings for the students in the room, and it's a good starting point to understand what this conversation is all about.
Okay, I think Abao has something to add as well, very quickly.
Mine is just to, again, respond about the issue which probably touches on phrases, language, the concept third world. To me, that's a very important concept to those who are concerned about a more just and more fair world, whether it's Africa, whether it is Asia. The term itself, certainly, I've not dug deep to, but it is certainly and has Eurocentricity. Must have come from, it has European origin, certainly. I don't need to research on that. But the term third world is about delineating, signposting, and bringing out how international law, its institutions have been have subjugated and exploited certain regions, and by doing that, there has been a lot of progress towards a more fair international system, whether it's economics, whether it is from a social perspective. Some of them, of course, even when we talk about now, there is even the aspect of the African approaches to international law. Now, if you look at the origins, all these began from realism. We're starting to question how the justice system and the law works. Then went to CLS, critical legal studies. Then from CLS, we had the likes of TWAIL, feminism, etc. Now, language becomes very, very important because the law as made is, and an interesting thing is, for instance, when Lugard came to Kenya, now what they called Kenya, again, we were given a name. What he did was, and Lugard was one of the most successful colonial administrators because he went and studied the people and acted as them. So he came and he knew, of course, when he arrived in Kikuyu, I think it is 1899, he asked for the chief of the area, and Waiyaki comes, and what does he do? They have a blood brotherhood. Is that a European concept? It is an African concept of covenant making. Pacta sunt servanda. So, but they are also the ones who break it anyway. He finds Lenana again, and again they have a similar covenant to show, I mean, these concepts were there with us. About democracy, among Kikuyu, I know how power was passed among Kikuyus. Kikuyus were democratic, there was no king. You would become a leader of your generation through what you achieve, through your own achievements. That's a form of democracy better than the monarchy, for instance. Now, where I'm saying this is, law uses language. And then we must then use that then to signpost and demonstrate those injustices, and especially in the international system. Thank you.
Wow, I think we could spend a lot of time listening to all the, I mean, there's a deep wealth, wealth of knowledge from all the panelists. But we must move on. I think you said we are finishing at 15:15. Yes. So we have less than 10 minutes.
Oh, we can finish at, we can go almost all the way down the hour.
You mean 30:30?
Yeah, but to be in the dining at that time.
Okay, okay. All right, we can quickly cover the next question, and that's to reflect on the institutional or environmental conditions that either facilitate or impede your ability to teach critically or research critically, basically to do the 12 work that Professor Ngugi talked about. So very quickly, again, just based on your experience. Yeah. And okay, we dare not go in order then. Anyone who has a thought that comes to mind right away. Professor Boya.
Okay. To the colleague from Ghana, the land of the black stars, and I hope they are not seeing stars, yeah? I'm pleased to inform you, actually I worked with Professor Njenga in the early 2000s, and also I didn't know of his great work in the law of the sea, and the UNCLOS and what he did. And he was a person who was very much down to earth, so you'd never know the work that he had done. So I don't know whether subsequently he published a book on international law. And I don't know whether that was his personal suppression or which factors led him not to write. And also he went to a university that was outside of Nairobi. So before you get to Professor Njenga, you would have passed the University of Nairobi. So in other words, that distance in itself was a problem. But he was a great guy. Now, coming back to question number 3 on the conditions. Yesterday, I met one of my master's supervisees who is writing on a right, and I would say which one because then you'd be able to know who this person is. And he had a section in his chapter talking about the evolution of right X. And when he started writing, he says this right started from some European authors. And I wanted to call Evans and ask Evans, what is going on here? Yeah? And he went on and on, paragraph after paragraph, these European authors, And then I asked him, but are there any local authors who have written? And he said, I've done research and I can't find them. So we did research with him. We got a couple of hits. Yeah. So the second example I want to give is you reminded me of jurisprudence. So I once taught jurisprudence, and of course it begins with all the legal positivism, and then the African scholars. It's a half a seminar. Okay. And I asked, can't we reverse it? And I was told that's the way it's done. Okay, so I left that course. I said, no. This will be, we will fight a lot. Yeah. The third example is a colleague who Dr. Musembi and I are supervising, and when we talk about their theoretical framework, is a PhD candidate. Yeah, and which frameworks do you want to use? And they go back to the positivists. Okay, and that seems to be the default. But when you start talking about local, Ubuntu, etc., they're taken aback. How does it actually fit in? Because what I was taught is these 3 or 4 theories. So it's a big struggle to actually change that mindset. So what have I done in my personal research? One of the things is, unlike Ogada, I've forgotten the Latin words. Ogada knows all of them. Ogada works throughout, by the way. At 2 in the morning, his WhatsApp is still on, yeah? You send him a message, he responds, and that's Ogada. Yeah, and he does a lot of... He's our colleague, yeah? So I know that he works. So I've forgotten all the Latin words because I also went to a school where they said, forget the Latin words, just tell us what the English equivalent is, yeah? So that's number 1. So Latin words out. The next thing is what Shako talked about, publishing. Of course, publishing in the big journals is not easy. Yeah, it's blood and tears. It's blood and tears throughout. And also you start from, I know one that, and Dr. Msebi helped me to make the choice. And when they accepted our article, we are 3, they asked us to send them about 150 sources. They wanted to look at them. And they said, just give us excerpts. So page 1 and then highlight that page. Yes. Another colleague of mine, his was worse because this was before the internet. They said all the sources. So you have 200 sources. They said photocopy them, put them in the mail and send them to us. We will pay for the mail, don't worry, okay? But we need to see them. So the default is issues about trust. That, you know, that saying that what good thing can come out of Bethlehem, yeah? So just replace Bethlehem with where you come from, yeah? So it's about that. And I understand. So what did we do? I had to go and get them. Some of the sources, I got them from the library. When I went back to the library, I couldn't find them because the book has walked. So I contacted, it's a 2006 edition. So I contacted the guy who wrote the book. He's a retired professor in the UK. And he asked me, why would the journal editor want to see it? And I told him, I'm used to it, so it's nothing new. But finally I got it, and I think the editors, because I managed to get about 80% of the publication. Others I just told them they're here, they're here, they're here. Yeah? So it is to hit those journals, I mean, it is just like Twail says, it is blood and tears, yeah? But you have to get there. For your work to be read, you really have to get there in terms of where you publish and what you write on, yeah? Something else that I do now consistently, and I mean, it's a project that I did with Justice Ngugi, is the reference to African scholars. And somebody talked about the Arab scholars. Actually, they're there. If you do good research, you will find them. And now I find it even easier to do research because you have Google Scholar. You don't have to go to the Haynes or whatever. Google Scholar for free, you can do 70% of your research from there. So I refer extensively to African-based scholars. Now, but there's a caveat that quite a number of us also publish in predatory journals. And so if you go to the pay to publish journals, I will not cite you. Just because it's a journal that you send your article today, and 3 days later, it's okay, and you pay $100. One even saw $1,000, and they said, Jesus Christ. So you pay $1,000 and it's published, yeah? So the more you go to the pay-to-publish journals, then there's a problem with that. But in terms of my African scholars, Arabs, you name it, it's all there, yeah? I also cite European authors, and I cite them to critique them. Yeah, because some of the things that are said are very, very general stuff. You know, Africa is one country. If it's about Kenya, it's a very generalized kind of system. We also talked about syllabus. I got into that problem as a young scholar. You want to cite Ryland versus Fletcher. You want to cite all the European cases, etc., because that is what was available. But now I hardly, in my course outline, I hardly use European scholars, apart from, critiquing, yeah? It is all African based because that is the system or the theory that we should push. I'm also glad, and that is work that I meet Ogada on the Zoom platforms in another forum that we are in, that today in Kenya, the insistence is on referring to local authorities. So many of our courts, in fact, they frown at you when you start referring to the European cases and they say, but you know, this thing was settled and we have a whole trail. When I was a young lawyer, it was all about the British cases. But now, I hardly would you refer. But why is that? It is because the local cases are accessible. Yeah, but still, the Ogada's work in the BBI, when they go comparative, they take you to Canada, they take you to the UK, and they take you to Israel, and then they take you to South Africa in a footnote. Okay? But I've read the submissions. Ogadas was actually in another world altogether. Yeah, but that is the default on how things are done. So and then there's a last one. Lastly, I'm doing also some work on alternative justice systems, and that just opened me up completely. So these things that you say, the right to fair hearing, you get it in the alternative justice system. Just what Judge was saying. If you're talking about the right to whatever it is, you will get it there. Yeah. And I was actually surprised that even the judiciary in Kenya has acknowledged that only 20% of the disputes in Kenya go to court. 80% are resolved in the alternative justice system regimes. That blew me, and I said, well, that then is where a lot of research needs to be invested in. So in terms of conditions, two conditions. There are conditions that we have imposed on ourselves simply because of your historical, but there's a lot of room to try and get yourself out of those conditions and to stop blaming what happened in the past. Thank you.
Okay. I won't belabor any point that Prof has mentioned, but I can mention 3 challenges. One is, I think, institutional acceptability. It's not that every university in Kenya will just happily embrace TWAIL. There's a fear that TWAIL is radical and is not within what is viewed as the traditional mode of teaching public international law. The language will not be that you should not use TWAIL. It will be that, due to the time constraints, let's stick to the syllabus, let's stick to, so there's that sense that you shouldn't veer too far from that which is the institution is used to. And it would be interesting to see like a very radical TWAIL just teaching even in where we are sitting. I'd like to see how that goes. And then secondly, there's the issue of access, and I think he's mentioned it, and just limited access to publications, to repositories, that yes, you want to cite this person, but maybe they're not, you don't know who's written in the area, you're not exposed to it, or it's under a paywall, so you want to access it, but you cannot afford to pay X in order to access that article. So that has also been a challenge. And I think as well, challenges in the units that are taught. I think even when we are all introducing ourselves, we say in Kenya you teach one for yourself and one for the dean. Yeah, there's that unit that you're always assigned that you have no idea where you're teaching, but here you are, and sometimes you just don't see how TWAIL necessarily applies to that. So that is also a challenge. I mean, I love what Prof. Joel said in the morning about even applying TWAIL to contracts, but it's easier said than done when you're teaching, like for me, labor law or whatever other course. But we're getting there, and I think those are some of the challenges I can mention. Anyone?
Three quick challenges that are met. Resources, Professor Abuya has mentioned this. For example, I have had the opportunity of dealing with refugee questions in this country. Usually I remember to go to Professor Abuya first. But beyond Professor Abuya, who else? Maybe Dr. Mutuma. But the resources to equip Professor Abuya to write more and to churn more are not there. The universities are hard-strapped. So, for example, we have a matter I'm dealing with on citizenship and nationality. We, through bias, the powers that be in the matter decided to go for Hathaway, Professor Hathaway, refugee law, as amicus, and not Professor Edwin Abuya. If Professor Abuya appears in court, he will be viewed with certain lenses. But when Professor Hathaway appears, even the process, the motion of convincing the court that this is a good amicus will be short. So resources, that problem. Regimented, indoctrinated minds. If I cite a local author in a certain area, it will be difficult for us to move from what we have been programmed, the robotics that we've been given. I was teaching, dealing with a treaty issue last week. When you want to introduce African and foreign concepts of treaty law, you cannot do that without reminding them of the base principles. Who have written about these base principles? The old white men. We are wired to think in a certain way. How do we get out of that? That's a problem. Culture. We have a culture in this country, particularly, that we don't read. I'm told that if you want to hide something in Kenya, hide it in a book. We don't read. So, for example, I have always the problem that in my classes, I will cite things in passing and tell people, go and read this, go and read this. When the exam returns come in, you look at the scripts and you ask yourself, God Almighty, was this one in my class? Because the person has gone and harvested verbatim what's on the internet and planted it there. Never mind the fact that you gave them the texts and you told them, go and get this book from Ogot. It's probably in the library or probably at Prestige Bookshop, Mamangina. But the good brother or good sister will rather buy a Muzinga 8,000 than buy or got a book. So, ladies and gentlemen, again, my refrain, let's read. Thank you.
I'd like to share some insights from the Kenyatta University. Number one, if you do not know how to access papers behind paywall, ask your students. They know. Number two, if the students cannot help you, I write an email to Florence. Florence, do you have this? Then I write to Emma, who is at Cambridge. I write to Jackie, who is at Harvard. I always access everything. But I think that the main predicament we are facing is the very idea of the university. It is not anymore, and I am talking about the University of Nairobi, the Kenyatta University, the Kabarak University. To what extent, but also many European universities, to what extent, because it's actually the malheur comes from there, the disease comes from there. Is it actually an institution of social transformation, which 12 scholars urge us to be? Is it? Or is it an institution modeled, number one, after the prison, as Foucault to convince us, after a Prussian school, and made to satisfy the neoliberal ideology? I will tell you one thing. I am getting official circulars from high offices telling me that I am delivering products to students who are my customers. What an impoverishment of education. For me, teaching is a lifelong commitment. For me, it is about personal relationship. I don't sell anything to anybody. So now, why I am saying this? 57 units we have to complete. 57 units, and we have make the students suitable for the labor market. By the way, for this labor market, which we are complaining about, that it is marred by corruption, tribalism, networking. So what should I teach them? To know, link up with a politician. What should I teach them? For me, to be suitable for a labor market. Rather than growing together, and find out how can we become agents of change. We are pushed towards churning out products, customers. Critical thinking requires time. Yeah? And there is no time. The system, the way it's set up with examination, cuts, audits. In June, I had 3 audits as a chair of department. 3 from different, institutions. The formalities, the structures are all meant, and this is why I say it's modeled after the prison, to discipline us to sell as much product, within a certain period of time. So how can we, we are discussing with Nona. Nona spends 16 hours a week in the class. Yeah? And she is a hero because she still finds time to do the research, to do 12. So how? I am put in the position of a beggar to expose students to different views. I am going around and begging, Florence, could you talk to my students? Isn't it? Yes. Yeah? Could you read through their memorandum? Could you? Yeah. All the time like that. Huh? So I think we must challenge, this is the main obstacle to 12 at the university. We must rethink the very idea of the university. Not anymore a Prussian school, not a prison, and not a tuck shop selling products to customers.
I want to be brief because of passage of time, but I don't want to be, again, in as much to be felt as if I'm repeating what Dr. Oganda has mentioned, and also has been emphasized by Thomas, about, because there's an approach I like using, seminar method, whereby at times even provide in advance reading materials and expect students to read in advance, and we have now a very, because whatever we are speaking about here, the 12 approach itself is about deconstruction, demystifying, questioning. So you expect now you'll come and have discussion with the students. But I have noted something which, again, I think is a cultural issue, which happened to us when we were students. We would read 2 weeks to exams, till I went out there and found, indeed, students do read ahead. So this continues. I mean, this is one of the limitations. Of course, before there were issues of materials because of resources of our universities. But now, as you have just been informed, our students are good, even beyond what is in the free commons, to go what is behind. But do they really read? Maybe I think they do that when probably they are assisting, because it is a big frustration. And I will give one example. Last semester I taught property law and conveyancing, and there's the new section of properties about transitioning to sectional properties. I told them, Mimi, that one, it is now what you are going to read. And I gave them a small write-up by an advocate who has explained, sent them. But I said, read that one, because I know how I'll know you don't. That is telling them it's going to be in the exam. 10 marks. I was very frustrated. Maybe we need a cultural change in terms of our interest in skills acquisition, knowledge acquisition, and especially from books, not the social media, which is neither here nor there, but specialized because we are lawyers. And we are being trained to be lawyers, then we become good social engineers through law.
Dr. Nyamo and I were thinking, because this idea is beginning to really heat up and go to some depth. We were curious to our colleagues who are teaching from other African universities in the global south or the north. What experiences do you have? Are there similarities? Are there any lessons learned as we wind up? Nona?
Thank you so much. Thank you to all the panelists. I think it was really, really great. I'm new to the academy, so it was just like picking so many tips here and there. I think for me what was important, because just how you've managed amidst all the challenges that we have raised, being able to include some of these things. I think for me the bigger challenge was raised by Dr. when he discussed the problem with a set curriculum. So by the time I enter, I already find a curriculum that was set. It has to be reviewed every 5 years. It already says what has to be taught. In TOTS, the curriculum is Rylands versus Fletcher. I can't do anything about it. We must go to Rylands and we must see how Rylands has evolved over time. It has not evolved in African legislation. It has evolved in UK courts. So sometimes, and before every class, I have to go and search. Okay, so Canada has done this and Australia has done this. But, I'm struggling to find, even when I look for Ugandan cases on the matter, they are repeating what that jurisprudence. So it almost makes no sense to even ask students to read some of these decisions. But it's also good to know that there's a network of academics that are trying, that are resisting. So for me, it's mostly just to thank you for sharing your experiences. It's very inspiring. I hope the next time we meet in, say, 2, 3, 5 years, we have much more to share. Thank you.
You said global south.
Or global north. I mean,
and we are still having that conversation about the right terminology, whether it's global south or third world. I was telling Godwin that it's funny how quite a number of those challenges are universal. Those challenges are universal. I teach climate change law, and it is a seminar across very few students. I got my students' ratings of instruction. Now, that's your students actually give you your scorecard after the semester. They grade you after the semester. And one of the comments, not two, of my students said, I get irate when they've not prepared for class. Of course I get irate. That is a good comment. In fact, in my next application, I will quote it. I get irate when you've not prepared for class. I will quote you, good professor. Read, but what should we read? And I think we've done the list, and he was telling me, because we had a short debate here, that the concept of TWIL and embedding TWIL into various courses, I was telling him that depending on the kind of course, it differs. The level of difficulty of integration actually differs. And then he went and said, no, that's, for example, contracts. Then he dug out this 1961 text by Theo Elias on the making of contracts.
So it was about the international law, and when we're talking about the making of treaties. But Theo Elias had written about this in the 70s. The new issue he had with, I think, one of the Former General, I think, IGBD, or I don't know his name quite well, but they had a second issue, and part of that covers how treaty making was happening in the pre-colonial era. At the very least, it gives us an indication. That book is available. The material is available. I think that we need to also put in some industry as teachers and scholars. Because if you're going to help these people, what are we going to do? As I said, Theo Elias' book is nearly 40 years plus. So it's available. So rather than saying that, oh, it's difficult, just get the book and read a few pages of it and see how you can tweak that into the introductory part of your PIL class on treaty making. That feeds into other discussions on sovereignty, because I remember this young man on the other side spoke about Islamic law. People are still writing on it. Recently I picked up Fatih Masood's Islamic law and I think Somali politics, and he's been writing, and others have written. I think there's another one, Khalil El, who's written on Islamic law and international law. So there are things out there. We can't answer all those questions in one cycle of the year, but if you can just tweak one topic for this year, By the time you run it by 6 years, you might have reformed the curriculum. And of course, if you're going to be radical, sometimes you don't have to tell our deans everything. You don't have to go tell your dean that, I want to include this in my... You can say it in passing in class. And students will pick it up. But if you want to say, oh, I want to add this to the curriculum. No, if I'm teaching 12 aspects of things in my school in Canada, I do it. It's a very conservative province. I was telling my colleagues about it. I don't have to flag it as 12. I'm teaching students about the evolution of the UN Global Compact, UNGPs, and then I send them materials to look at the Kissinger and Allende debate from the 72 UNCTAD. Then I come to class. We are engaged in a debate, a discussion. Of course, they like market economics, free market, but then at least they've read Allende. So the discussion can go on, whether they still support that or not. Somebody's working out, at least having encountered Allende for the first time. So I'm not going to tell my dean I want to let my students read Allende. Why would I do that? I won't do it. So as scholars, we also need to put in some industry. That's what I'm trying to say, that it can be very easy to say, oh, it's difficult. I don't think it's ever difficult. Prof talked about baby M. Contract law, he didn't talk about 12 to his students, but he got them to think critically. I mean, that's the broad template that we are trying to, organize around. So I think that's how I want to approach issues and to share with our colleagues. Thank you.
Thank you. I won't ask anyone of the students to say who Allende was. Go research, and it's A-L-L-E-N-D-E. Okay, not A-Y-E, as we want to assume as Africans. Okay, we have to close. But Florence had made a plea for each person to say just for 1 minute on the last question, what you see as the next frontier of 12. I think Justice Ngugi gave us a lot to think about, but literally 1 minute, if not 30 seconds. Okay. And I know I'm breaching the protocol, but please, go on.
30 seconds. My boss has spoken, 30 seconds. We have to use the existing tools to transform our thinking. Article 31, for example, of the Vienna Convention, the law of treaties, that's a very rich tool for us to transform international law in terms of molding it with a global south interpretation, and also use the reservations and the interpretive declarations to inform the character of international law. That's where to start. Thank you.
I'm still...
Okay, so I would say that we need to break the barriers between, what academia, activism, social struggles, social movements, theorizing. We have to, essentially, TWAIL needs to speak to also what social movements, the work that social movements are doing. So if you think about the recently concluded climate summit, what the dominant narrative about the outcome of that summit is versus alternative voices. So I think that's the first thing, breaking those barriers, transdisciplinary learning, which again, one of the functions of the neoliberal university has been keeping disciplines and knowledge in silos so that we don't speak to political scientists as lawyers, we don't get enriched by other perspectives, anthropological, sociological, etc. So that needs to change. I think there's work, for instance, that's been done around by Professor Babatunde Fagbaibo around what is the role of music in interpreting international law, and he does this from a sort of broader African perspective. But so I think in the future should also to be localized TWAIL, so from the African to the local, and say what does the evolution of Kenyan music, for instance, speak to TWAIL, to issues of law, concepts of law. So essentially stepping outside of the law in order to enrich the law. Yeah.
Yes, I would like to just to echo that. So it's not just about teaching TWAIL, but it's also for TWAIL to learn, which basically means to go outside of the university, to talk to the people. Thank you for this. Actually, I want to echo what you have just said. There's so much we can learn from the civil society, from their struggle for indigenous rights, for rights of those marginalized, of those voices. And they are not They are not victims, they are fighters. Yeah? There are so many fighters out there. My personal experience, just very briefly, is, I see Emily was also there, Turkana. Yeah, my engagement with friends of Lake Turkana, for example, I must admit there's always this thinking that a formalized structure of county administration of the national government are those enlightened ones. Yeah? While the clans and the traditional structures are those who needs to be enlightened. Yeah? This thinking. So I think that is, as much as we know that it is not true, yeah? As much as it is a claim of it, way that this is not true, that we should unlearn that, actually going there and seeing that it is actually other way around, yeah, is that. But it was for me actually a very, very forming experience. So TWAIL is also about.
Thank you. I was going to say your minute is up.
Only 30 seconds. Just 2 points. One, a lot of work has been done on TWAIL already, so I don't think you have to feel like you have to introduce TWAIL or map out TWAIL all over again. That work has been done. Think of it as a methodology, as a lens, and think about issues that you could highlight in your work. You don't have to justify TWAIL anymore. It's there and it's real and it exists and it's powerful as a movement. And secondly, just when you find like-minded people, stick together. We call it solidarity in international law, and that's what you need to do to grow in TWAIL.
Just a question to the students. Did any of you take human rights with me? Yes. Okay. Tom, they actually read, eh? And she will tell you she read all the 100 articles that we had in that course. Oh, there are 2,000 pages. Okay. Okay. They did, and all of them read. So I have no worry about that.
But Prof, when we taught theories and foundations of human rights to LLM students, how come you didn't make them read?
Oh, these were undergrads.
That was difficult. Difficult. Getting them to read, it's a big frustration.
So they say mambo ni mangapi? Matatu. So for the students, research, research, research. Thank you.
Sorry, Kabau. Thank you for saving us the time, Kabau. I think we have offended the catering department. We had better just make our way there very quickly. Yeah.
Yeah, just thank you. Let's continue the conversation.
So let's try to be back here at 2:15-ish, so that we can learn more. So please hurry up so I can go, so that we have much more in the afternoon.
Working a bit. I have a bit of cold, so I hope you can hear me. And I'll just try to be as loud as possible. And perhaps we could make this an interactive session so I don't have to do a lot of the talking. As Professor Gathi has said, my name is Titi Adebola, and I'm a lecturer at the University of Aberdeen in Scotland. And so it's lovely to see us all here today. Perhaps I could start by asking how many of us are familiar with intellectual property rights? So how many of us have studied intellectual property rights? Okay. So we just have a few people that have studied intellectual property rights, and I will start from the beginning. So what are intellectual property rights? Intellectual property rights are mainly property state-granted rights given to creators and inventors for the creations of their minds. So if you create a new, let's say you write a story, if you write a novel, if you write a play, if you have a music video, if you have computer programs, medicines, you could have intellectual property rights protection for that. And please feel free to ask me questions at any point. Intellectual property rights grant the creators or inventors exclusive rights over the use of their creations and inventions for a certain duration. And we could divide it into two broad categories. We have copyright and allied rights, and we have industrial property. Industrial property covers things like patents, industrial designs, trademarks, geographical indications, and trade secrets. So in Kenya, for example, you have Coffee Kenya as a geographical indication. You could have trademarks for logos, so many of the products that we have trademarks on them. You could have patents for many of the inventions in our mobile phones, in our laptops, medicines as well, which is one of the topical areas of patents, pharmaceutical patents that came to the fore during the COVID-19 pandemic. We had lots of conversations about that. So you could have patents for that. And sui generis rights are simply or literally rights of their own, right, of its own kind, so they could be unique or special rights. And one example of those rights is plant variety protection, and that will be the focus of our conversation today. But before we go into that, I'll introduce us to the international intellectual property architecture. Now, many of us would be aware that before, like in the past, intellectual property rights were mainly alien to African societies in the colonial era, right? So when we had in Africa, and then when we had colonial administrations come into the different countries on the continent, they extended their intellectual property rights to us. And we had different regimes or different systems in Anglophone Africa and Francophone Africa. But we're not going to go into that. Let's start from when we started having a proliferation of intellectual property rights on the continent. And we can trace that to, or we could start from post-independence. So the intellectual property rights architecture, we could divide the institutions into two main institutions. So the World Intellectual Property Organization, WIPO, and the World Trade Organization that has an agreement. So the Agreement on Trade-Related Aspects of Intellectual Property Rights, the TRIPS Agreement. Both organizations are based in Geneva. So you have WIPO, World Intellectual Property Organization, and you have WTO, which has the TRIPS agreement, and it's also based in Geneva. WIPO administers about 26 treaties on intellectual property rights, but WTO has the Agreement on Trade-Related Aspects of Intellectual Property Rights, the TRIPS agreement. Now, you might ask, why do we have two international institutions governing one subject matter? One of the reasons why we have that was, while many of the global north countries were actively involved in building the intellectual property rights regimes in the WIPO, they felt that intellectual property rights did not have strong enforcement mechanisms, and so there was the forum shift or the regime shift to the WTO. Now, the WTO is an enforcement-backed institution, although we know the crown jewel of the WTO, the dispute settlement unit, is in disarray at the moment. But actually, that was one of the reasons for the shift to the WTO. So one difference is, although WIPO has treaties that govern intellectual property rights doesn't have strong enforcement mechanism, but WTO, on the other hand, has a strong enforcement mechanism. And one question for us to ask here would be also, who are the interests, how are the institutions governed or administered, and also how are the treaties constructed? The WTO, I'll just give us a brief background to the TRIPS agreement. So in the discussions, TRIPS actually was one of the later instruments that was included in the WTO set of agreements. So the WTO is a single undertaking. That means that once you join the WTO, you're obliged to follow all of the agreements, or to adhere, fulfill obligations under all of the agreements in the WTO. Now, we had the TRIPS agreement that was added much later on in the WTO. Now, whose interests were pushed there? In fact, it was primarily or predominantly the United States. So we saw multilateral companies in the United States that were interested in expanding their businesses beyond the States, but they were concerned about enforcement. So if I'm going to open my offices in Kenya, for example, or in India or Brazil, how am I going to be sure that I can have this strong type of enforcement that I would like? And that was why there was that shift to the WTO. And in discussing the agreements, we had lots of contestations and debates, and many of the provisions that made it into the TRIPS agreement were delicate compromises. Now, one provision that I will focus on is Article 27.3b of the TRIPS agreement. Article 27.3b of TRIPS agreement makes an obligation for all member states of the WTO to protect plant varieties. That article says that they could protect plant varieties through a patent system, through a sui generis system, or through a combination of systems. Now, the reason why we had that provision was actually because there was there were some tensions between some of the key actors in the construction of the provision. So we had the US, for example, we had the US, for example, that had patent systems, and they also had plant breeders' rights systems in existence. And then we had the EU that had plant breeders' rights systems. So they had a special system. The EU said no to patents for plant varieties. The US said, you know what, Diamond versus Chakrabarti, anything under the sun is patentable. Let's go all the way out and protect plant varieties through the strongest means of protection, so through patents or plant breeders' rights and sui generis system. But the EU was against patenting plant varieties, and so the delicate compromise was to have this option, so you could protect it through a patent system, a sui generis system, or a combination of systems. Now, that provision has a clause that says that it will be revised 5 years after it enters into force. TRIPS entered into force on 1st of January 1995, and it has not been revised to date. Now, there were questions around the definition of revision. Are we considering the implementation of the provision, or are we substantially revising the wording? Now, the Global South, or third world countries, come into this picture as well, because while there were those contestations amongst the EU and the US, like Tom mentioned in the earlier plenary, he said that there was also countries or jurisdictions that were resisting or pushing back. Now, we had Africa as a group, so the African group. We had India, we had Thailand as examples of countries that said, actually, while you're saying options are having a patent system or a plant breeders' rights system, we also want to have alternatives. We want to have farmers' rights systems. So we recognize that farmers are breeders, and farmers are invested in the creation of new varieties, or even in the conservation of new plant varieties, and these farmers should be recognized. So while the WIPO and the WTO did not provide platforms or forums for the introduction of these alternative legal norms and principles, there was then the shift to an alternative forum, the FAO, the Food and Agriculture Organization, under the United Nations, where the Global South actors were able to converge to push certain provisions. So under the FAO, we had the introduction of the International Treaty on Plant Genetic Resources for Food and Agriculture, the ITP-JRFA. And under the ITP-JRFA, we have Article 9 that provides for farmers' rights. So you can begin to see that we're having sort of a complex regime where we have different institutions, different agreements that are covering one subject matter. Now, it doesn't end there. Even before the ITP-JRFA entered into force, we had the Convention on Biological Diversity. There, the argument was that actually plant varieties, when you want to develop a new variety of plant, you are sourcing the base genetic resources from a certain source. Now, that source, we should recognize that source, and we should also have some reward systems for the source. So let's have, before we can access, let's say, a new variety of rice, let's ask for permission. So that's called prior informed consent. And when we ask for permission, let's have an access and benefit sharing framework. So that means that if those varieties are then going to be protected through patent or plant breeders' rights systems, the source communities of farmers where the base genetic resources are sourced from should be accorded some types of benefits. So you have the access and benefit sharing framework under the Convention on Biological Diversity. So we have WIPO having general provisions on intellectual property. It doesn't cover plant variety protection specifically. We have WTO that has an obligation for all members to protect plant varieties under Article 27.3b. It doesn't prescribe. It gives you the latitude and the flexibility to introduce any system that you want. Then you have the FAO, International Treaty on Plant Genetic Resources, Article 9, that provides for farmers' rights. And then you have the CBD, Convention on Biological Diversity, that provides for access and benefit sharing. Now, the difference amongst these institutions and these agreements is that the WTO perhaps is the one that has enforcement, right? It doesn't have it doesn't give you an option. So that means that if there is going to be, if you default, for example, in the introduction of certain plant variety protection systems, then you can be taken to the dispute settlement body for, to institute an action. But the ITP-JRFA that provides for farmers' rights, it leaves the interpretation of what farmers' rights would mean to the member states. So members can decide how they want to interpret farmers' rights. So some of the contestations or some of the questions that we have had is, what is farmers' rights? First of all, the ITP-JRFA in Article 9 says it recognizes that local and indigenous communities and farmers have made and will continue to contribute to the conservation and development of genetic resources. It says that they should have the protection of traditional knowledge. The farmers should have the right to equitably participate in sharing of benefits. Farmers should participate in making decisions, and farmers have the right to save, to use, to exchange, and sell farm-safe seeds. But it leaves all of that interpretation to member states. So however you want to interpret it at the national level, do that. We're not going to prescribe. We're not going to set you an example. That's on the one hand. Now, on the other hand, you have plant breeders' rights. Remember, I said that was one of the examples of protection mechanisms you have. You have a specialized international institution, so the complexity is growing. So you have the International Convention on the Protection of New Varieties of Plants, UPOV. UPOV sets out an just explicit interpretation of what plant breeders' rights mean. So it says that for you to protect plant breeders' rights, you have to have distinct, the varieties have to be distinct, they have to be uniform, they have to be stable. Now, the UPOV officials and UPOV sort of supporters are actively involved in pushing or coercing countries to join UPOV. And some of us might think about the implications of this. So what will happen when we have distinct, uniform, and stable varieties? So we have monocultures, for example. How would that affect the land? How would that affect the soils? What would be the impact? We've had conversations around climate change. What would be the impact on sustainability of agricultural systems and planting? Now, many of the arguments are that, first of all, for you to have distinct, uniform, and stable varieties, they go against the sustainable principles of farming. So you have to think about the inputs that you're including in your planting. So many times it is agricultural inputs, that so lots of fertilizer. You're going away from the type of traditional agricultural systems that you have that are based on agroecology, right? Where you have mixed farming systems, where you have potatoes or tomatoes that don't all have to look distinct and uniform, but they are nutritious and they are, healthy and, perhaps safer to consume. So you have the UPOV system, and many of the resistance to UPOV are the implications on, first of all, the environment and also on the farmers. Right? So if you have a provision or a system that provides for only distinct, uniform, and stable varieties, in Africa, for example, we have countries where we have a large population of small-scale farmers, let's say 80% of small-scale farmers, depending on which crop and which country. Their varieties are not going to be able to meet the distinct, uniform, and stable varieties, right? So you can imagine mixed cropping of tomatoes on a land. You're not going to meet those varieties. First of all, you are using local varieties, so you will not meet those standards. So that means that the plant breeders' rights system is marginalizing or excluding those small-scale farmers that are the predominant producers of food in many of the communities in Africa. So that's one reason or one rationale for the resistance. Another is that the UPOV provision sets out its conditions for protection, and it also includes a provision that says no other clause or no other provision can be included in the plant breeders' rights system. So it is only what has been prescribed or set out by UPOV. This means that provisions that global south countries, African countries, Brazil, India, and other global south countries have pushed for, like farmers' rights, cannot be included in a UPOV-styled plant breeders' rights system. So UPOV has the template that only provides for plant breeders' rights, but it doesn't provide for farmers' rights. It doesn't provide for access and benefit sharing. So who is going to benefit from a plant breeders' rights system under UPOV? It's going to be mainly the multinational agrochemicals, right? Agrochemical companies. And then we are now seeing the proliferation of those companies around Africa. And that has to do with many of our seed laws. So we had reforms of many of our seed laws. And then many of them are privately sort of driven interest in pushing for profit over sustainability or over agroecological mechanisms that protect the interest of farmers. So remember that some of the questions that we ask from a TWIL lens is who benefits from this provision. So plant breeders' rights system, you're benefiting the multinational, the agribusinesses. Who benefits from farmers' rights system? It's the small-scale farmers. Who benefits from access and benefit sharing? It's the local communities. So you have a tension or polarization of two distinct systems. Now, on the one hand, remember I said that the UPOV plant breeders' rights system has set out its own definition of plant breeders' rights, but the International Treaty on Plant Genetic Resources leaves it to the member states. It sets out the broad understanding of farmers' rights, but it leaves it to the member states to interpret. Now, because plant breeders' rights and farmers' rights are esoteric, many of the member states do not know how to couch their farmers' rights provision. And this has been one of the perennial questions that we've had in interpretation. Now, to go back to the discussion around the lawmaking at that time, so TRIPS entered into force in 1995. We had the Convention on Biological Diversity. We had the ITP-JRFA. I remember that we said that TRIPS was, the Article 27.3b of TRIPS was going to be revised in 5 years. Now, African countries said, actually, we have a solution. We are going to give you a template. That template is going to be a sui generis system. Remember, we said sui generis means literally of its own kind, a unique or a special system. So we are going to have our own system. And in that system, we are going to protect plant breeders' rights, we are going to protect farmers' rights, and we are also going to have access and benefit sharing. Now, that system was couched under the African Model Law on the protection of local varieties, farmers, and breeders. So we have the African Model Law 2000 as a living testament of the ingenuity, the creativity, and the innovation of African stakeholders in constructing our own definition of what a comprehensive sui generis plant variety protection system means. Now, one of the main protagonists of the African model law is Professor Ekpere, and you see that in one of your readings. Professor Ekpere, he was working with the OAU, now the African Union, and he set out that law as a living guide to show how African countries can translate their ideas around a comprehensive sui generis system into action. But that law is a guide. We have no African country that has implemented the law. On the other hand, we have a proliferation of UPOV plant breeders' rights in Africa. And this has been driven by commercial interests, by funding, capital, and the interest in investment on the continent by multinational corporations. Now, the question you might have is, so what is happening with farmers' rights? What do we do in interpreting farmers' rights? And how can we protect the small-scale farmers that are providing the food for us on the continent? The ITPGRFA Secretariat has been attempting to work on that, but there's been lots of resistance. So they had the inventory on examples of farmers' rights, and they have another document on views and experiences on farmers' rights. But those are all guides, and countries can choose how they want to interpret farmers' rights based on the guidelines that have been provided. So one of the questions then that we might have is what should the response of African countries be in introducing their own plant variety protection systems? You have a UPOV system that is providing support in introduction of laws, but you have an ITPGRFA Secretariat that has limited resources in supporting countries in introducing farmers' rights. So one of the arguments I would make is that Africa must take ownership of its plant variety protection lawmaking, designing and introducing effective, inclusive, and equitable sui generis plant variety protection systems will cater to the interests of small-scale farmers that we have on the continent. Now, Ghana is one example of a country that was resisting the introduction of UPOV when they were going to pass a plant breeders' rights system that was basically focused on UPOV. We had a case that went to court, but we see that the plant breeders' rights system was still introduced. Kenya was one example of a country that actually had introduced its own UPOV-based plant breeders' rights much earlier on because of the interest in the horticulture industry that we had from foreign interests even before TRIPS entered into force. Now, many of the other countries that introduced plant breeders' rights systems under UPOV introduced it due to bilateral trade agreements. So we had bilateral trade agreements that we call them TRIPS plus agreement. So while TRIPS gives you a latitude and flexibility, you might have a bilateral agreement that mandates you to introduce a UPOV plant breeders' rights system. So that is where we are now with regards to the lawmaking provisions. Africa, here I would argue, should lead in the formulation of farmers' rights laws as set out in the International Treaty on Plant Genetic Resources and the Convention on Biological Diversity. Now, one of the limitations, like I said, is internal funding. So to avoid dependence on external support and influences in domestic lawmaking, Africa must invest in itself to sustainably fund its growth and on its own term. To decrease the transplantation of laws unsuitable for African contexts and realities, Africa must close the knowledge gap on plant variety protection and related subjects. This could be achieved by education. So all of what we are doing now, when I'm teaching intellectual property rights, I introduce students to plant variety protection as one of the important categories of intellectual property rights for Africa. So through education, capacity building, collaboration, South-South collaborations, and knowledge sharing. Now, to limit agreements and economic partnerships that mandate the introduction of unsuitable plant breeders' rights systems, African countries must thoroughly assess the terms of proposed agreements and make informed decisions before concluding. Also, we should strengthen national laws to protect the needs and the interests of different actors, including small-scale farmers, breeders, and communities. And we should enhance regional cooperation and collaboration. The AfCFTA provides a platform for us to rethink intellectual property rights because it has an intellectual property rights protocol. So the AfCFTA is the African Continental Free Trade Area. And then we should foster South-South cooperation and exchanges. So that would be sort of my broad introduction to plant variety protection to us. Apologies for my voice. I hope that you sort of understood, and I look forward to questions.
Okay, so let's give her a round of applause, even with a cold. Okay, so in my view, Dr. Debola is the leading expert on IP, in particular in the way it centers Africa and the way it decenters the interests of multinationals. So we have 15 minutes. So we're going to take a round of questions. Is that okay? Because then we have to go to the next session, which is going to be 40 minutes. Okay, and there are going to be materials distributed. We are making Elvira work very hard. So don't worry. Everything she has said will be distributed. You're going to have access to materials. No questions? You've been convinced? Umefika? Ulikuwa wapi?
Quick, Daktari. Sure. Just straight to the point. On decolonizing the teaching of intellectual property law, what will you recommend for Kenyan law schools?
You have set a good precedent. You have set a good precedent for a good question. Hey, the lunch has not settled. There are no questions, comments? No. Your brother already dissented you in the morning. Okada, you teach IP. I'm coming to you. I'm sorry. You were talking about interesting questions about, I don't know, stuff. Now it's IP.
Thank you. IP rights, property rights, center around the Lockean philosophy, the property notion in the West. How do I, for example, re-tinker with the conceptual thinking of property to incorporate African notions drawn from, for example, Ubuntu, and make that linkage with intellectual property?
Okay, you know, you had Dr. Debola mention somebody called Dr. Ekpere. If you leave this room without knowing who Dr. Ekpere is, that's a sin. The mortal sin.
Great. Thanks, Bob. And thanks, Titi, for an excellent presentation. Again, we're having this situation which is becoming emblematic, where you have several regimes, and there should be a way in which we can urge our states about the need to use the model law. And I was wondering whether, based on just jurisdictions in the rec courts or with some kind of link to the African Charter, whether there is a line by which, strategic litigation could be brought to force to the fore that there is a model law that is passed by the AU and that it should take some kind of precedence.
Okay. Does somebody have a question about creative industries? Because she's also an expert on creative industries. For example, maybe she'll tell us about why Changa. Let's talk about Changa. So it's the Ogogoro of this jurisdiction.
Okay, thank you. Thank you so much for the questions. So I'll take them in turn. Decolonizing teaching of intellectual property rights. I would say that in thinking about decolonizing teaching of intellectual property rights in Kenyan law schools or in African law schools, let's think about what types of intellectual property rights are actually beneficial to us in Africa, what are our strengths in intellectual property rights? For me, I think some of our strengths in intellectual property rights in Africa include plant variety protection. In thinking about plant variety protection, we teach our students farmers' rights as a type of intellectual property rights. Now, this is not taught in mainstream intellectual property. Mainstream intellectual property will cover copyright, patent, and trademarks, industrial designs mainly. But in thinking about intellectual property rights as creations of the mind, what type of creations of the mind do we have prevalent in Africa? We have plant right. We have new varieties of plants, right? We have plant variety protection. We have traditional knowledge in relation to plant varieties. We have traditional cultural expressions. So, for example, many of our artworks, many of our artifacts, many of our paintings can be protected as traditional cultural expressions. TK and traditional knowledge and traditional cultural expressions are not protected under either WIPO or WTO. So there's this hypocrisy in intellectual property rights to say that traditional knowledge and traditional cultural expressions are not categories of intellectual property rights, that the orthodoxies of intellectual property rights do not extend or permit the protection of traditional knowledge and traditional cultural expressions. So there has been debates at the WIPO. So we have the WIPO Intergovernmental Committee for over 1 decade now discussing the introduction of a new international treaty, and that debate has stalled for years from about 2000 till date, so over 2 decades actually, and we don't have a system, we don't have a TK system yet. However, now with the discussions around artificial intelligence, we are having conversations at the same WIPO to think about how we can extend the orthodoxy of intellectual property to protect artificial intelligence and new technologies. However, the TK, traditional knowledge and traditional cultural expressions, that has been pushed for by the Global South for over 2 decades, they say that we cannot have protection. So we're having sort of a slow compromise in that regard. So it shows that if there are types of creations and innovations that are driven by global north companies, we can think about how to revise our intellectual property structures to have protection. But if we have from global south countries, we say that doesn't qualify as intellectual property. So in teaching and decolonizing intellectual property, let's think about the types of innovation and creativity that we have on the continent. So plant rights protection is one example. Geographical indications is another. So we have Scotch whiskey, for example, in Scotland where I live. But in Kenya, it's called Changai. Or Moratina. In Nigeria, it's called Ogogoro. In Ghana, it's called Apetisse, right? During the colonial era, it was banned and tagged illegal gin, so that we have foreign alcoholic drinks imported into our countries, and they are protected mainly as geographical indications or other types of intellectual property rights. So in thinking about intellectual property, let's think about branding and trademarks and how that can benefit our own type of innovation and creativity, right? So also in thinking about things like copyright, what are the types of products or creative works that we can have protection for? In many parts of Africa, we have traditional textiles that we can have protection. This is called Adire in Nigeria, and this is called Ashoke. We can have protection for those as creative works, but they are not usually recognized in mainstream intellectual property rights. So in thinking about a dual approach to intellectual property rights or decolonizing intellectual property rights, for me, I'll start from the types of innovations and creations that we have in Africa. And then let's think about reforming our intellectual property architecture to have protection for those types of innovations and creations, rather than starting from the mainstream or streamlined categories of intellectual property rights that would benefit the global north. So, for example, many times when you have intellectual property rights systems in many African countries, you see that the main companies or actors that register this IP are foreign companies. So what type of intellectual property rights will benefit our own local producers? So that's where I'll start from. And then I'll think about the orthodoxies of intellectual property, so the rules that govern intellectual property. Let's think about how we can also begin to think about the theoretical justifications for intellectual property and rethink it from an African perspective. Africans are innovative, Africans are creative. If we don't meet the type of conditions for protection that have been set down in certain international treaties, let us create our own conditions for protection. So that's how I'll decolonize it. Now, thinking about the conceptual justifications for intellectual property, Ubuntu, community intellectual property. We have community rights for farmers, right? Many times when farmers are developing new varieties, when you have one great variety of cassava, for example, you exchange it with your neighbor. You tell your neighbor, I had a good harvest. See what I planted. Can you, do you want to have some? If you help me harvest my plant, I'll give you some seeds. I'll give you some plant varieties. We can have community rights. And that was one of the examples of rights that Professor Ekpere recommended in the African Model Law. So there we can think about the African philosophies and say that actually, rather than focusing on individualistic, private rights, we can actually have community rights of protection. We can do that for traditional knowledge. We can do that for traditional cultural expressions. So IP rights don't have to be this exclusive, private-driven rights. We can also have community rights that will benefit other constituencies or stakeholders. And also we could have things like access and benefit sharing that I've mentioned that would benefit other members of the community. So I think that we can rethink our philosophies of intellectual property rights in that regard. How do we urge our states? I think first of all, we should think about how to sort of disseminate information about intellectual property. I think there is a gap in knowledge in intellectual property rights, and many of our government officials do not understand the different categories of intellectual property rights that we have. And that has sort of limited types of negotiations that we have. Now, intellectual property rights are a combination of a variety of innovations and creations. And the external influences that are interested in intellectual property rights often go through different institutions. So let's take plant variety protection as an example. If an external, so for example, if UPOV, for example, is trying to push a country to introduce a plant variety protection system like it did in Nigeria, when it came through the Intellectual Property Office of the Commercial Law Division of the Ministry of Industry, Trade and Investment, the intellectual property plant right protection law was not passed through that because there were some debates around that. It went to the Ministry of Agriculture and introduced it through the National Seed Council. So you can go through different sort of government agencies in introducing intellectual property rights. So I think that we should have some sort of synergies in our national intellectual property rights to ensure that we have one voice with regard to our position on intellectual property rights. Now, I said that as one example. Another example is the bilateral agreements that we have and the free trade agreements. So countries like Tanzania, for example, Morocco, they introduced certain types of revisions to their intellectual property rights through economic partnership agreements and through bilateral agreements. So if a country wants other benefits, just like the WTO, one of the teasers was, come and join agreement on agriculture, you have a benefit. If you sign that up, then you also have to sign up to our TRIPS agreement. So what African countries can do is to have common positions on intellectual property rights and enforce those provisions. Now the AfCFTA intellectual property protocol can provide that common position for Africa. But the question is, are we going to use that platform to redefine what intellectual property means to Africa? So that will be my answer to that. In terms of thinking about how to enforce it strictly, I think that it's going to have to be at the national levels. So who are the stakeholders, the academics, who are the civil society organizations, who are the activists that are going to be watching the type of intellectual property revisions that we have on the continent? Many times the laws are shrouded in silence. the revisions to the laws as shrouded in when Nigeria was going to pass its plant right protection law. We didn't have a law of, we had one HOMEF that brought and instituted an action in court. When India was going to pass its plant rights protection law, we had farmers lining up on the streets of Delhi protesting. Even though they didn't fully understand what the revisions were, they knew that, okay, these people want to take our seeds and we're going to resist that. So India has a strong civil society activist body that are protecting the interests of the small-scale farmers. And I think that that is where we all should be interested in promoting our own types of intellectual property architecture through the academy, through activists, and through civil society organizations.
We will have a break after tea because we are really pressed for time. Dr. Debola, you have done really well. What you have done is what we'd say in Kenya is kionjo. It's not the whole thing. So we have, unfortunately, to move on to the next session for another 40 minutes so we can have the session on international investment law. So please join me again in thanking Dr. Debola. So coming around is the abstract of an article in the first issue of the African Journal, pass this around, of the African Journal of International Economic Law, mapping Africa's complex regimes towards an African-centered AFCFTA intellectual property protocol. Dr. Debola was one of the experts who did the zero draft of the AFCFTA intellectual property protocol. So that article is freely available on the AfronomicsLaw blog. You just go to the African Journal of International Economic Law. It's pages, issue 1 of the African Journal of International Law, pages 233 to 290. So that's just the abstract to give you context that there's more material that is available. I have 2 troublemakers. I've never met these guys. I don't know who they are. I'm just telling you, be prepared for trouble. Dr. Harrison Bori, he calls himself these days, and my co-editor, Professor Olabisi Akinkube, the Emperor.
So this session, we're going to be brief and quick. It will be led by my friend and brother, Harrison. Over to you.
Thank you very much. We're going to do a primer, at least whet your appetite on what is critical international investment law. Apart from a few people who I'm sure have sat in an international investment law class and some who have even taught the class, I don't see Prof. Milej here. But I'm going to do sort of context, a bit of context setting. Try to do it in at most 12 minutes of this primer so that we see what we are trying to talk about from a very critical angle. The first thing is just to say that international investment law is a sub-branch of, general public international law with certain kinds of specialities. I know that it's not been offered, at least in most of our African law schools, as a specific course. At best, it might be an elective course. So knowledge in public international law is very important in terms of understanding it. But its origins are very much within colonial origins of understanding how the law operates. At least within in our part of the world, especially the Anglophone Africa colonized by the Britons, the idea was from the early colonial times that a person who was subject of the crown moved with the law of the crown. And it didn't matter where they went. And when they came in this part of the world, they assumed that there was no law. In this part of the world, the idea of law as the white colonial government knew did not exist because anyway the white man was moving with the law of the crown wherever they went. So what happened is that if you came in this part of the world and you had a problem, say a tort as you know it in law, the law that would apply to you if you are a British citizen will not be anything that is called law here because they thought and they said that it didn't exist. Many of us know that is a huge myth. But if we push into the late 19th century and early 20th century, the origin of international investment law for some critical international investment law scholar like Emson Araja, whom I encourage you to check out his work. He says that at least in Latin America and the United Kingdom, we see an interesting meeting of the origins of international investment law as we know it, especially with US-Mexico mixed claim tribunals, and it comes out of a revolution. So what happened in the late 19th century in Mexico, there were a couple of revolutions that caused real problems for especially US citizens who were running their businesses in Mexico. The most famous case is called the Nia case, which is actually a murder case. You know, someone was actually killed as part of this revolution, and the estate of this person wanted to make claims that are related to what the loss that was suffered, including loss of life. And a huge exchange begins here that is at the core of international investment law. How do you protect a foreign national in a foreign land that claims to have full sovereignty and has full laws within that country? There was this idea that Mexico under a revolution had the law in Mexico was so bad that the standard of customary international law, which according to scholars at this early point is still being developed, was higher. And therefore, instead of using Mexican laws to deal with this kind of case, the Nia case, you actually were supposed to deal with a minimum standard of treatment. And that minimum standard of treatment was now contested between whether it is at the same level with customary international law or whether that minimum standard of treatment is actually, lower than what is in Mexico. So that is the quick origin story. Then you fast forward up to the 1960s. What happened between the early 20th centuries into the 1960s is that now we have a huge development of very many standards on how to treat foreigners in foreign lands. And then African countries have mass decolonization. And the transnational companies which had enjoyed better treatment, because many a times within this period, transnational companies who had been in these countries that were former colonies and who were in Latin America were claiming that they should be treated better than the nationals. So if you have done any international trade law, there is a principle called national treatment. That principle says that you should treat any foreigner in your country as well, and I could possibly say as badly as you're treating your nationals. So if you're going to treat them badly, then treat everyone equally. It's a discrimination principle of treat people equally. But even that at this time does not apply. So at least in the earlier period, some scholars, again in Latin America, come up with contesting doctrines, doctrines of contestation. I call them sometimes doctrines of resistance. Like Carlos Calvo is the famous one. He comes up with this doctrine that we nowadays refer to as the Calvo doctrine. And in this doctrine he says, he goes first for the national treatment and said, why should we treat foreigners in our lands better than we actually treat our own nationals? So he's making a claim for national treatment. A big claim for national treatment. And he says, if a national, say in this country, is not being treated better, why should we have another law that wants to treat a national better than the nationals here? So national treatment is important. But he also makes another important claim that is core to customary international law, that before you espouse a claim at the international level, you need to espouse it at the domestic level. It's well known as the doctrine of exhaustion of domestic remedies. So even if we are going to treat you better then please show us that you have exhausted domestic remedies, unless there are exemptions or exceptions that are justifiable for you not to exhaust domestic remedies. The other idea is related a lot to sovereign debt, the Drago doctrine. I think I would highly recommend this book on this, the first one on war, commerce and international law. It's maybe the best introduction you can get on some of this doctrine and how the doctrines and how they relate to international law. So again, I told you it's a primer. There's a lot to be said. I can't say everything. So I'm going to drop names intentionally so that you can possibly get some of these readings and you will really enjoy them. Now, 1960s, multinationals are worried about mass decolonization, because mass decolonization, at least in Anglophone world like our country here in Kenya and most of the Anglophone Africa, meant that now African countries will gain full sovereignty, and they will make not just the claims that Calvo had made and Drago had made, they're going to want to enjoy their sovereignty fully. So these guys had to come up with a plan, and this plan was executed meticulously. I think the best person who writes this story is called Nicholas Peroni. He gives a very interesting story of how transnational companies, Shell, especially the ones that deal with oil and gas, Shell, Total Energies from France, and the corporate interests that were tied to them were the early drafters of, I think the earliest is the Shawcross early drafts of the what now we call bilateral investment treaties were developed at this point. And then they now not only, they started creating standards, not just standards of treatment, I've given you one minimum standard of treatment, but even more, something like fair and equitable treatment. They dealt with the question of compensation for expropriation, which had been a big issue at the time Carlos Calvo was dealing with this issue. Now, at this point, we already have the introduction of international arbitration, and investors are now, especially transnational capital investors, and I'm using this very specifically. There's very good work that has been done by another leading TWIL scholar called Bupinda Chimney. It's done a lot of work on just trying to show us who is the transnational capitalist class, calls them TCC, what do they do, what are their characteristics, and why we should be very careful with what they're doing. They're the ones who developed this idea of modern international investment law, including these standards that we are concerned about, like fair and equitable treatment. And international investment arbitration then begins to grow and enter the World Bank. For me, when you hear the word World Bank every time, just this should raise your eyebrows. At this point, the World Bank enters into the question, and the World Bank develops what we now call ICSID, the International Center for Settlement of Investment Disputes, under a treaty that nowadays, we call the Washington Convention in 1966. The big guys, the history sometimes is written in a very revisionist manner to say that some of the people who came up with these treaties did not know, some of our scholars, or they had good intentions, or it is difficult to fathom what their intentions were. Someone like Theo Elias, Humphrey is laughing because his doctoral work is trying to figure out what are the intentions of dead people. It's very hard to find out the intentions. In my doctoral work, I was asked by my supervisor, seated here, so what do you think was the intention of these guys? These guys are dead, So you have to figure out, you read their works and you can't find clear intention of what, they had inside their minds. But ICSID then becomes the center where it's now I think the fifth, if I'm not wrong, please fact check me on this, arm of the World Bank, together with a few others, but the World Bank now has become a humongous organization. And the role of ICSID was to solve these disputes that transnational companies, the transnational capital class, did not want these disputes to be solved at the domestic level. They wanted to do what in legal terms is called delocalization. They wanted to delocalize these disputes. They go to arbitration. So some of the most interesting works that have been done here have shown how not only were disputes being delocalized, the laws of these countries, especially the former colonial countries, were completely being set aside. And they are being intentionally set aside by the arbitrators who are sitting in ICSID. That's the next marker. The last marker, and important based on what is developing, is what happened in 1990. In 1990, there was a big case called AAPL versus Sri Lanka. This is a big and important case. It really marks out what is, old international investment law possibly, and then what is new international investment law as we know it. In that case, for the first time, international investment law moved from just the contract between the multinational companies to allowing these multinational companies to espouse treaty claims based on bilateral investment treaties and multilateral investment treaties. And I've told you already these treaties, and if you can look at them, there are many right now. The new debate now is what is an old style one, what is a new style one. BC will cover that a bit. But the idea is that they are very short treaties actually. It's not a long treaty with certain provisions that are the most dangerous and pernicious to the development of developing countries, as I know it today, in terms of how they have been interpreted. And AAPL, Sonaraja calls it the original sin. It is from that point where we move from contract-based claims to treaty-based claims. And from there, just the number of ISDS cases, and ISDS is International Settlement of Investor State Dispute Settlement, sorry. I do this so much that these acronyms. Yeah, so the cases increase from there, a large number of cases from the 90s. And most of these cases were based on a principle that we're focused on in our concept called the fair and equitable treatment standard. It is related to the minimum standard of treatment that I had spoken to at the beginning of this presentation. But that standard, you could possibly fit any kind of mistreatment. Think about yourself as a foreigner. If you think about any kind of mistreatment, could feel fair, equitable treatment. And not only can our multinationals have used it very well, arbitrators whom we have critiqued in some of the work that has been done criticizing investment law have really accepted and pushed it, which is one of the biggest critiques of how arbitrators themselves have been willing to accept how the ones who have been broadening and ballooning this standard. And this standard has become maybe one of the, you could fit any kind of thing that has been done to you and say this is not fair and equitable. And the fair and equitable standard that has been used, at least one of the work that we have done recently, it will come, I'm sure, at the end of this month. It's a special issue in the World Journal of Investment and Trade. One of the authors who has written an interesting paper there said that the standard that these arbitrators have used to say what is fair and equitable is so high that even you will not find, you cannot be met in any of the developed world. The standard is crazily high. It's utopian to think about. It doesn't exist, and yet these arbitrators think that the developed country governments can and should meet this standard. And this is how many of these cases have actually been lost. I don't know how I'm doing on time.
I heard you mention that BC is taking the stage.
Yes.
You have up to 4:10.
Okay, let me take just 3 more minutes, and then BC will come and fill there are many gaps. We can't do everything, but again, it is to whet our appetite to be really interested in this area of law. It's in vogue now, and some people have taken it more seriously, at least in the Western world. So I guess one of the big debates that we have now been having in Africa is Africanization. Knowing this, how can we then Africanize, okay? How can we then make this international investment world work for us as Africans? So here we have given you, I think BC's work is the best. It was given as a reading. I wouldn't say a lot about that. Yeah, mine is coming out also at the end of the month, trying to speak to BC and to other interlocutors out there. You will be able to read it. Maybe I will stop there, and BC, you can come and pick it up from there. Thank you very much.
Okay, thank you very much, Harrison. And I think that my own part in this is 5 minutes. So that Q&A. Okay. Okay. All right. No, we want Q&A. So 5 minutes. What we thought we'd do was to have a crash attempt at a little bit of doctrine, right, and a little bit of critique, right? So if you were here this morning, you can tie this to what the judge said about the commitment to TWIL.
You can also think about what Dr. Adepola did as, putting personal interests aside and suffering through it. And so a question was posed to her earlier today. Do you think you want to go ahead with the session? And she said yes. And you saw she powered through, even though with a voice happening like that. So sometimes these things are not so scholarly far away in terms of what we give away to do this work with our heart. But let me say that when you think about TWIL and international investment law, you can think about them in very broad terms as critiques of investment law that are procedural and critiques of investment law that are substantive. Of course, you say, what do you mean by that? It's easy, right? If you think about procedure, you're thinking about the practice of the law. And so in the context of international investment law, it's about the arbitral processes that happen. Processes because you have to think about not just the rules by which the arbitrators do the work they do, but the process that actually leads to their appointment as well. Whether we have enough representation in the appointment of arbitrators, whether we have enough women, for example, in there, whether we have enough persons who mirror the states that have become the most respondents, right, in that process of investment. So that's one. You can think about much more technical questions of double hatting, right, where an arbitrator not only sits as an arbitrator, but also becomes a party who represents, right, a person who represents one of the parties. So we can think about those in very many terms, and we're more than happy to share materials with you on those. But the other part, which has become the maybe most important one that a lot of Global South scholars, or if you like, Third World scholars focus on, is much more substantive, right? And here you can maybe imagine it by saying that, I wrote this now, that the DNA of international investment law is coded, right, with the subordination of the Global South states. So if you imagine that the DNA of anything is coded with any kind of subordination, it means it's very difficult to disentangle, oppression, power play, and so on and so forth from that. And that's what has happened, right? So a lot of scholars have written about this from its inception, right? And you can think about the little bit about how colonialism ended and how states were made to believe they now have independence. But if you think about it, do our states truly have economic independence? I assume the answer will be no, as some of you are nodding your heads in that direction, right? So you think about maybe they have political independence, but maybe they don't have economic independence. But in the way we also understood it, as Harrison said, there was a transfer of power quite smartly, right? Not from the old imperial orders that we know as the states, but to now transnational capitalist firms. They are richer than many states across the world. Think about Facebook. Think about Amazon, right? You can think about the oil companies who have been a lot of the claimants in this situation. But you can also think about the dispute system itself. It is set up against the interests of developing countries. Let me give you an example and then we'll go to Q&A. 2 weeks ago, I did an interview with one of the radio stations in Canada, and this was about a new case that has been filed against Honduras, right? This case asks for an amount that totals 11 billion USD from Honduras. Do you know the origins of that? Apparently some years ago, the Honduran government wanted to create this special economic zone area where they would give investors liberty to carry out certain responsibilities that actually mimics what the state will do. And essentially what you see a lot of these investors do is to undercut what the governments will do. They not only provided most favorable tax regimes, but they have, structures, infrastructure, and so on and so forth that mimic the efficiency of the private sector. And so with a change of government, which is one of the risks that a lot of investors want to make sure they are covered, won't affect their contractual rights. When they enter into these long-term agreements, there was certainly an move against this. And when the government decided to repeal the particular law that was in place that facilitated that sort of investment, they tried to, move against these investors. The investors were maybe tried to approach the government to discuss this, but it met with silence, right? And so they wrote the notice of intention to commence arbitration. The notice is online. White & Case is the one representing them. So maybe the last point I'll make is this. When you think about that, you ask yourself, what's wrong with that? Of course, Harrison mentioned the overlap with debt. A lot of you would have had or may have copies of the books that have been written by a lot of some of the people in here, 2 books now, that talk about the debt status of many countries, not just in Africa, across the world. That has direct connection to these cases, right? Because if you think about a state like Honduras, who may potentially get slammed to pay, let's even say, $9 million, they are in terrible shape in terms of their economy, in bad debt. Look, I don't have to give you a hypothetical example. You can go look up the case that has involved Pakistan. They are the most clear example of what I'm talking about, right? They're in trouble as a result of investment claim and the damages that has come out. So if you think about the procedural, many issues under it, and the substantive, and one core issue that relates to the ungodly nature of the amount of damages that are given against these states, you can then step back and start asking yourself questions about who is this regime really for, right? Who are the, in loose terms, winners and losers of this regime? If you think about that, to invoke some of the words that Professor Joel Ngugi used in the morning, right? How should we think about this system being undone? So you've been given that excellent blog that Harrison wrote. You should think about his own thoughts in there. He says, we should exit this system. There's no need, window dressing it, as he says, right? Don't move the chairs in the living room. The architecture remains that of a colonial entity, right? Many other scholars agree with him. But there are those who think maybe we should, for now, think about rearranging the chairs in the room, because maybe that's the best we can get right now. There are those who will say, no, you're being too moderate, right? Look at the Europeans. The Europeans are actually saying what Harrison is saying right now, because the very disciplinary nature of investment disputes, dispute settlement damages has come home, especially in disputes that have arisen in the context of solar and the movement to friendly, climate-friendly investments, right? In Europe, that's involved the cases of Spain and Germany. And so you have to step back and ask yourself, how are these regimes playing out? Of course, there's a move to reform the system under what is called UNCITRAL Working Group 3. It is mainly procedural. It is not substantive. And so a lot of scholars, who are Twill scholars, are not happy about that. For good reasons, you might say. But others might still say, but well, you're complaining about the procedural aspect as well. If we can't achieve the substantive reforms yet, can we at least go with the procedural and focus on it and see that it addresses some of the challenges that are out there in the procedural context? So this is to lay out potentially things you can engage with in a Q&A. I don't think I've presented my own views at all. You can engage with that material and make of it what you will. But we'll be happy to take Q&A right now, right? Okay, thank you very much.
So what they didn't disclose is that they have a fight between themselves, but that's, they do. They have 10 minutes.
Thank you so much. I think my question is based on just one particular thing. You have talked about investment and the dispute regime that is there, Rwanda. What you have not discussed with us, and I would like your comments, is what is the place of human rights in the international investment disputes? Because as you recall, as a country, we had a case, the Kotek mining case of Mrima Hills. And you recall that Kenya largely relied on the question of human right to revoke the UK-based company, and they won all the way. So just your comments on the place of human rights in the international investment disputes. Thank you.
Yeah, good question, but it was really environmental. It was the lack of getting environmental licenses.
Okay, thank you. Almost 30 years ago, I took a course called Foreign Investment in Natural Resources. But the tone of the course was more like teaching African and Asian lawyers how to better negotiate foreign investment contracts that involve them natural resources. Now, Harrison seems to have given up on that project. He's saying, let's exit. Is there any investment now in getting capacity in Africa to negotiate better, or even to serve as the arbitrators? Or are we now giving up on the system altogether?
Wow. It's fine.
My friend, you're decentering your brother again.
Then I think you will take this.
Okay, thank you. I've heard we are speaking about international investment law, and I'm hearing us mention only European cases. I hear Sri Lanka, I hear Pakistan, Spain, Germany. So my question is, what about the African approach to international investment law, and even the TOEL approach to the same?
You really want them to disclose what they are fighting about. This is good.
I can go. You go faster than I deal with it. There are more questions.
That is the crux of their war.
We give time.
Yeah.
They're being very friendly today. I want to see fireworks.
Okay, I think my question lies with something that Dr. Harrison mentioned about the fact that the main issue, or rather one of the main issues, is the rules that now build up to the appointment of these arbitrators. So how, and it relates to a question, how can we then bring about capacity building in terms of the kind of arbitrators that we are having on these benches? If we could have toilers as these arbitrators, wouldn't that then be a solution? Thank you.
Thank you. My question is with regard to something that Mr. Lisi had said about, like we see time and time again, about how the third world countries or countries in the global south enter into agreements with countries or companies that are from the global north. And time again, we see that they disadvantage the African countries or the third world countries. So what is the way forward? Because like in a lot of those cases, there is a lot of imbalance of power, there's a lot of factors that come in such situations. So what is the way forward with that regard? Do we continue with this regime of investment law? Yeah, I think that's the question. Thank you.
Yes, since there is equality of treatment, I'll go to Sipala first. Under international investment law, you guys are going to 410, so just bear that in mind.
One question on two parts of hegemony that I've not heard you speak about, and whether you think they actually exist. One is your comment, BC, about how Europe is beginning to feel the brunt of the investment system. Reminds me of Austria's anger at having become landlocked after the Second World War, the First World War, and having led the Group of 77 to push for landlocked states' rights in UNCLOS 3. So there was a merger of interest between African states and the European landlocked states. I'm wondering, do you see an opportunity where, again, we could rework this, what happened in the 1970s, and change the system because we have some suffering Western states? One, and two, what about...
Sipala, kuna another question here.
So this is me. Okay, it's just another part of hegemony. Another part of hegemony where Africans go register foreign companies and come through corrupt deals to their own countries as foreign investors seeking... This is the issue, I think, with the Nigeria case, the corruption case that Nyanji writes about. So is that another part of hegemony that we want to fight? Yes.
Thanks.
Quick question. Do we have rudimentary corpus of African thought or African contribution in terms of international economic law? Because we are facing a dog's fight. Naomi Klein gives you shock doctrine, gives you a broad view of what will be put to bear when you try to challenge the existing economic order. You see the fight now between BRICS fighting the Bretton Woods establishment. Do we have a modicum to fight?
Over to you guys. Over to you guys.
Yeah, I think there are many, so we'll try to, because of time, to deal with them. I think the human rights question on Kotek, as Prof. Gadi tried to clarify, the Kotek case for me was more environmental than human rights, but for me it's more corruption than environmental. And I think Village might agree with me. We won the case because we are actually corrupt. That's my critique. It's not as if Kenya won the case because, and I think Village, you could engage with this even more with the question on how the corruption angle sort of fits into this discussion. If I start talking about human rights and investment law, we won't finish. So that's my very short answer. We can do also bilaterals. I think Prof. Musembe's question is very interesting. My claim on exit was to exit the dispute settlement system. And I've really tried to clarify this so that people understand. My claim for exit is not to exit international investment law. We can't. We can't exit the system because it exists even at the domestic level itself. My claim is that the mode that we're using to settle these disputes is completely wrong. That is my the claim that I'm stating. And BC has always asked to where. We have a strong administrative law system that is developing, at least in this country. I know that after the 2010 constitution, we even have a right to administrative action. The South Africans were the ones who led us to even understand how strong administrative law can be. I know that some European scholars have reflected on this. If you have a strong administrative law system that deals with this question at the administrative level, and we deal with the hegemonic question of that has existed for a long time, that we can't do good law. You know, the global south cannot do good law. It doesn't matter how well you set up your system. Some people think that we can't do good law. That we have to deal with psychologically, in the Fanonian sense. It's not a law question. That is a psychological question. So if you ask me, we even have to go to psychologists to help us with that. That's why I'm citing Fanon. But the legal question is that if you have a strong administrative law system, it means that we are going to have good national treatment. By the time an investor thinks of espousing a case that has been decided by Justice Joel Ngugi, they'll think 10 times. It won't go anywhere, in my view. A case that has decided on administrative law, a case that he decides here at the domestic level, will be so watertight, you cannot challenge it anywhere. And that's my national treatment. So my claim is, go where? Go back to what has already existed in international law that we are trying to reform. Go back to national treatment. Go back to diplomatic protection. At least for now.
So 2 fingers to balance. I think this is what James tries to say we fight over. So I'm happy he's engaged with my thought, and I'll be very happy to engage with his thought once I've had the opportunity to read your thesis and the forthcoming article, okay? So thank you for doing that. But so I'm skeptical of this exiting the ISDS, as it were. Look, I come to it not just from a twill-centric academic heart, but a pragmatic heart. That's why I ask, to where? You've signed an agreement, contractual. What do you want to do? Just contractually. This is very doctrinal at this point. There's nothing critical about it. It's just the art of the practice of corporate commercial project financing. And so at some point you have to say to yourself, hold on. Maybe we approach this much more methodologically in how we go. So the other claim, which people like Dominique Dagbanja and so many other scholars, who are Africans by the way, have written about, is that you go to the national courts. I am sympathetic to that argument. I'm actually not disagreeing with it. But it's just not real at this point that the edifice, which was built on a lie, which I agree with you again, that the national courts cannot adjudicate over these kinds of disputes, is the reason we shouldn't go there. It's not true, but we have to be sincere. To do that, we have to be sure we have the expertise enough on the bench. Joel Ngigi, the judge, is an excellent mind. maybe we don't have many of him already trained in that way. Look at his trajectory. We're all saying come back to the academia, right? So maybe we don't have that. And I'm not necessarily saying we have more of it in Canada or elsewhere. So not arguing that we shouldn't come to national courts in the African context is not an affirmation of the superiority of another national court. Rather, it is a regard to, in practical terms, the sanctity of contracts. Okay, sorry. Continue.
Now you see what you did, Prof. You see what you have done now. I don't want this debate. We are having it also in writing. So we keep going. I think for me the other question is to deal with giving up. I've already said no. Sipala's question on Europe filling the gap. Actually, some scholars have argued the reason why we are having the ancestral process of reform now is because Europe has suffered. We have been saying the system is bad for many years. No one has ever said we need quick reform. Now that they are suffering, now that Netherlands is actually trying to deal with climate change and the fossil fuel production companies are suing it in ISDS, that's when they are realizing, oh my goodness, you mean actually this thing that we meant to bite other people can actually bite us? You know, that the revolution can also eat its own children. In this country we've had that expression. Don't be happy when you have a revolution, it can come back to... So this is in itself a critique of how Eurocentrism in itself works. So I agree with you in that sense, and it has already been presented. And the problem is with treaty shopping. The question was, where are the African cases? I mean, if you just focus on the ISDS cases against Tanzania only, in fact, the recent ones that came up after Magufuli's good decision to try and protect the mining industry of Tanzania, there's been a flurry of cases, recent cases, for what you would consider to be, to us, to have been a very Twilian move, that once you make the vultures come at you, and this is Tanzania. In fact, one involves, TANESCO, which I cite in the book chapter. I'm sorry for self-promotion, and I see you looking at time. We are about to finish. We have a few. So there's a TANESCO case, which is the version of Kenya power in Tanzania. And Tanzania has had cases that if you check right now, there's a lot going on there. And just to say, most of these cases involve Global South countries. Sri Lanka is part of us. Sri Lanka is in the Global South. One of our respected elders, Tony Engi, is from there. The AIPL case is a Sri Lankan case, and sometimes you look at the problems going on in Sri Lanka, they're very similar. I went there earlier this year, and they had a BBI debate in the 90s. They had a similar question. We're not speaking to each other, I think, enough. Can we rework the system? That's the debate we are having. I think also, just last comment based on Prof's question, I think Prof. Gadhi's view and mine here also conflict when it comes to negotiation. He says, bring good negotiators to the table and things might change. I think it will not change, because I see the kind of negotiators we take to DC. They went to DC for the ESIL, and one of our senators was saying he went to a negotiating meeting and he sat down as an observer, and then he saw the side of the Kenyan side and the US side, and he said, oh no, this can't happen. There's nothing we're going to negotiate here. They will give us a list and see which boxes we check, and that's it. Prof says, I don't think with the elites that we are electing in our African countries it will work, but there is hope for the future. There's always hope.
Do I have 3 minutes?
At least 2 seconds.
That means I have 3 minutes. Thank you. Thank you very much for your generosity. So, great work, Harrison. So, appointment of arbitrators. Efforts have been made, right, to make things better. 3-4 years ago, there was a publication that was done in response to this idea of, we don't know where the African arbitrators practitioners are. We can't find them on the website. How do we find them? Okay, we'll help you. Okay, so they don't exactly. So a body of arbitrators, African arbitrators, put together from Africa, Latin America, the Caribbean, this list. There's actually a special one also, female arbitrator practitioners that were put down. So that's an action, a response, right, to a critique. But also there has been calls, right, to try to make better the appointment process. But look, this is where power and the stronghold that the European white male folks have on this system, white male, in the axis of just France, maybe London, England, you know, Germany a little bit. That's where you are, and a little bit of the US. Okay, pale now added to it, right? So this particular claim is not one that, you know, I think will go away. It's one we have to keep working at, and we all continue to shed the light on it, but there are action being taken to do that. You should also know that in the Kenyan context, right, Willie Mutubwa, right? Exactly, the other Willie, right? He Florence and a couple of other folks, right? The Kenyan arbitration circle is actually a very vibrant one. I follow it, so you should follow it to see what is happening. And part of seeing what can make the system better to the female scholars in here is to engage right now and not wait till you've left law school and start asking the same questions we are asking. So start getting prepared. 2 more questions, and then in 2 minutes I'll keep quiet. Which one? Imbalance. I think you responded to that, right? That's good. Rudimentary docs on Africa. Oh, great question, right? There are fantastic scholarship on African international economic law, right? There's one that is called African Trade Agreements as Flexible Legal Regimes.
That's a big one.
Exactly. It's written by Professor James Gathie, right? Why do I go to it? I think genuinely it's one of the first pieces that put together in that book form that we all go back to work with. If you think, oh my God, this book, there is a chapter, I think, that is available as a journal article that frames it, right? Which you should all get. It's online that you should get that. In the international context, I was coming to other generations. In the international context, right, there are also pieces that have been written by not just him, right, questioning the regimes, but by others, right, of the era. And here you can think about older names, right, like our Ghanaian SP Asante, right? SK, thank you. Who's written in the 80s about the ECOWAS ones and has many articles out there. Then more recently, about the same time, Professor Gathi's Bejawi, the New International Economic Order. You can download it as PDF. I download it each time I can't find my own. So just go online and download it, right? But at the same time Professor Gathi's book came out, there was also Frimpong, Richard Oppong. It came out the same month. His was actually also the same month, right? His was Private International Law and International Economic Law in Africa. That's not the title, but that's the general ballpark that it's in. So you have 2 great books to start with. But much more recent books have been written, not just in the context of trade, but IP. There's Amaka Vani. There's Timothy Masiko. There's Titi's book coming out, right? As well, our Titi here. So there are many others. I can't start remembering them now. But the idea is not to... Don't believe anybody who says there are no materials on international economic law in Africa. One last thing, it is also being taught in African law schools now, right? And I know that Janet had conversation during African International Economic Law Conference asking about how she can do that. So happy to share lists, but thank you very much. And you see, we don't fight, so don't perpetuate this thing.
Join me in thanking them for not fighting. Okay, so we will take a tea break now, and let's be back at 4:45 for our closing plenary. Let me just say that first, I think we need to thank, even before our closing session, Elvira back there. Please, let's thank Elvira. She has gone over and beyond and above, and we are very grateful for everything that you have done, including frantically copying lots of stuff that has been mentioned. So let's take the break. Please come back 4:45 so that we don't keep you too long.
I think we want to thank you guys for the time you have spent in, not just being here, but spending what looks like the whole day. For some of you with us here, I'm sure it's an investment that will pay off at some point. In this last session, what we want to do is, or at least my own session, is to maybe just quickly walk you through the features of the AfronomicsLaw website. A lot of information has been dished out at you guys today, and sometimes, they come quick and fast and can be overwhelming. At some point you're like, there's so much to learn, but I'll get to them. So we thought, rather than tell you, go download it on the website, we can show you those features in the hope that you can see that these are materials that are, number one, available free access, right? So I used to say open access, but one day Professor Gathi, talking, and he was like, no, it's free access, guys. So so I always give him the footnotes, citing in this here, free access, because he said it to my hearing once in that context, and it's a good thing to acknowledge where your thoughts have come from when you're writing as well, your scholarship. It's a good practice. Okay, so if you look at it, this is the AfronomicsLaw website. This is the homepage, right? The irony of this is, Professor Garcia and Dr. Adebola, in 2019, maybe about this time, we were doing a similar thing here at Strathmore. We were unveiling AfronomicsLaw blog. We were doing that. We were on the stage in the other hall. It just occurred to me. So, how life works. We weren't thinking about it in this way when we said to do this. But here we are giving an account of what this honor to serve has come in the past couple of years. So you would see the articulation of our commitment in what it is about. It focuses on international economic law and public international law. We cover not just Africa, we cover the global south. Maybe it explains why our examples are not limited to the geographical area that is called Africa in some contexts. And we seek to amplify voices and issues. Amplification of voices, you can see not just in the publication of these two books, not focusing on names that are known out there, but on focusing on emerging scholars. And that's the practice we do in all the blogs, in all the other publications that are carried out as well. Once you've made your way through that, then you can see more substantive features. So you can see the home page here. You click on that, then it brings you to this page, right? At the top, we have various buckets. Let's put it that way. So the first, this is not quite, this is more rectangular in shape. So this is the African Sovereign Debt Justice Network. So I'll use the language of products of AfronomicsLaw going forward now, right? It's one of the products we have. It is a coalition. If you click on it in the red map, if you want to know more about it, it takes you to this page, right? And you can scroll down and see, coalition of citizens, scholars, NGOs, church groups, because they matter in these conversations as well. Religious groups matter in these conversations. And our commitment is to exposing the adverse impact of sovereign debt that is not sustainable on the ordinary lives of citizens. That's you and I. We initially focused on Kenya, Zambia, Zimbabwe, Mozambique, Nigeria, and Senegal because that work was supported so kindly by Open Society Initiative. That's why we're able to make these books available, free access, and I'll show you more about it in a short while. But over time, we've also committed to becoming the place you want to go to if you want to hear the news about anything sovereign debt in Africa. And so we have excellent fellows who work with us. One of them is here, Samantha Chineso. Hi, she's the one, she's produced a lot of what you see. Yes, please give her a round of applause. As sovereign debt news. There's Akinyi who couldn't join us here. There's Yori as well. They produce this series of updates, right? And if you scroll down, you can always go back and use the feature at the bottom to just go through the many pages you want. So you can see if we go to the last, we now have as many as Let me see. You see, we go back to page 14, right? So you can see 14 with about 7 or 10 average of posts per page. That tells you how much has been produced in the past, maybe roughly 2 years in this bucket of our products. So if that interests you, you should look at it. But you know, you shouldn't just look at it because it is information that is good for consumption. It should inspire you to think about, may this be something I'm interested in for the future? You know, I don't know how many law schools actually teach sovereign debt in classrooms. So, you know, it's a genuine feature that also not just provides information that is digestible, but is meant to spur interest in this area. And for me, I can tell you about myself, it has been very helpful to learn more about sovereign debt as well for my own scholarship. Okay, so once you move past that, then you see the buckets. There are 6 additional buckets. There's what is called the analysis. We might call that the blogs, right? They are short, crisp, reflective pieces. The maximum is 2,000 words. It's not footnoted. Maybe in some cases we make exception for light footnoting, but it's more easily hyperlinked so that you can go through them easily anywhere. You know, you're in the matatu, you're in the workspace, you have something to read that is different from what you're working on. And so you see all the articles in there. Once you click on that again, you can see a lot more of those pieces in there. Now, in the analysis section, there are 2 types of blogs that you'll see in there. There are individual blog posts that are done by one person who reflects on one issue. So, for example, you can think about this particular one, a new era for arbitration in Nigeria, right? And this person, Nabayomi Okubote, reflected on the new Arbitration and Conciliation Act, Mediation Act in Nigeria. So it's an individual publication that he wrote, and it will be there. But the other type that you will see in there is what we call publications that belong to a symposium, right? And so you see this particular one, for example, Symposium Introduction, is an example of the first post that is made in a series of symposium posts. You might say, bless you, what is, a symposium? Well, it's basically a very thematic set of reflections that has been curated by 1 or 2 conveners or 3 that has, reached out to different persons to write on specific questions that then become maybe 5 posts for a symposium. The minimum is 5 posts. But we have had as many as 20 posts in a symposium. And we've had as many as maybe almost 40, right? Which is, during the pandemic when we did the collaboration with Trila on teaching international law in Global South as well. So there's a lot in there to look at. So you might say, where do I find the symposium posts? They are here. So if you look on this, you see Symposia, forthcoming feature symposium page. All right, look at that name there. That's part of this latest one, right? He's there smiling now, right? And so you'll see that, but there are others that are forthcoming and we'll add them in this context. But look at the ones that have been prepared, right? You see, they're not just about what happens in Africa. They happen about what happens in every space in the world. So we are not, even though we emerge as thinkers from Africa, we are not concerned just with what goes on the continent. You click on them, you get anything you want. And you can download them easily as PDFs. Right? So you just click on them, download as PDF, and you have it to go. So you don't always have to print if you want to think about conserving the environment. And so there's a lot more in there. This one was even, done, but for the Academic Forum guys, this was done by one of our editors who is not here, Dr. Omionu, who leads the Academic Forum, with 2 of the former regional leads of the Academic Forum. So don't sit here saying, oh, maybe I'm in 2nd year, I'm too young to write. No, the Academic Forum belongs to you. You should all write to the folks in the Academic Forum. Where do I get the details? I'll show you in a short while. Okay? Then the other feature you find in that bucket of symposia, I need to move quickly now, is what is called the book review. as well. Here, people who have published important books. So this is, Professor, this is part of the work we do to highlight publications that are on important issues that relates to the African and Global South context. Let me tell you the thinking about this. In most journals today, you see if someone wants to review this book, they'll write 1,200 words or 1,500 words maximum if it's a book review. It's a different if it's a review article. You have more room to write in there. And so it's buried in the pages of an issue, right? It's usually 1.5 pages in print. Now, not many people get to read that. So we thought, as far as African scholars are concerned, when it comes to their material, we want to highlight and put the searchlight on it. And so you see this, we've done 23 books so far. That's a lot. He's down there, right, as well. And then, the introduction to the first issue, I think I recommend to you to read, because it's not just introducing the article, it articulates the philosophy around it. Okay, move quicker. Once you've gone past this, you're back in the video content. This is straightforward. It leads you directly to our YouTube page. This is being recorded. It will be on our YouTube page right away. But there's also the Indaba. Indaba is important conversations. The one had with Samantha is already there with Professor Gathi. Titi did one with the special rapporteur on right to food, who is a twailer as well. And so you can go through those. And a lot of academic forum videos are up there for you to digest. This is the news and events. We post job opportunities, conferences, everything that is important for you to know that offers opportunities for you. So you can always peruse that on a daily basis to see what's new. This is the all-important academic forum. All important because a lot of you here should just belong there. If I were you, I wouldn't say, should I not? Maybe. No, I want to be part of it. And I don't just want to be a passive person in it. I want to be active in it, because you don't need any more invitation than this. You have the information, and so you should just run with it. Then we have this great spot that I think has not been highlighted enough, which is the repository. So, for example, Professor John Ngugi talked about the fact that we should think about how the bibliography for the TWIL scholarship can be made accessible. Once that is ready, it's going to come up in this bucket, right? And here, look at the book. That book right there can be downloaded here by just clicking on it, right? And then you have your copy downloaded to you straight. So I don't want to do that, but it's somewhere here already, right? Look at that. You click on that, download the full book here. Download the front and cover. If you want printed copies, then you can go to Amazon and buy them. But you guys are fortunate, you're going to get some here today to go home with you. And in that same bucket, we have other things that you can also download that are materials that are useful. One last thing I'll say. I encourage you, if you're on Twitter, to just follow us. Consider it. I think it's a good idea, right? Well, these days, X. If you're on X, it's weird, right? And we can also talk about tweeting again. You're posting, right? So go in there, follow, engage with it, read the posts, say your thoughts. There's a comment feature under each of the analysis sections that you can provide your comments, and the author will see them and respond. We are available on LinkedIn, on Facebook, and on YouTube as well. I think that is it from me. Now, thank you.
Peer review your abstracts, talk to your lecturers, ask them for feedback on your abstract and the papers that you'd like to present, and just join. I remember when I was finishing my PhD, it was at the point when I was going to make a decision about TWIL, because I had a lot of hassle in conversations around whether I wanted to continue working on TWIL issues. And I saw the conference, the TWIL conference in Singapore. I attended the conference. I had my pen and my paper, and I was asking all of the TWIL scholars questions I was curious about, and they happily obliged me. They happily answered all of the questions that I had. And that's the same attitude, I think, that you could consider adopting if you want to learn more about specific issues in relation to international economic law. Do your background reading, prepare questions that you'd like to ask, and then reach out to your lecturers, reach out to all of us here that are in this room and all of us that are involved in Afronomics law, and would be happy to support you. And if you would like to join or contribute to the FILN, just feel free to send us emails and we'll be happy to respond. I just want to say that I'm also proud of everybody, all of the students that have waited. It's been a long day, and you have all waited until the very end, and it shows me that you are interested in building your own scholarship, in building your own research in international economic law. I would say that you should keep up this enthusiasm and push, because you are the next voices in international economic law. All you need is to start with one area. So pick one subject, pick one topic that you're interested in, and begin to work extra. You're students, but you also have voices. So start using the voices that you have. Use all of the resources that you have. Think about blog posts that you want to start with, and think about collaborations. So if 2 or 3 people decide that you want to collaborate to write a 2,000-word blog post, you can easily do it. And one low-hanging fruit that you can consider is think about contemporary issues. So if there are issues in relation to perhaps cases that you read in the news or cases that have been recently decided, take the case and research on it. Think about ideas. Think about your central thesis in that and write a blog post. That's how you start. Many of the chapters in this book, actually, Godwin was telling me that his chapter started with a blog post, right? And then it became a chapter. So many of the ideas, you start with one blog post and then you build it into bigger research projects. So I'll just invite you all to engage with Afronomics Law. Feel free to send your contributions, and we'll be delighted to see how your career evolves and progresses. So thank you.
Okay, so So I want to say a few things, and then we can open up for just a discussion, a general discussion, because we did this when I called Humphrey. He says I texted him very early in the morning, like 2 weeks ago. The whole idea was that we were doing this to engage with you guys, not just to listen to us, especially those of us whose knees don't allow them to stand for very long. So I'll sit down. So I wanted to just say a few things about some of the conversations we have had today before opening up. The first thing I want to do is that I'd like you to, in light of the discussion we had this morning about during the excellent session by the professors who teach international law in the various universities, I want to refer to the report of the International Law Commission's Special Rapporteur. He's actually an African. He's called Charles Chenor Jalloh, Jalloh, and Elvira has been so great. It's a big report. I hadn't thought about it before the conference. It's called First Report on Subsidiary Means for the Determination of Rules of International Law. And all the questions we were discussing this morning, I think Samantha asked about the Eurocentricity, about I forget precisely how you framed it. Why is it that only, I guess, you implied white jurists are considered to be the publicists, the leading publicists? And there was another part of your question about, yes, I think it was about why do the rules on sources of international law say civilized nations? This is the first report of a major international law institution taking head-on those questions. So if any of you is interested in those questions, if you haven't read, so I say things like this all the time, if you haven't read this report by Professor Charles Jalloh, then you cannot ask that question, because this is a really important, and I'll leave it here. You can come and take pictures. It's freely available on the website of the International Law Commission. I'm going to give this copy, this hard copy, to somebody who is going to ask or make a very good comment before the end of this session. So that's one set of comments about some question that arose today. We are also happy to put it on the AfronomicsLaw repository, because it might be easier for you to get it there. The other very good piece of news is that Justice Joel Ngugi agreed to publish with us his keynote address. So we will make that available on our blog when it is available. I think it's going to be perhaps the first article of the 4th issue of the African Journal of International Economic Law. So watch out for that. So let me tell you very, very briefly how AfronomicsLaw started, because I think this is very important. In light of the conversation, especially I think it was Professor Edwin Abuya, who said that he wrote an article, sent it to some journals, and they asked him for 100 for all the sources in the footnotes. And he said quite correctly, it's because of the lack of trust that African scholars can't produce the kind of quality scholarship that is published in so-called leading journals. So it was about 2018, 2019, and it was the climax of the trade war between the United States and China. At the same time, the African Union was beginning to negotiate the Africa Continental Free Trade Area. I just happened to have been called to be one of the people that did the zero draft. It was very frustrating because everybody was talking about trade and investment at the time was talking about the war between China and the United States. And it was impossible to have any conversation about the AFCFTA, even in Africa. So I was driving home one day from work, and I spoke to, I don't think BC knows about this, I spoke to Professor Biora Okafor, And, he said, call BC up, do something about it. So I called BC, and I told him before I got home that we needed to start a blog where we would center the debates that we cared about, and that we would establish the audience over time to get attention to these issues. Long story short, we never thought that we would be here. As he said, I didn't even remember that we launched the blog here in 2019. So it may look like the Afronomics law has existed for a long time. It has only existed since 2019. Then we thought, we called Dr. Adebola up and said, would you like to join us? And she said, sure. And then later we approached Dr. Omiunu, who is in charge of the academic forum, and he said, sure, we don't get paid, we have full-time jobs, we devote our time to voluntarily develop this forum. These books are the result of the very many people who have shared our vision, also writing almost for nothing. So it's not about the money, it's about the commitment. We didn't know, I didn't know Samantha, I didn't know Afshin, I didn't know Godwin, sorry. I didn't know Bio. We just have almost organically grown into what we have become today. The academic forum, those of you who were at the book launch yesterday saw that those students are highly motivated on their own without much of our guidance. So it's possible to develop alternative forums for doing the kind of work we care about, for doing all the things and overcoming all the problems that Professor Abuya was talking about, and many of the other people who spoke today. How do we carry this conversation forward? I'd like to hear from all of you. How do we carry this conversation forward? Or are you not interested in carrying this conversation? That's also a possibility. And certainly we don't want to impose ourselves on all of you. I mean, for the teachers, I would love to see all the wonderful syllabuses. For example, Godwin, the way you use Felix Jenga and other people in your teaching. Dr. Harrison Bori, the troublemaker, has done a wonderful job promoting moot courts, and the blog has covered lots of work on using moot courts as a teaching tool, and we are very interested in that. We are nudging him now to help us with litigation as another way of advancing the work in this area. And we're interested in hearing from all of you, both about today, was it useful, could we have done better? As I said to Humphrey, this is a kionjo. This is not it. This is just hopefully the beginning of a conversation, and was wonderful to have the students from many Kenyan universities represented here today, because we believe in collaboration. We believe in working in concert with other people who are interested in doing high quality work in a way that advances our commitment to centering African voices, African issues, and rejecting ideas from outside that frame our concerns in ways that don't advance the interests of African people. So I'll stop there. I can talk endlessly, as Dr. Adebola would tell you, because we want to spare the last moments of this gathering, hearing from all of you, especially about how we can move forward, if at all you're interested in moving forward with these discussions.
It's Q&A for you guys.
Yeah. Teddy,
good evening. I'm so grateful for this session, and especially to Prof for involving the students from the University of Nairobi Faculty of Law. As my colleagues can attest, the teaching of law and This is, I'm trying to hit out at one of my lecturers. The teaching of international law from a TWEL perspective. There is lack of teaching international law from the lenses of TWEL at the University of Nairobi. And it is time lecturers of public international law from Kenyan universities take this up. You don't have to teach us a lot of Eurocentric stuff. Coming back to Afronomics law, I think about a year or two ago, I applied for, I think, the regional lead position at Afronomics. I unfortunately did not get it, but I said one way or another, I will have to look myself into discussions around TWEL, conversations around TWEL, writing on TWEL, and Prof, I don't know if it's possible for the work of an undergraduate student to feature in the 4th issue of the African Journal of International Economic Law. We have very good drafts around whatever was being discussed here today by OT, by Olabisi. Yes. So I think it's time you involved us in this area. Thank you.
Okay, thank you so much. So I'll begin from where Miracle has left. We are both very good. This is me putting out our CVs there. We are very good writers in the room. Around the room, I can see very good writers, both in undergraduate who are my friends, and that is the first point that I wanted to put out. The second point is that when we are talking about now debt, and we are talking about the global debt and financial architecture, we realize that, yes, it is good to teach it from the university, but then do we realize that the debt we have now does not affect only students from the university? This is a burden that will be carried out. Will be carried by people from high school, people from the pupils in primary. Now, how do we simplify this conversation so that they can decode it and know whatever is happening? Yeah. That is my second. And the third about the website. I was thinking of a way, when we look at most of the South African, and even when we are going to Forbes, the website, we have that particular area where it's like a podcast, but not a podcast. It reads for you the article. Could we think of a way to incorporate that in the website? Thank you.
Thank you, Teddy. Those were very good comments. You're competing with Miracle. I want to go for a lady first, and then I'll go back to the two gentlemen, because I will get accused, and I don't want to get accused. Yes, this is good. Of discrimination.
Thank you very much. This has been a really inspiring session. I have learned a lot, and yeah, I've also, my interest has been sparked in some of the, in TWEL as a discipline in whole. I just want to say that there's hope for us as young African scholars, especially in the realm of international law. And just to mention also, at the Kabarak Law Review, we also study scholars of international law, specifically those from the global south that have been that their contributions have been overlooked. So when you have the chance, just go check out the Kabarak Law Review. We operate a section known as Know Your Elders section. In our first volume, we have an article on FX Njenga. And again, thank you for the opportunity.
Yeah, you didn't say that it is fully student run. And that's important. How many more can I take? I have two burning ones. I'll take three three now, because they're becoming many and you might want to react. I'll start here, I'll go up there, and then there's someone behind you also will speak. So we can go like that, okay?
Yes, so first I will begin by saying I am very much grateful. I think this is one of my inaugural meetings into the Afronomic workshops, and I'll begin from there. I think, as my brother Miracle has said, I think the conversation around, Twahili is very important. And not only for the disciplines that are around international economics, because when I recall I have shared several classes with Miracle, and one problem that we usually had with our lecturers, I wish they were here, is every time we would raise the question of how do we decode this from an African perspective. We kept on asking from second year, why do we study, and it's not, that's the reason why I said, it's not about IEL and only international law related subjects. How can we take this conversation to other disciplines, disciplines of constitutional law? Because we know that a number of our laws were formulated from a Judeo-Christian perspective that are basically, from the Western. So I think we need to have a conversation of how can we broaden the scope of this into other disciplines. And then number two, I think we also need to begin thinking of how are we going to assess, the tangible impact and benefits of what Afronomics, what the Twahili perspective in general has been doing, substantively to government. Because you see, we are having all these good conversations from academic perspective, but how do we ensure that the government, we have the aspect of neo-colonialism in most of our governments. How do we ensure that, the substantive people who make policy decisions are aware that, time has come for us to chart our own way from an African perspective. So I think that is very important. And lastly, I would just like to say that, and Miracle did speak to this, I think the frustration of Western journals is a real issue. I was talking to one of my lecturers and he told me he sent one to an international journal and he was told that that is part of a thesis that somebody wrote from Harvard, a thesis that he has really never seen. So I think there is a deliberate frustration from the West in terms of really writing. So I think it's a good idea that we have the Afronomics Journal and we can carry this conversation from our perspective going forward. Because you also realize that if you send an Afrocentric article, for instance, to a journal in the US, it would be very difficult for them to relate, what you're really talking about, because we are providing alternative schools of academic thoughts. Thank you.
Yeah, well, your name and university, and I'll go back to her, because you didn't mention, so that we just know.
Okay, my name is Ndong Evans, a finalist at the University of Nairobi.
Great. Nice to know you, and you can also start by introducing yourself and the university you're attending or what you do for a living.
Okay, thank you. Those are my friends laughing. They're wondering what I do for a living. My name is Valentine Kasidi. I'm from the University of Nairobi. I'm a finalist too. First and foremost, I would like to thank the panelists for the wonderful session since morning. For those who are here, we have been enlightened, we have been educated, and we have learned a lot. Just as I said earlier, I am a freshman in this school of 12, and I hope to continue in this school. Now, how we students we can carry this fire forward, I think you have done enough as Afronomics, and you will still continue to push through. I think it's high time now, since we have attended such a session, that we students, even from other universities, we carry on this perspective to our schools. It would be futile if we left everything here. So, first and foremost, from a personal perspective, just as Mwalimu Evans had earlier reiterated, let's read. Then secondly,
with regards to how we can collaborate. Just as my colleague from Kabarak had stated, they have the Kabarak Law Review. The University of Nairobi also has the University Law Journal, the University of Nairobi Law Journal. We can also collaborate with you guys and see how we can disseminate the Afronomics in the University of Nairobi Faculty of Law, so that more students can get this perspective of 12. Then this is just a small experience. Actually, this 12 perspective I learned it from Miracle Mude. And you know, when he was saying it, we were wondering, what is this 12? 12 every time. So today I've seen it for myself and I've learned a lot. Thank you.
Yeah, we are coming back. I mean, yes, you're going to go next. You go next. Those are very good comments. I'm very happy, Evans, that it's still happening at my alma mater, you know. It's really good comments, and people are throwing in, you know, a couple of, throwing out names of what they're doing. I know, I will say, you should say something. There's a something student run in KU. I know the Law Journal at the University of Nairobi is doing well. The Kabrak Review is very active recently. They're churning out very good material. So there's some fire building, and it should continue. Yes, of course. Elvira will be on my case. You know, I have to sell Strathmore. The Law Review has been more active than the Law Journal, which is run by faculty, to say the truth. Yes, and I'm not even sugarcoating it here. Yeah.
So, hello everyone. My name is Michelle Kakai. I'm a student at Kenyatta University, and I think I'll start with something that has been mentioned about here Kabarak has a review, UON has a review. So for Kenyatta University, we have just recently launched it, actually in September, and we launched the All Kenyan Moot Court Competition journal. And actually the first issue that was on the journal was about debt sustainability. So I think that we should then, as we have spoken about collaboration, that is something that we can look forward to. Then the second thing that I would say so fast, so that my colleague can have a chance to speak, is that I've had conversations from my fellow colleagues from other universities about the fact that TWIL is not that much integrated in public international law. But I'd like to take this chance to just give a shout out, let me call it a shout out, to our professor, Professor Mille. And I think when we learned about public international law, TWIL was one of the first things that Prof taught us. And today when we're here is when we are actually realizing this is what we were being told about. And can we just give him a round of applause? And oh yes, he was voted the law ear of the teacher. The law teacher of the year. Yeah, the law teacher of the year. So
we will bring you far.
And then I think in terms of what I wanted to say as the last thing that I think AfronomicsLaw can do, if we can, as much as we have a workshop like this, speaking with students, perhaps we could also have a workshop where we are, as someone mentioned, working with civil organizations. So whether we can have a workshop like this where AfronomicsLaw is doing what do you call it? Is doing a training. So is doing a training for maybe civil society organizations, and also maybe have policymakers being engaged in this conversation. But others I'd just like to say thank you, and this was very, very, very mind-opening. Yeah, thank you.
Thank you. I think two last comments, because we have to save time. But we can take more if I'm given the leeway. Oh, you three. 4. The last one, 5. Yeah, we'll take 5 last ones. Be short, very short, okay? So we'll start here, 1, 2, 3, 4, 5. It will be very short. I'm going to regulate.
Good evening, everyone.
My name is Wambo Injonjo. I am a fourth-year student at Kenyatta University School of Law. And I would like to say thank you for the scholars we've had today. It has been both an eye-opening and a mind-opening experience for me. It has challenged my preconceptions of international law that I had. And also, it has reminded me of the complex and often inequitable nature of international law. And also, it has enabled me as a future lawyer think about how I'll critically engage with the issues that we have talked about today to make a positive change towards international law. So thank you so much for having us, and we thank you for this workshop. Yeah, thank you so much.
Thank you. Wonderful comment. Wow. Yes, yeah. I would say, like, Gen Zs. Oh, they don't say that. What do you say now? I mean, oh, this is a millennial thing. This is a millennial thing. Gen Zs are.
Good evening, everyone. So my name is Vaida Achieng. I'm a fourth-year student at the Kenyatta University School of Law. And first of all, I'd just like to thank the professors, all the scholars that are here for this opportunity. I think it's so inspiring, especially when Professor Adebol, I don't know if I'm pronouncing it well, was just speaking about intellectual property law, and she was just flowing. I feel I'm challenged and inspired. I actually did not take intellectual property law, but I'm going to take it. I used to choose units because how hard can I handle it, or how much will I score? But I'm challenged today, and the grade. So I'm challenged today, and I think I'm interested in it. And also, our professor here, I'd like to thank him so much for this opportunity. Actually, I remember presenting on the first topic on international law, and it was about contributionists and critical theorists, and I was like, okay, how is this helping me? And today I'm like, yeah, I'm seeing, yeah, I'm really, okay, it's an eye-opener for me, and I think I'm also challenged in the fact that some of us, we are like, what next after law school? Some of us are even interested in writing, but you don't even know where to start from, and today I've heard that you can even start from a blog, and I think we'll do this. Thank you so much, AfronomicsLaw.
So good evening. My name is Emily Kemunto. I just completed my fourth year from Kenyatta University. So for me, it's not a question or a comment, but but a challenge to the speakers that for us to ensure that we don't end this year, it will be nice if like you pick mentors from the group and mentor them along as years go by, so that by the next time we meet, some of them can give credit to AfronomicsLaw for mentoring them into the program. Thank you.
Yeah, just two last ones. Evans, be brief.
Definitely. He's taking the liberty. Dr. Mbori was my classmate, my brother. Thank you very much. Quick ones. Mudenyi, and choose any colleague or viewers that you wish to work with at the platform. Please do as a review of this book. Yeah, do as a review of this book so that at least I'll be able to look at this one. So we have 2 reviews of this book and of the event. We will do it for the platform for the next edition. In terms of litigation, now that my brother Dr. Mbori has been assigned the responsibility for litigation, we have at least 1 or 2 that are coming in and are related to this subject matter. Expect me to reach you, those odd hours. So me and you are going to help see that that assignment on litigation is delivered. We go back to what we used to do some years back. May I thank AfronomicsLaw. May I thank everybody. This is noble. This is great. I'm a foot soldier, Harrison. I've never changed. You can call on me. You can call on us. Humphrey, Sipala, Nyanje, everybody else. We will do what needs to be done for this to remain viable and vibrant. Thank you.
We have the last one. Keep it as brief as the others have done.
Sure, thank you. Good evening. My name is Julius Wandolo. I'm also a finalist at the University of Nairobi, Faculty of Law. My classmates are here. I have 3 concerns. I have to be very brief. The first one is I'm a writer. I've authored various legal articles. I've also faced a lot of challenges trying to diversify publication. Recently or previously, I was publishing with the Platform magazine, where my good lecturer is the chief editor as well. But I've also sent some articles to AfronomicsLaw before, but I haven't been quite successful yet, but I'll keep trying. I know there are reasons. Secondly, I also bear the crown of the Secretary General of the Law Students Association of Kenya, an association that we launched recently on 4th of August. It is a student-run association. It is not political, it is apolitical. So on the basis of how we can bring this conversation forward, I'm making my plea to you to partner with us, because with ALSAC, you'll have access to all the law students in Kenya. Now, if we can have these conversations with all the law students in Kenya, then I believe we'll be doing justice to TWAIL. In the University of Nairobi, I believe it's my colleagues here who talk about TWAIL. But the juniors, although I see our juniors here, and I'm very much glad that they're here, because after we've gone, they can continue the conversations. Yeah. And, well, Teddy is also the chairperson of the Nairobi region ALSAC. So if we were to do contacts, or if we were to reach out, then Teddy would be the best contact for the Nairobi region. Although we have emails. My third and last request for you is that we've been trying to partner or work together with the African Law Students Association. I've sent them quite a number of emails. I haven't been able to get access to them. So because you are our seniors and you got quite much the connection, this is my request that you help us, because if we are the Law Students Association of Kenya and we get ELSA on board, we might also help take TWAIL to the next level. Thank you and lovely evening.
Thank you so much. That was a very wonderful comment. I want to take the final one, very final one, from Janet, because she's also our host. And I was I heard that our law student association is apolitical. I'll tell Evans we were never apolitical. If anything, we were political. Okay. Okay.
Okay, so thank you. And thank you for allowing me to speak. I know we are out of time. So first of all, just a few things. I would like to say thank you to all of you for coming. On behalf of everyone at Strathmore Law School, I think it's only right for me to say that we are happy to have hosted you, and also that this was a very useful platform for those of us who are young in this journey of academia, and also for the students. I guess all of us are on the same boat. We're just on different parts of the journey. I also wanted to give a very special shout out to Dr. Titi, who spoke very well despite struggling with the voice. I thought that was very inspiring. And lastly, I wanted to say that as a way forward, at least for me, I was, as I was tweeting, I was just reflecting, and I think that for me, the way forward would be, first of all, to embrace the community that already exists here, of people who are always willing to help you and to give you comments, etc., and also to apply this as I teach in the courses that I teach, to apply what I have learned. So at least for me, as far as way forward, that's what I think I'll do going forward now. But I just wanted to say thank you, and I didn't want the session to end without thanking all of you for coming to the law school. So thanks.
Thank you. That's all. I think it's over to you.
Thank you so much for all the excellent comments and for the questions. You know, as I look around the room, I'm so proud of everyone, and I cannot overemphasize that. You know, the fact that you spent the whole day here, I just feel that all of you are the future of Africa, and I'm so proud of you. So congratulations to all the students here, and congratulations to all the Malimus that have supported the students. So all the teachers and all the students, I'm super proud and grateful for all of your commitment. Now we have a number of questions, and I think I'll just pick a few. One in relation to mentoring. Perhaps if you're interested in having mentors within the AfronomicsLaw network or group, perhaps you could compile the list of students that are interested, write their areas of interest, and once you have a working document, feel free to send it to any one of us, and we'll be happy to begin the process of establishing the relationship. So one thing I say about mentoring is actually many times you might actually be the ones to push that relationship. So one way, as one of your Malimus has suggested, is start reviewing articles or reviewing books or reviewing documents. There you can build a relationship with the author. You can ask them questions. I remember the first time I met Professor Gatti, I had my books and he was going to eat, and he just kept on looking. I don't know if you guys know bombastic side eye. But at a point, I guess he just changed his mind and said, okay, let me listen to the questions she has. So I think prepare yourself first, do your reading, think about the areas you're interested in, then prepare your questions and feel free to reach out. Everybody here would be interested in engaging with students that are proactive. I remember BC as well, one of the ways that perhaps we even got to build this relationship was when we had some blog posts and some resources updated on AfronomicsLaw. I'll just read it and share some grammatical corrections I had then. And first of all, I'm like, am I doing too much? Because I'll just say some things. And then I realized that he, embraced that, he appreciated it, and he would even say thank you. And I continued, and that was how we built that relationship. So we're open to building the collaborations. You don't have to start by applying to be a mentor. You could start by engaging with the work already proactively, and you'll see that organically that relationship will be built and maintained. So that's one thing I'll encourage you about. In terms of thinking around workshops, I would say that also when you're having your student review, when you're having your own programs, right, in relation to being students, feel free to reach out to all scholars, and we can collaborate. And we as well will be thinking on our own part on how to engage in more sustainable types of interactions and interventions. In relation to writing for AfronomicsLaw, the other thing is, I think that you should realize that this is a learning process. So you're going to get reviews from your work. You're going to get feedback. Don't feel bad if you get feedback to rewrite. I remember, in fact, every time I want to work on an article, I'll send to BC, I'll send to James, I'll send to other colleagues, and I would say specifically, please feel free to use your, I would not say feel free, I would say please use your red pen generously. So as much feedback as I can get, I know that it will only make my work stronger. So when you get feedback on your work, at first you might close it and sleep. And when you wake up the next morning, you start taking the feedback one by one. So if your work is rejected from AfronomicsLaw, just know that it is done with love at first. And the published work, you'll be proud of the published work. So just take that in stride and feel free to work on the corrections that you get. In terms of submitting your work to the African Journal of International Economic Law, feel free to work. And I think that you can work on collaborations. So if you work together, work with your Malimus as well. Build that, so engage in the peer review internally first and present a paper that is as strong as possible. I don't see a reason why students cannot publish if you show that you can research rigorously, you can engage in the literature, and you can present your own firm arguments. Trust me, it will be considered strongly. But do the internal peer review first. Go through that process and send it, and we'll definitely consider it. So in terms of improving the website, I know that we've had conversations around how to improve the website. So we would consider the features around the voice activation, that this is a 12 approach to environmental law. For example, you just see that you're asking questions, pertinent questions around what Professor Justice Joel said this morning. You're asking whose interest, who are the winners, who are the losers. So even though you don't say this is a 12 analysis or a 12 examination, it might be 12 in its delivery. And if you feel that you're not engaging or your teachers or your professors are not engaging as critically as you would like, ask questions. I think classrooms are for learning. So ask questions, push back, and have those interactions and conversations in class. And I'm sure that they will be happy to respond accordingly. I'll give the microphone to my...
Thanks a lot, Siti. Thank you very much. So Dr. Debola has done a lot, so I'll keep this one shorter. So forgive me for those who said this in this way, but I have to help you here. Don't say to people, I am a good writer. Writing is active. It is seen. It is done. Then it is left for others to assess. So it doesn't get you anywhere if you say you're a good writer. In fact, it makes me scared of you that you are saying you're a good writer. So you have to write, period, and let the writing speak for itself. Okay? So take those vocabularies out of it. Okay? Number 2, to supplement the mentorship part, the academic forum is there. In addition to what you've said, I can't promise that I will have the time to mentor, just because I'm being sincere. I would love to. So bless you. When we started in 2019, Nsiko, Janet, they were all around. We could start with them. But now we've all gotten busier. And the truth is, Dr. Omiunu had a system that's already in place where they've been able to connect different people to people beyond us. So this is not about us alone, even though we would like to do it, and we will do some. But it's not. There are many more people that support this work than those of us that are here. So academic forum is another important route to go through. And Dr. Omiunu is excellent with that. Number 3, how do you assess the impact of our work with government and policy? I think that's a good question. We can't say, okay, let me give. Samantha is here, right? African Sovereign Justice Network, we worked with the Zambian, NGO in relation, for example, to a particular legislation that they were drafting. We provided comments and ideas about how to push it, and that went through, for example. Yesterday night, Dr. Adebola and I were in conversation with a president of a bank. For example, this president of a bank was invoking, critical literature in conversation. So some of these things are not in the air. They are not like, as people make them seem. Right? So I think it's happening, even though we don't tend to put the metrics so much and the heavy weight on that as part of it. For the law reviews, we will support you. Tweet, tag us when you post them. I've read some of the articles. I think, is that the one that John Yanje wrote in, and brother Milage wrote in as well? Oh, that's the commercial law one. Yeah, okay. So I read some of these journals myself too. So please feel free to tag AfronomicsLaw. We'll retweet them. That's one good service. We'll share how wide it goes, right, on those ones. Yeah, let me see what else here. The student association, partnership. So this partnership one, sorry, this is pet peeve for me. It's like the writing one. Don't come to people, I'm sorry, I'll be blunt. Don't come to people and say we want to partner. It's just not the way. Look at, if you join a law firm, do you start as a partner on day one? No. There's no direct route to partnership. It's a business decision, whether you become a partner or not, at least in top law firms. So you might be the best senior associate, and the partnerships remains the farthest from you, because they don't see the route to you being a rainmaker in the law firm and working with them. So I applaud what you guys are doing. I applaud it. I encourage you to do it, but don't lose the vision that you must have. The basic work. There are a lot of associations. The reason you can't get across the African Law Student Association is because they are not coordinated. Many years ago, I tried to reach them. There's no way to reach them. So why spend time on what doesn't exist? When you reach them, can you speak Portuguese? Can you speak French? Can you speak all the languages on the continent? You're assuming everybody will speak English. So it's not as plain as you think. So just focus on what you're doing. Collaborate with people who are already doing excellent stuff. Locate yourself in there. Work with them. Just do the hard work, and then it shoots. Okay? But don't be discouraged. Just take it in context, is what I'm saying. I'll let Professor Gathi cap it up.
So thank you. So I'm going to be very brief because I think both of you have covered almost everything. And I agree with everything that you guys have said. I think the story I want to tell is, maybe this is not what your experience was when you were going through the Kenyan education system. When I was being tested for CPE, that was before, what is it called now? Yeah. Some of the questions I was being asked was, who discovered Mount Kenya? Who discovered the source of the Nile? Questions like that. That was in my, this is what, actually, if anybody can get me the papers, the CPE papers from those years, I'm old, that have those questions. I would love to see them because I've been looking for them. And the reason I'm telling this story is, and I got to reflect about this because Dr. Debola a few years ago asked me to lecture during the pandemic at their, at Aberdeen, where she teaches. And I was reflecting on many things about my experience as a, having grown up in what now is, what then was known as the White Highlands. Why were they called the White Highlands? And, I reread that essay the other day that I prepared for Dr. Debola's, to give a lecture at her school, and I thought, I should have published it because this is what motivates the kind of toil work to question why it is that we think the way we do as a really practical matter. So I'm glad to hear the students here saying, that they have problems with the way they are being taught. You may not change what the lecturers are, how the lecturers teach. You don't have to wait for them to change. Because as both my colleagues have said, you can do the work. You can, if the quality of the work speaks for itself, it will find outlets. All the journals that have been mentioned here, amazing. Amazing. When I was a student, another story, I was actually part of the University of Nairobi Law Journal editorial board. And we were scrapping for any little funding we could get with Professor Sihanya. And you guys now have access to the internet. We didn't have access to the internet. We didn't have access to the tremendous amount of information that you guys have access to at your fingertips. There may be some journals that are behind paywalls. But where is Harrison? Amanda. He tells me that there's nothing he would want that he cannot get. I don't know how he does that. But we as law students, we couldn't get access to 1%. We couldn't get access to like the kind of stuff you guys are getting access to. So from my perspective, some of us with creaking knees are really out of the way. Our job is to deliver the message and get out of your way. because this is in your hands. It's not in our hands. It's you guys. You know, so don't throw the ball back to us. We are happy to support and to nudge and to provide hopefully the inspiration and the guidance in broad contour, sometimes specifically to work with you. I mean, Afshin has left. Afshin was reminding me yesterday that her chapter in this book on transforming climate finance, she went through 6 versions. 6 versions of her chapter. Samantha, how many did you go through? About 4 versions. Publishing, as Humphrey Sipala will tell you, and my 2 colleagues here, is a lot of work. It's a lot of labor. We do it because we love the job. We do it because we believe that it's important to challenge the epistemic violence of Eurocentricity that it still lingers. I still remember being asked who discovered Mount Kenya. When I did my high school exam, no, when I did my A-levels exam, I did A-level history. There was a very big fight among Kenyan historians between the Eurocentricists and the people who believe that they had to change the way we tell African history. I want to investigate. I actually want to investigate because William Ochieng, the historian, wrote about this in The Nation. I'm still looking for that article. It affected how I performed because I was more on the decolonial side of things and not on the Eurocentricists that controlled the way African and Kenyan history was told. This Felix Jenga, here, you will take this hard copy because this is what this work is doing, centering the voices of Africans and the people from the global south, like Dr. Felix Jenga. We've been talking about this with Florence, with Dr. Milesh, about doing exactly this kind of a project in the Kenyan context of unearthing these African scholars that have been forgotten. So I'm so glad to hear that you are already doing that work, you know, and not repeating the mistakes of my time, you know, when I was being asked who discovered the source of the Nile. Or should that be the history that is taught? You guys look like, or maybe you're tired. Should that be the history we are learning? So when you hear some of us say we reject, or yesterday Godwin, I think he said resist. What are those 3 terms? I want you to say them.
To advocate, to organize, and then resist. Because if you don't advocate, you can't get masses to organize. And if you have masses, resistance is easier or more plausible.
Yeah. And I'm pointing to him and to Samantha because you might think that the kind of conceptual work has no practical implications. The fact that the work we do does not have practical implications is a function, as my colleague said, in the many conversations, especially the one on international economic investment law and also international intellectual property law, is a function of who controls those systems among African elites. I think it was, I don't remember who it was today now, I think it was Judge Ngugi who said that the Europeans that think like the Europeans, and then they are the, how did he frame it? Yes, and the Africans who think like the Europeans. So I will say this for the record. Our states, and many people have said this, not just me, our states are controlled by Africans who think like the Europeans, who are more European than the Europeans. That's the problem. So when somebody says, why doesn't this have practical import? Where's Harrison? This would excite Harrison. I'm very bothered. So we have had many conversations like this with Harrison. That's the problem. So last point, and then I will say a few thanks. So we have been unearthing for many years with Harrison the making of Kenyan company law. This book will be published by Sharia Publishing House. It's actually ready. but we really want it to be high quality. We have been judging ourselves very harshly. And one of the major insights in our book, it's not just about the doctrine, is that in Kenya we have two competing elites who have been involved in the making of Kenyan company law. They are the Africans who think like the Europeans, and they are more European than the Europeans, who are the architects of the 20... what year was that act again? Of the Companies Act? 2015 Companies Act. It borrows lock, stock, and barrel from the 2006 English Act. It's not Harrison. And in fact, some places they forgot to delete some provisions which were entirely inconsistent with the entire premise of the new act. Like they left some provisions relating to liquidation, although they are completely transforming that into an insolvency regime. They rejected an initiative that had been for several years in the making, led by Professor Arthur Eshiwani, that wanted a domesticated kind of corporate law informed by our experience and practice. Now, so this is an example of how you might, as Judge Ngugi was saying in the morning, unearth whose interests are represented in some of these rules and why are they enacted. And it takes a lot of hard work. So it's not just about the fact that it's going to be accepted or rejected by a journal. It's about what is the contribution to the status of what we know at the moment. So much work remains to be done. We talk with Humphrey all the time about at least the Kenyan and the African context. So much work, I mean, from torts to contracts to jurisprudence. There were very interesting discussions this morning. But then we are not the only people who are coming up with these ideas for the first time. There's another generation. You know, we heard about the critical and the contributions. I don't know about those people. There's work by the Dar es Salaam school that Chico talks about. He keeps reminding me about the African historians, the UNESCO. Yes, they rewrote the history of Africa. There are many precedents that we can borrow from and be inspired by. So in short, the work is cut out for us. We are ready and happy to do all the things that my colleague said. I want to end by first thanking again our team that has been streaming the event the entire day. We haven't thanked them. Please let's thank them. I'd like to thank also all the collaborators who, when we called them, from Humphrey Sipala to the team, all the team that was here this morning, all the lecturers from all the schools, they said yes. Dr. Musembi, one of the founding members of TWAIL. I'd like to thank you, the students, and especially the TWAILvocates, the University of Nairobi TWAIL students who were amazing to work with, led by Mr. Miracle there, Mudei. It was very easy to work. He was very responsive. We wanted to do this in a public university. We just didn't have enough time to make things happen as fast as we would have. When I reached out to Milesh, I call him Milesh, my very good friend. He was on holiday in Poland without much access to the internet, so it could very well have been at KU. But I was moving very fast because I wanted what hopefully you think has been a successful day in terms of logistics. Alan Mukuki from Strathmore was amazing. When I called and reached out to him, he promised me that we would get a room. It was not easy to get a room here at Strathmore, but he figured out something. And then he introduced us to Elvira, who has been amazing. She has created this link. Scan it, and if you're interested in being added to the list, add your name to the list. All the documents that we have mentioned today, we shall make sure you get a copy, including the 12 bibliography. And actually, that is climate consistent instead of printing too much stuff. We have a few copies of the first book, bless you, Reforming the International Debt Architecture. And then we still have copies of the book that we launched yesterday, so feel free to help yourself to more copies if you'd like. We are super delighted that you all decided to spend this very, very, very long day with us. And since Dr. Debola, who has a flight to catch in not before too long, we have to end so that she doesn't miss her flight. So Asante Sana, we hope this is not the last conversation, and we hope this Kionjo has sparked the interest that will continue this conversation among yourselves in particular. And we are happy to continue if and where we can to be very supportive of all those efforts. So Asante Sana.
Oh, that's not one.